Yes, please, from that side. Appeal right now we are not adding. We let us dispose of some. Yes.
Application for it.
Application, please. Application order 41 matters, please hand over. Application order 41 matters without mentioning, please hand over.
One item number 45.
Rest of the matters we will take up. First, let the order 41 matters and applications come. We cannot repeat every time. Yes. Yes, ma'am, you are doing your. What is this?
Lordship.
You'll be getting crushed otherwise. Yes, quick.
Your Lordship, this matter has came up before the
What's the
honorable
matter? It is to appear under
FAT number 388 of 2019.
it's a hearing matter.
It is an appeal matter. For the preparation of paper books, the department was directed to bring the lower court records. But still now it has not been...
It will appear as to be mentioned. Please put the caption to be mentioned in a slip and hand over.
okay.
I have similar prior matter.
Yes, yes.
I have
those-
similar
those-
prior.
yes. Appeal hearing we are not taking up. Other matters, please hand over. Yes. If it's a hearing matter, no.
For to be made, LCR has been called, only the short paper book has been made. Only the difficulty is that the caveators wakalatnama has not been tagged with the main appeal.
We'll pass that order. Put it as to be mentioned. Yes.
Mentions with regard to the order 41.
Order 41 application, please hand over.
Some extent urgency with regard to this exhibition.
Anything else?
December.
Hand over. Yes.
Well, there is a direction for filing of a requisite number of paper big mandatory direction within a week. But in spite of that,
To
appellant
be mentioned. Yes.
Kindly of your Lordship. Matrimonial appeal. The record is not found. And
You have to approach the register for that, not this.
I have approached, even on the last week, my lord, I have made the OSD, my lord. I was
See, follow up with the registrar. Court can't do anything else. What can the court do?
let the matter appear as to be made.
No, 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 no.
I have.
And
Please follow up with the registrar. Otherwise, write to the Chief Justice.
There is a.
No, we can't do anything else. Yes.
my lord, item number 45. It's an order 41 of 2024, my lord. The determination is with my lord Justice Harish Tandon. My lord.
45.
Yes, my lord. To FMAT 204 of 2024, my lord. My lord, kindly pass necessary direction.
If you can't call it today, it will appear as to be mentioned tomorrow.
My
The other side has to.
my lord, for release. Order 41, a new fresh matter.
You don't understand what you are saying.
My lord-
We'll release it.
Yes.
But if it is called on today, otherwise it will appear as to be mentioned so that we can.
My lord, may I be permitted to mention one matter, my lord? This matter, my lord, I mentioned before your Lordship on 21st November.
We are
and
not
your lordship-
interested.
and
What is the
Your
matter?
Lordship had directed the matter would be taken up under that to be mentioned. The only problem was that at that time, the file was not in the court. But now the file is in the court.
It will appear as to be mentioned handover.
Lordship for release.
2002 matrimonial appeal informal paper books have been prepared.
Not now. Yes.
My lord, may I be permitted to mention two matters. The first is for release because Mrs. Shohini Chakraborty is
Handover.
appearing. And the second one, my lord, substitution was allowed. The time given to amend the cost title was until 28th of November, which has
For
expired.
extension of that time.
For extension
To
of
be
the time.
mentioned.
I've written, my lord. I'm deeply obliged. First appeal.
Hearing no. Hearing no. Not right now.
My lord, for inclusion for admission, my lord. Order 41.
Order for 20.
Lordship, may I? Lordship, stay application, order,
Application yes.
Lordship for hearing appeal along with the stay, that order 7 rule
Not
11.
right now. Not right
Lordship,
now.
on 9th December, it has been already fixed for hearing stay. I have served. That order
Why are you
7 rule,
mentioning?
order 7 rule 11 rejected first appeal. The main crux of the matter is
Why are you mentioning?
mentioning for taking the stay application along with the appeal. The informal paper book has been prepared, served.
Appeal has been directed to appear on 9th.
No, only stay application. But the thing is, order 7 rule 11 rejection, that matter,
No,
Lordship.
appeal hearing we won't add right now. Whenever the stay application comes up, remind
And
us, we'll
Lordship,
put that.
Another matter, appeal hearing.
No,
Test deeply.
no, not right now. Let us dispose of some then. Again, we'll take. Yes, call.
Monthly process, item number 1.
I appear on behalf of the appellant.
Why is it appearing as to be mentioned?
My lord, on the last occasion, the learned friend appearing on behalf of
Use the mic, sir.
learned friend, my lord, appearing on behalf of the respondent has submitted, my lord. It's a matrimonial appeal. The wife has become a monk, my lord.
Wife has become,
Monk. Brahma
he
Kumar.
has relinquished the world.
Kindly see your lordship's last order.
Thought affidavit, where is that?
My lord, they were to file the affidavit. I am the husband appellant. My suit for divorce, my lord, has been dismissed. My lord, suit on the ground of, my lord, cruelty and desertion.
We'll pass over, contact Mr. Ghosh, Prantik Ghosh, and if you see whether you can do it. Pass over, pass over.
Because it was the
Whenever they come,
specific.
whenever they come, we'll
That's why Lordship said the lawyers what will not.
For Mr. Ghosh, we have just passed it over. It will be in the list. Yes.
Item number 2, my lord, I beg to appear on.
Was it appearing as to be mentioned, sir?
This is at the instance of the respondent for probably not filing the paper books. It is already under process, my lord. I'm praying for 10 days time to file the paper books.
You are for the appellant.
Appellant.
You are directed to file paper book.
Yes,
my lord.
initially there was a direction, the paper books have
Then
arrived.
we will direct you. You will extend the time for filing a paper books for 10 days as he's praying. That will be a last chance. It will appear as to be mentioned if he does not file or final lodging orders.
Grateful, your lordship.
The appellant was to prepare paper books. Full stop. However, comma, learned counsel for the appellant submits that due to certain unforeseen circumstances, the paper book could not be prepared. Full stop. As a last chance to the appellant to prepare and file the paper books as per previous direction, comma, the time for filing the same is extended till December 12, 2024. Full stop. In the event the paper books are not filed, comma, the matter shall be placed in the list under the heading to be mentioned on December 16, 2024. Full stop. In the event the paper books are prepared and the appeal is otherwise ready for hearing, comma, liberty to the parties to mention as and when so ready for inclusion in the list for the purpose of hearing.
I'm grateful, your lordship.
Next.
But I'm for the
Yes, Mr. Ghosh, what is the matter? Why?
due to wrong file put up before your lordship. The direction has been passed.
Oh,
to,
that. But unless Justice Kumar is there, all right, we are not recalling the order, we are putting in something. This matter, wrong file. Manage it in a different way. We'll see that. The other directions remain, we'll just say that the defects are not. By an order dated November 26, 2024, comma, it was observed that there was no hindrance in the appellant proceeding with the present appeal, subject to making good the deficit court fees in terms of the report of the registrar administration within bracket L and OM bracket closed. Full stop. The file was sent down for such limited purpose. Full stop. The application was directed to be listed on December 9, 2024. Full stop. As rightly pointed out by learned counsel for the appellant, comma, it transpires that there is no such deficit court fees as of today. Full stop. Accordingly, comma, let the application be listed as per previous direction on December 9, 2024.
much of it.
Milord, with regard to item number 1, Milord, Mr. Ghosh is here.
Mr. Ghosh is here. So one type of password matter to call.
Lord, I am for the
Where is that affidavit?
Lord, I am the wife respondent. Lord, the wife is residing at Karnataka. I have prepared the affidavit and sent it for his signature. And
Give us a date.
Lord, I pray for only 1 week time.
Give a firm date. Today we are on 2nd. We'll put it on 10th. We'll give you one more day. Very well, 10th. But 10th you have to be prepared with that
Yes,
affidavit.
yes, I prepared and I sent it.
No,
to
no.
my client.
You have to be prepared means for filing input. Learned counsel for the respondent seeks. Learned counsel for the respondent seeks a week apostrophe time for filing the affidavit as per the direction dated November 12, 2024, in view of the respondent wife living in Karnataka. Full stop. Next para. Such prayer is granted. Full stop. The time for filing such affidavit by the respondent is extended till December 10, 2024, when the matter shall next be listed under the heading to be mentioned.
Milord, only one thing.
Give an advance copy to them.
Yes, Milord, only one thing. My learned friend will file the affidavit, but I have just checked up the record. The department has given a note that respondents have not filed Vakalatnama.
Vakalatnama has given.
Ask your client to bring another Vakalatnama also. So these things are cured.
Grateful.
Number 4 and 5. 4 and 5, Mr. Chakraborty is appearing for the appellant.
bracket Bhattacharya J, bracket closed, appearing in the matter, comma, for the sake of propriety, comma, let the matter stand released from our list with liberty to the parties to take steps for assignment before a different coordinate bench.
Lodge.
File type.
6, my lord, in this matter, my lord, I am appealing for the appellant petition. This is an application filed
Respondent.
for substitution.
Yes.
Allegation the matter was
Beyond time.
beyond time because from the order dated last order, your lordship find the argument was advanced mostly at the flag end of that argument. It appears well that one of the party dies.
Ah.
If your lordship can consider the order dated 5th November 2024.
Yes, yes, it was substantially heard, then it was Mr. Chatterjee.
Yes. So that's why, my lord, an application has been filed for substitution of the.
That is Can 3.
Yes, Can 3.
Recording date means the other heirs are already
No.
on record.
No, Can 3.
What is the Can? Right, Mr. Rai?
কোনটা কোথায় গেল?
Respondent number 2 died.
Respondent number.
Do you have instruction to appear for her heirs also?
I don't have instructions from her, but from her, yes, yeah, but I haven't filed any vakalatnama.
Could not, because they were not parties.
My lord.
So we'll direct the implement, will allow this application. And what is the reason for the delay, Mr. Rai? Lack of knowledge?
Lack of knowledge. My lord, on the very date, my lord, already Road 10 capital A has been practically, I take that advantage.
The last occasion, the information was provided from our end that.
Yes, yes, that is precisely his ground.
Yes, yes.
That is the ground order.
Suspicious circumstances also, my lord, his own sister. They don't have any
Not
knowledge.
knowing the whereabouts of sister may not be a suspicious circumstance to that extent.
That is my only objection.
If you knew, that could be a suspicious circumstance. Every whereabout of his sister. The present application bearing Can 4 of 2024 has been filed for substitution of the heirs and legal representatives of the original respondent number 2, Uma Bishwas, after setting aside abatement on condonation of delay. First up, learned counsel for the petitioner submits that the petitioner learned about the demise of respondent number 2 only on November 5, 2024, comma, for which there has been a delay of about 240 days in taking out the present application. First up, upon carefully considering the averments made in the application, comma, we are satisfied that sufficient cause has been made out by the petitioner for belated filing of the present application. First up, accordingly, Can 4 of 2024 is allowed, comma, thereby setting aside, thereby directing substitution of the heirs and legal representatives of the original respondent number 2, Uma Bishwas, upon setting aside abatement on condonation of delay in filing the present application. First up, the heirs of the said respondent number 2, as named in paragraph number 5 of the present application, be accordingly substituted in the appeal. First up, next para, there will be no orders to cost. First up, paper books have already been prepared. We'll direct your advocate on record to carry out the necessary corrections.
Yes.
The learned advocate on record for the petitioner shall carry out the necessary consequential amendments to the cause title of the memorandum of appeal as well as the paper book by tomorrow. First up, the matter, the appeal shall be listed for hearing on December 5, 2024.
Get full time. হ্যাঁ ইয়ে করে এসে ইয়ে হয়ে গেলে ইভিন আওয়ার্সে এসে এসে কথা বলতে
My lord, item number same. I am praying for a short passover. My lord,
Diffused. What is the matter?
My lord,
Number 1.
Yes. What is the matter about?
An application at the instance of the appellants.
Condonation of delay.
No, that has been allowed on the last occasion.
What is this application?
My lord, your lordship kindly takes a look into the order of 15/1/2019, the first order.
This application has never been moved. No endeavor has been made from the side of the appellants, my lord.
What is the nature of the application?
Well, this is an injunction application, it was actually they paid for stay, but it was considered as injunction, and the court granted a status quo
Status
for,
quo was
for, a,
still?
for a period of 12 weeks. Now they did not choose for extension of that. Neither they, my lord, went for hearing of their application, or it has become redundant now. All I was beseeching your lordship, my lord, kindly fix a date, my lord. There was a specific direction, my lord, on them also to prepare the paper books.
Have you prepared the paper books?
Nothing has been
He will be embarrassed. He's not in the know.
Yes, sir.
We'll put it tomorrow. If they don't proceed with the application
Can
tomorrow,
there be a passover today on this matter? Because
passover is risky. I mean, whenever we don't know, very well we can pass it over. But yes, when will he come? Your
My lord, he's stuck in jam in Howrah. My lord, he will come within an hour, half an hour.
Howrah where?
My lord, he told he is in Salkia.
Salkia. We are passing it over. You keep someone. Whenever they come, if they don't remind, you remind.
yes,
Let
We'll
him
pass over. Next.
My lord, Mr. Shoptangshu Vasulonet, senior counsel, is appearing. Lordship, he is engaged in courtroom number
Yes, you start
26.
the
My
matter.
lord,
Yes.
My lord, there are two appeals.
Yes.
one is
One
my
filed by
appeal.
my lord, the referring claimant, and my lord, the state. My lord, we have also filed an application under Order 41, Rule 27. They have also.
We have also filed an
And may I
application.
file the my lord, affidavit in reply today?
Regarding the order 41 rule 27, Mr. Bandyopadhyay, regarding the order 41,
41 Rule 27.
but they have to file
Stand
the opposition first. Let them
I
file the
don't know, my lord,
opposition.
whether it has been filed or not. I have ready with the my lord, the
You are the advocate on record.
Yes, Lordship.
Then you should know whether it has been filed. Your opposition. Where is your brief, sir, ma'am?
My lord, I'm also led by Mr. An Banerjee.
You should have a brief. The junior does not have a brief. You are the advocate on record.
It is with Mr. Banerjee.
We'll dismiss the application.
My lord,
No.
Lordship.
If you dismiss the application, next time we'll have a brief. We'll ensure that. The learned junior has to have a brief in every matter. If Mr. Basu can be engaged, you can be provided with a brief. That much expenses the client has to bear.
She passes it over for some.
No, not every matter can be passed over. Why should it be passed over? It's very unfortunate that you don't have a brief. Tell Mr. Basu this, or whoever is there leading you, Mr. Banerjee. We are making it not today, Mr. Banerjee, let them come. Because we have to ascertain whether this...
Today, not today only.
Only not today.
I see.
Please keep it with you. We are not sure whether the opposition is there. We are not being helped very
I have
well
also submitted
from
copy
any
of
side.
it was by copy of the.
Do that, yes. But no, serve it properly, get a receipt so that we'll take it formally on record. An adjournment is sought on behalf of the for the respondent.
Lordship, I'm for the respondent in item number 8 and appellant for item number 9.
Two appeals, my lord, and effective.
An adjournment is sought
6 million for the state.
on behalf of Mr. Shoptangshu Basu, learned senior advocate appearing for one of the parties, full stop. Let the matter stand over for the day, full stop. It is made clear, however, that in the event any further adjournment is prayed for on behalf of the same party, the matter will be dealt with in the absence of the state party. Next.
Thank you. Thank you.
Yes, Mr. Kormakar, what is the matter?
We are appealing for the respondents.
Right. Please take your seat. We'll just hear him.
We have taken out an application. Justice Kant Lord had heard out this matter on the previous occasion.
What was the opinion of Justice Kant? To dismiss or?
The issue is with respect to this honorable court had appointed an administrator for running and operating Jewish girls' school situated in Park Street. Initially 6 institutions were clubbed in one suit. By virtue of an order, the 5 institutions having their separate cause of action were driven out of the suit, and only liberty was granted to proceed on the basis of the cause of action surviving on Jewish girls' school.
It was a declaratory suit.
It was a declaratory suit in the course of management of that school for constitution of a managing committee.
You were the plaintiff?
I was the plaintiff. I am for the plaintiff and appellant against refusal of an order of injunction. I had approached this honorable court. This honorable court, for the best interest of the institution, had appointed an administrator and also directed for elections to be held so that the managing committee can be constituted. Against that, Lord, my learned senior friend's client went up to Supreme Court. The Honorable Supreme Court retained the order, Lord, of appointment of the administrator with respect to continuation, but Lord, deleted the portion whereby Lord, the election was to be conducted. Now, Lord, the suit is going on, and thereafter relegated matter back to the Lord, the trial court, indicating that whatever the issues are there has to be decided by the trial court, keeping this appeal pending. This appeal was not disposed of. Lord, now I come up before, we are proceeding with the Lord trial. Lord, whatever applications are there that has to be decided is decided. Here, Lord, I am today before your Lordship, Lord, with an application whereby I want the name of the administrator to be changed. Mr. Probal Mukherjee, Lord, senior advocate, was appointed as the administrator. Lord, due to his preoccupation, Lord, and other engagements, Lord,
Both of you agree on a name?
it is, Lord, he is not agreeing. He is not agreeing. He is taking a point that either I have to go to the trial court to get this name change, or Lord, I have to travel to Supreme Court to get this name change. Lord,
Who was the parent order, Mr. Kormakar? Who was the parent order? This application is numbered?
Lord, this application number 9, CAN 9.
যেটা application শুনবো সেটা বার করে।
Incidentally, Lord, this main order was also passed in this court.
16.
Justice Banerjee was there. Kindly, Lord, comes to. I'm sorry.
Can 9 টা খুঁজে দেবো নাকি? We'll find out.
আমি আছি, তুই আছিস, গার্গী আছে, গার্গী আছে। ক্যান 9টা একটু জজ সাহেবকে দেবো।
So that was the order dated
Lord,
4th of September.
Lord, 4th of September, it's a lengthy order.
Yes.
Lord, kindly straight away comes to page 19. 19. It is deemed necessary, fit and proper that I'm sorry.
Yes.
It is deemed necessary, fit and proper that an administrator be immediately appointed over and in respect of judicial.
9টা দাও। Can 9. কি দিচ্ছ? ওনাকে can 9টা দাও।
হ্যাঁ। We have got.
No, we have. Thank you very much. Thank you.
But I was asking him, I had served at least 20 copies to his clients. He has not been given one also. He has obtained a certified copy.
Poor him.
Lord,
Page 14 is the order of this is vanity, and page 19 is the relevant portion. The yes.
Supreme Court final order to back. Lord, it is deemed
Has he
as-
communicated? Has Mr. Mukherjee communicated anything to you?
Lord, on the last occasion also he was there.
He
Even
was
he
there.
also once released.
No, that we can appreciate. Obviously, why should you tell a lie? I mean, but
Lord,
Mr. Mukherjee
he
was
was
there on the last
Yes,
occasion.
yes. Mr. Mukherjee had
And
argued.
Mr. Karmakar, let us do this. Let us hear their objection first so that you can answer that.
Very.
Because it's only, they must be saying that this has merged in something in the
Yes,
Supreme
yes.
Court
Lord,
order.
they say that it's gone with Supreme Court order.
Achha, is the
Now-
Supreme Court order here?
Lord,
Annexed?
the Supreme Court order part is here. The main, I'll show one aspect of the Supreme Court order first. Lord.
Part is here means the
Lord,
irrelevant part.
No, no. Order tala hoy.
You have got a copy of that also, yes.
Yes, Lord. Lord, kindly comes to page 26.
Very good, 26.
Lord, this
This
was
is
the-
actually the relevant part.
Yes.
Where is the relevant part?
Lord, the relevant part is Lord. Page is-
So that is in our affidavit in opposition.
Yes.
Your opposition. all
That
right.
is part of the affidavit in opposition.
Yes,
This
Lord,
is
kindly
the
comes
first
to
document.
page 66 of their affidavit in opposition.
Right.
It is
6 July. 6 July. Okay.
Opposition of
part
respondent
one,
numbers
volume 1.
5 to 5, 6, 7, is etc.
Yes, yes.
Volume 1, pages 1 to 150, yes.
Lord, page 66.
66 is the middle of that order.
Lord, 66 is annexure P5, Lord.
No, it is something else. It's an application for clarification.
Opposition. Volume
This is
1.
opposition,
This is can 10, your lordship, which we have filed subsequently. What your lordship
Oh, it
has
can
made.
but it's written at the top can 9. Can 9 opposition.
Lord, kindly have a look.
Not
at
even a
this.
comedy of errors, it's a tragedy of errors.
Lord, kindly have a.
And 10, your lordship, we have filed subsequently. We have given that order.
Canteen to just fill.
Because the affidavit in opposition is huge in volume.
Right.
Canteen list.
Friends, I mean, what is your objection to this?
So lordship has seen the main part of the Supreme Court order.
Yes, yes, affirmed.
But that it had been remanded back to the learned trial court with the difficulty that any and every objection of any nature has to be handled by the learned trial court. Now, my first objection to the point is that whatever they have taken out the application after the Supreme Court's order, lordship finds that the last paragraph of the order
Yes,
dated
any
6th of
further-
July, any
further-
further
Yes.
grievance of either party with regard to the administrator or otherwise will therefore naturally has to be raised before the trial court.
Right.
Now, my lord, one submission which I was making before the earlier bench, my lord, was that this basically implicates that this particular appeal has become infructuous by its very nature, because main part of the order that the appellate court had given was taken away. And then this what remained, that whole thing was remanded back to the learned trial court to decide upon merits, including any grievances which is against the administrator or otherwise. So that basically takes out the whole gamut of the issues. Your lordship, what remains to be decided by the learned trial court. Now, what my submission, my lord, we have taken those points in the affidavit in opposition also, is that what their application is deficit about are there are multiple applications pending before the learned trial court in regard to the administrator under order 40, which we have made part of the affidavit in opposition, your lordship. I don't want to take your lordship to the merits of those applications. That is to be decided by the learned trial court, my humble submission. And there are multiple applications pending regarding the compliance of the directions issued by the administrator, which are being violated by the plaintiff. That is my humble submission. Now, in the meantime, my lord,
The appeal has virtually been disposed of by this. The trial court
That
has
I
been
agree, my lord.
will give you liberty to take this same point before the
At
trial.
the same time, Lord, only for this, Lord, I was not alleging.
Let us not waste time on this.
Given 2 minutes. My lord.
Yes, very well. We'll complete the 2 minutes and then we'll come back to you.
My lord, what happened in the meantime is there was an application under section 151 which was being heard exactly on this point, that certain directions issued by the administrator regarding the appointment of a new principal, because the earlier principal's contract had run out 2 years back, and it was new principal was not being appointed for whatever reasons, because tug of war between the parties, I may say. Now, that application was being heard out by the learned trial court. A preliminary point was taken by them as to the maintainability of that particular application under section 151 of the CPC during the pendency of a Order 7 Rule 11, which has been filed in 2019 and which has already been heard out twice, but unfortunately the presiding officers got transferred twice just before giving the orders, and therefore it was still being heard. Now, because of certain developments, a section 340 proceedings also started, and that is pending before the learned trial court. So they took out a civil revisional application, which is presently pending before the civil revisional court, where they challenged that hearing of that section 151 for only compliance of the administrator's directions, or the non-compliance of the administrator's directions by the plaintiff, on the ground that no interim applications, whatever so, can be heard out by the learned trial court when the maintainability of the suit itself is pending before the learned trial court. Now, in that, your lordship, we have taken certain points before the learned revisional court that, if your lordships just give me a minute, I will. The basic issue is the whole jurisdiction of the administrator is pendenti light. Now, your lordship, when the suit is pending, if something happening with the pendenti light assets and whatever it is, if somebody comes and makes a proposition that, okay, because the maintainability of the suit is pending, the administrator's orders will not be complied with, or nothing can be heard about that matter, to us, my lord, that appears to be a bit of a misnomer in concept. That's all I can say, my lord. Now, in this condition, my lord, they obtained a blanket stay on the suit by an order dated 27th of August 2000 in the civil revisional court. We went up in a racketing application which is pending, which is fixed to be heard during the month of January. This is the present situation. Now, if your lordship sees their application, the primary issue is they have not even informed the court that all these issues regarding the administrator are presently sub judice before the learned trial court. Now, your lordship, kindly, from your lordship satisfaction, kindly envisage the situation. We have exercised certain rights under the directions of the Honorable Supreme Court to vent our grievances before the learned trial court as per the order of the learned Supreme Court. Now, today, your lordship, the same administrator against whom order 40 multiple issues are pending, 1D, 3D, your lordship knows the provisions. In such situation, the administrator, one point is the administrator is not asking for a discharge by himself. Now, your lordship will find in the 4th of September's order, my lord, which is before your lordships, before the earlier bench, a liberty was given to the administrator himself to come up in and prefer appropriate application if he needs so. So the first objection that I have is that they don't have a locus as on date to prefer this application. The administrator can come and seek discharge or whatever it is before the appropriate forum. That liberty has been given.
Are there any allegations against the administrator himself?
Yes,
there are.
In my application, no.
No, obviously not in your application. But you have certain allegations against that.
Yes. Yes, your lordship.
Mr. Karmakar, this we cannot brush this aside. I mean, whoever he is, it has to be taken before the trial court as per the Supreme Court's observation. We will say that the appeal has virtually been disposed of, we'll actually dispose of the appeal, and we'll relegate you to the trial court to take out all applications. And their applications.
I was not
before changing him. No,
Mr.
Karmakar, before changing the administrator, the allegations against him and your non-compliance of his orders, those have to be gone into.
Allegations are only with respect to Milord. He is not working in a particular manner. That's the only allegation.
That has to be resolved first before releasing him, Mr. Karmakar.
Very well. I understand.
Even if it was, I mean, whoever it was.
But then in that case, kindly dispose
the person cannot come in the way of that. Yes.
We'll
dispose of the appeal itself, give you liberty to take these points before the court.
Wait.
And we are not going into the merits that they usually do.
And Lord, kindly also records that
just to bring the situation.
No, you are right. You are right. You are right.
So the merits have to be decided.
All merits have to be decided that the Supreme Court.
Yes, kindly also records that we have not used the reply, Milord, to their opposition, and also no opposition to contain. Milord, so kindly protects us to that aspect regarding we are not using that.
Very we'll dispose of that. The limited scope of the present application is alteration of the administrator who was appointed by a coordinate bench with a order dated September 4, 2019. Full stop. A challenge was preferred against the said order before the Honorable Supreme Court. Full stop. The Honorable Supreme Court, by an order dated, what is the date of this?
July 2021.
July 6, 2021.
Further modified by an order dated 20th September 2021. There was a
comma
clerical error.
As subsequently modified on September 20, 2021, comma, had inter alia disposed of the challenge by confirming the interim order dated November 4, 2019, appointing the administrator. However, comma, the trial court was directed by the Honorable Supreme Court to decide the suit expeditiously, comma, preferably within a period of 6 to 10 months, comma, if not earlier. Full stop. It was recorded by the Honorable Supreme Court that counsel for the parties had assured that they would render full cooperation for the early disposal of the suit. Full stop. Any further grievance of either party with regard to the administrator or otherwise was therefore, comma, naturally, comma, to be raised before the trial court, and which would alone be competent to pass appropriate orders with regard to the same. Full stop. Next para. Learned counsel for the petitioner submits that since the prayer in the present application is innocuous, comma, as the administrator has certain personal difficulties due to his engagements in continuing in such post, comma, the same can be disposed of in this court, comma, particularly since the parent appeal is still pending. For sub next para, learned counsel for the respondents opposes such prayer and submits that in the light of the order of the Supreme Court, comma, all grievances have to be raised before the trial court. Full stop. Next para, in fact, comma, certain applications, comma, allegations and counter allegations are at present sub judice before the trial court, comma, inter alia pertaining to the functioning of the administrator, comma, alleged non-compliance of orders of the administrator by the plaintiff stroke appellants, as well as on other issues. Full stop. In fact, comma, challenging the applications in that regard being taken up before hearing of an Order 7 Rule 11, comma, CPC application, which has also been taken out, comma, the plaintiff stroke appellants have preferred a revisional application which is now pending before this court. Full stop. In connection with the revision, comma, a stay order was passed, comma, an application for vacating of which is also pending before this court. Full stop. It is thus submitted that this court ought not to pass any order, but it is the trial court which now has jurisdiction to decide all issues. For sub next para, upon a careful consideration of the arguments of the parties and the materials on record, comma, we are of the opinion that the Supreme Court, comma, by its order dated July 6, 2021, as subsequently modified on September 20, 2021, comma, made it amply clear that nothing remained to be adjudicated in the present appeal. Full stop. By directing the trial court to decide the suit itself expeditiously within the time frame as given therein, and making it clear that any further grievance of either party with regard to the administrator or otherwise would have to be raised before the trial court, comma, there is no occasion left for this court to interfere on the matter. Full stop. Next para. Moreover, comma, since certain allegations have been raised by the respondents herein before the trial court as regards the functioning of the administrator as well as non-compliance of certain orders of the administrator, comma, it would only be prudent, comma, in the context of the order dated July 6, 2021, passed by the Honorable Supreme Court, comma, to relegate such issues, comma, including the change of the administrator, comma, to the trial court. For sub next para, since we have not invited affidavits to be exchanged on all the pending applications in connection with the present appeal and are not deciding the merits of any of the issues involved before the trial court, comma, it is deemed that none of the allegations made by the parties in connection with the present appeal as well as the connected applications are admitted by their other sides. Full stop. Next para. In the light of the above observations, comma, FMAT, it's FMA now. FMA 1058. FMA 1058 of 2019, along with all connected applications, stand disposed of with liberty to both sides to take all issues raised herein and in the applications made in connection with the present appeal, comma, including Can 9 this is can 10,
And 10 is from us, your lordship.
including can 10 of 2024 and can 9 of 2024, comma, before the trial court in the light of the observations of the Supreme Court. Full stop, no address to cost.
Great.
Long. Thank you.
Lord, Lord, I am appearing for the appellant, my lord.
Yes.
My lord, there was an interim order for a limited period. Now, my lord, that was expired. Subsequently, my lord, it was dismissed for default.
We are
Thereafter, my
hearing
lord,
which
restored.
can 4472.
4472 of 20.
That has become can 1 of 2024.
Yes, subsequently, it has been renumbered as 1 as 2018.
Now, my lord,
20? 1 of
4472 of 2018 was subsequently renumbered as can 1 of 2018.
2018. Yes.
now, my lord,
It's the injunction
there was already a direction.
When did it
for-
expire last? The injunction granted?
2019.
My lord, 15th November 2019, my lord, interim order was passed, my lord. My lord, and my lord, that was no, my lord, for a limited
What is the
period.
impugned degree? Probate was granted or refused?
Granted in my favor.
Probate was granted, my lord. I have, my lord, challenged, my lord.
Challenge that. That
Yes,
appeal
my
is pending. You got injunction restraining them from doing what?
My lord, no, my lord, not to effect or further effect the, my lord, grant of probate, my lord.
Let us see.
Not
What
to
is the
change
date
the
of the
nature
order?
and character of the property.
No, my lord, there was
Granted, my
already a
What is the date
direction.
of that order? Do you have the
15
date?
1 2019.
15th
of January 2019.
My lord, there was already a direction for filing paper book, my lord, on that date. Now, my lord, that was also expired, my lord.
So that was
Now-
the first order.
15 November 2019, my lord. My lord, I am praying, my lord, for enforcement of the order, my lord, let, my lord, direction may be given, my lord, for filing paper book, and my lord, to fix a date
The
for
records are
hearing
before
of the appeal. And
records are before this court.
Yes, there is an order of 12th of May 2023, my lord, in connection with this matter. 12th of May 23. Well, my lord, there was a specific direction to send back the lower court records, and as far as I have looked into the records, my lord, the LCR has come, and the defects have been cured.
The appeal is otherwise ready for hearing.
Otherwise,
my lord, I am praying, my lord, subsequently allow me, my lord, to file paper book, my lord, within a month, my lord, informal paper book, my lord, as my lord, order was passed on, my lord.
Status quo regarding nature, character, and
nature,
possession.
character. I have
Maintain that. We'll continue that.
For
We'll
the last
direct the
6
appeal.
years. for the
We'll
last
direct the appeal to be listed in the monthly paper books. You have not prepared.
Yes.
No, my lord,
There is a specific direction, my lord. Otherwise, when this is going on for the last 6 years, I have not changed the nature and character, and I undertake not to. But there should be a specific time bound.
my lord, within a month, my lord, I will, my lord, prepare and file, my lord, informal paper book.
Well, we'll put it on a specific date for hearing.
Yes.
But we'll make it clear. We'll again extend the interim order for a limited period so that they have a handle to mention. The present application for stay was treated to be one for injunction, and an order of status quo was granted for a period of 12 weeks on January 15, 2019 by a coordinate bench with regard to the nature, character, and possession of the subject matter of the disputed will. For next para, it is pointed out by learned counsel for the respondent that such interim order has expired long back without any effort on the part of the appellant to have the same extended. For next para, learned counsel for the appellant submits that the time for filing paper books be extended for a limited period. For next para, we find from the records that despite directions, the paper books have not yet been filed by the appellant. However, in order to do complete justice between the parties, more so since a testamentary matter involves the wishes of a deceased person, we are at present not being too harsh on the appellant. The interim order granted earlier is reimposed, and the parties shall maintain status quo as regards nature, character, and possession of the subject property till January 31, 2024 or until further order, comma, whichever is earlier. Full stop. Next para. The appellants shall prepare and file the requisite number of paper books latest by January 2, 2025. Full stop. The appeal shall thereafter be listed for hearing on January 8, 2024, along with the present application. Full stop. It is made clear that in the event the paper books are not filed within the period as stipulated above, comma, it would be open to the court to vacate the interim order granted.
But I have only one correction. Well, I am for the respondent number 1. Your Lordship.
আচ্ছা যেখানে যেখানে learned advocate for respondent number 1. Very. We are keeping the injunction pending along with the appeal. Appeal will be heard, and if you don't, then
Yes,
yes.
Grateful.
grateful.
We have made something in the
some time, my lord. Gives me some more time, my lord. And another thing, my lord, the appeal, my lord, SAT 67 and SAT 68, these are, my lord, connected. There were, my lord, two first appeals, my lord, before the Honorable District Judge. From there, my lord, from the analogous order, there were, my lord, two second appeals. My lord, so, my lord, in SAT 68, perhaps, my lord, the decree, my lord, the certified copy of the decree is there, my lord. If, my lord, if that is so, my lord would
no, we had already passed a direction. You should have pointed out at that point of time. Now
I
file
ought
as
to
the
have. I
certificate.
ought to have, my
Take
lord.
out another certified copy and file instead
My
of
lord,
the
kindly grants me time for 1 month, my lord, at least. My lord, I have tried to communicate with them.
They are not enjoying an interim order. Appeal has not been admitted. So this will only
No interim order, my lord.
no scope of interim. This was not admitted
not-
even. Was it admitted?
Not admitted
Could not
yet.
have been. Section 5 is
No,
pending.
no.
Learned counsel for the appellant submits that due to certain administrative issues in the appellant, what is this? A school?
A college, my lord.
Appellant college, comma, appropriate steps could not be taken to ensure that the defect in the appeal is cured in the meantime, full stop. On the prayer of the appellant, comma, the time for filing the certified copy of the trial court's degree is extended till January 15, 2025, full stop. Liberty to the parties to mention the matter for inclusion of the application for condonation of delay before the appropriate bench thereafter.
My lord, the condonation of delay has been allowed.
Then now it has been taken up under order 41.
Under order 41, yes.
Very well. To mention যেখানে বললাম up to mention, mention এর পর to mention the matter for hearing under order 41 rule 11 of the code of civil procedure thereafter.
Grateful, my lord.
Minus 12, my lord, I am appearing on behalf of the petitioner, my lord, appellant. This is my affidavit of service, my lord.
Good service evicted?
My lord. I sent to the parties, my lord, directly.
Yes, yes.
Track report is
Why
there,
an advocate is appearing for them?
my lord, once upon it, actually, I have preferred an appeal. Appeal has not yet been served. During the pendency appeal, the appellant has died. This is the matter relating to, my lord, execution of the will, probate of the will and succession certificate. Actually,
that was granted by the trial court.
Yes, succession certificate was granted when it was within the knowledge of the learned trial court that my client has filed an application that he is the executor of the will. The will is there. The court has granted his time fixed 30th August 2018 for hearing of that application. But in the meantime, that date was preponed without knowledge
Your
of my
application
client.
was for probate.
My application was not probate. I have intervened into the succession application.
You are the executor.
I am the, yes, my lord.
Executor of the
Yes,
will, named
yes.
executor in the will.
Named executor.
Why didn't you take out a probate application? You should have done that.
That has been filed, my lord.
If you don't do that, then they are entitled to take out letters of administration.
No, they have not taken letter. They are the third party. They are filed a succession certificate that has been granted, my lord. And during the pendency
If
of
you
this
sit
appeal.
tight over the probate, if you are the executor, if the executor does not want to take out a probate
My lord,
application,
he just died, my lord, kindly see, he died in the year 2020, my lord, I have 2020.
so what is
So
this application for?
it is only
Substitution.
for substitution because the appeal has been filed by one of the executor. There is two named executor, one has died, another is there. So I have filed this application on behalf of the another executor to be substituted in this, my lord, and to proceed with the appeal, my lord. Can 3, my lord.
There was you have served as per a previous direction of the court.
No, my lord, there was no direction. It is first time appearing, my lord.
Then this is not a valid service in the eye of law. You serve again, come back. Despite service, none appears for the respondent at the time of call. Full stop, affidavit of service filed today be kept on record. Full stop. However, comma, since the appellant stroke petitioner served of his own without any previous direction of the court, comma, in order to keep the records straight, comma, the appellant is directed to serve a fresh copy of the application on the respondent, indicating that the application shall be listed for hearing in the monthly list of January 2025, when the appellant shall file a fresh affidavit of service to that effect.
Much.
Thank you. Previously ruled by the court. This 13.
Yes, Your Lordship. I beg to appear for the respondent. CAN number 3 of 2024 is the application which I will be pressing for on the ground of immediate urgency, Your Lordship. There is a pending appeal by a licensee under a KOPT, under the KOPT. Now, what has happened on the ground that the building where I was a licensee has caught fire. They served me 2 notices that you have to evict the property without initiating proceedings under due process of law. They said that since the building has caught fire, it has become dangerous, now you evict the property. Now, those 2 notices were challenged by me before the City Civil Court by way of filing a suit. Initially, there was status quo order not to do anything with the property. Now, they filed an order 711 application, the KOPT, saying that the suit is barred under section 15 of the Public Premises Tenancy Act. Now, the order 711 was allowed, but on the ground, the court did not accept their contention. Court said that no, it is barred under 120 of the Major Court Trust Act, though this point was never taken by the defendant. Against that, an appeal has been preferred. Now, in the appeal, initially there was an interim order passed on 3rd of January 2023. If Your Lordship kindly comes to that order, page 14 of my CAN number 3 of 2024, Annexure A. Your Lordship allows me, I will place the order.
Yes.
The present appeal by order dated 20th February 2022, whereby the application taken out by the respondent under order 711 was allowed and the plaint was rejected. It is submitted on behalf. Yes, Your Lordship will then Your Lordship will come to the relevant portion at page 16. Yes. So considering the sequence of facts and considering the aspect that if before determination of the issue raised in the appeal, the appellant is evicted, it shall suffer substantial loss. We are inclined to pass an ad interim order to the effect that the parties shall maintain status quo with regard to the nature and character of the suit property till 31st of January or until further order. So this was a contested order.
You are wanting a recall of this order?
No. Restoration. Yes, I must candidly first. I must candidly first.
Restoration has been scored through and you have written recall.
Correct. I must candidly admit, Your Lordship, this is inadvertent error on the part of my advocate and record.
That's a very well.
It should have been restoration. When I saw the brief, I scolded him that this
what
could not
happened?
have been done.
This was vacated?
Now, yes, no. What has happened? This interim order was valid for more than 1.5 months. Now, kindly come to page 17. On 28th of February, the appellant, the advocates representing the appellant failed to appear, and the learned division bench was pleased not to extend because we failed to appear on that date. That is the only ground. It has not been recalled on merit. Kindly see page 17, second paragraph. No one appears today on behalf of the appellant and no accommodation has been sought for. Though Mr. Nag appearing for the respondent is present and in spite of Earlier order, no affidavit in reply has been served.
Mr. Nag was the architect of this.
Architect. So since we failed to appear, he took advantage that he's not
Rightly done.
rightly done. Rightly done.
took advantage.
Right.
Had the advantage he took.
I am not blaming him. Yes, he's entitled to for his client.
We are just saying he was the architect of.
Yes, he is the architect. Since we did not have he praised
He had a right
for
to be the
vacating. Yes, yes, he has, obviously.
Yes, Mr. Nag.
Now, what has happened now? Your Lordship kindly come to
Something else.
page. No, the urgency. Why this application? Page 19 and 20.
Yes.
Now, on 21st of October 2024, they have passed an order that kindly apprise me of the pendency of the appeal, because mere pendency is not stay. I will proceed with the eviction.
Obviously, yes.
So that is why the pending appeal, Your Lordship has seen the first order. The only purpose for granting the interim order was so that the cause of action survives.
What about the appeal? Have you taken any steps for hearing the, preparing the paper books or something like that?
No, so there was no direction for preparation. That's why
This is only Order 7, Rule 11.
Yes,
Correct.
my lord, may I tell you, Lordship, one thing, my lord?
Yes.
In case of reimposition, the matter has to be heard again for the passing of interim order. Now, my lord, here the appeal, the question is so short, my lord, it can be disposed of in 5 minutes. So, my lord, I am beseeching your Lordship, my lord, to look at the impugned order.
We'll dispose of in 5 minutes, but not today, because today the application is before us. We prepare informal paperwork so that there is uniformity between what the courts see and you see. Because only the plain written statement is also not there and not required to be looked into.
Not in.
Plain
My lord, only-
711 application objection
My lord, I tell you, Lordship.
and the order and memo.
When this impugned order was passed, my lord, on considering a Supreme Court judge, saying that under, if you file
I'll take up the appeal for hearing, Mr. Nag, but not right now.
Your Lordship,
But
only
the-
thing,
what
Your Lordship,
I want to say-
I showed
Their informal paper books within a week.
that I have not challenged any action taken under the Major Court Trust Act. So it cannot be a bar under section.
That we
9.
will
my
consider.
lord, clarify one thing. My
Yes.
proceeding
kindly
will not
grant
be
me-
stopped.
What proceeding?
The proceeding, the eviction proceeding,
If they
that is
evict,
going off before the
If you
estate
evict, then
office.
where is the question of there being any status quo regarding this
Well, it's-
position?
The eviction order, well, what happened here? This was a covert action. To, my lord, stop, my lord, an action.
We don't see any change of circumstance otherwise than what was observed by the division bench, earlier division bench.
Correct.
There is no positive change
When
of
the
circumstance.
interim order was obtained on suppression, because they were saying,
Suppression.
yes.
No,
they
we are
said-
not hearing any Order 13 and Rule 4,
Yes.
Sir Nag.
They have not filed any
That
application.
injunction application, they are asking for reimposition.
Reimposition.
As of today, there is nothing to show that there is any change of
And
circumstance.
they are proceeding on 21st of
No,
October.
yes.
Please
Sorry,
don't make a running commentary.
very
We cannot
sorry.
have a talk discussion.
No,
like
very
this.
sorry, very
Take your seat. Yes.
Sorry.
There is no change of circumstances, but the status quo order was passed as if there was no proceeding pending before the estate officer. Because that what, if Lordship kindly again look into it, the submission,
No,
kindly have a look
pe-
at page 2.
pendency of proceeding before estate officer is not germane, because the court observed categorically that there was a reason for this.
Well, let kindly have a look at page
No,
2.
see the reasoning. So, considering the sequence of facts and considering the aspect that if before determination of the issue raised in the appeal, the appellant is evicted, it shall suffer substantial loss. We are agreeing with this.
No,
Yes.
I am not saying that I will evict, but the proceeding under the due process, what
You
is
are not
going-
saying, we will say that you will not evict. You will not be
Lordship,
saying, we will be
Lordship,
saying.
I bow down to you.
Don't-
But
don't-
the eviction proceeding should not be stopped. But it cannot be
No,
because
eviction
section
proceeding should not be stopped and will direct status quo regarding possession.
Well,
What a ridiculous proposition of law,
no,
Mr.
well,
Nag.
I am saying, well,
The court will grant status quo
there
regarding
is eviction
possession
order,
and say, but yes, eviction proceeding will be
I
proceed.
will not give effect to the eviction
You are
order.
naive, but not so naive. With the double dots.
Because Lordship sees the internal page 2 of the order.
No, Mr. Nag.
We have
Record your
informed
objection, but
the date of proceedings.
prepare your paper books, come back with the, we can fix the appeal itself next week.
Lordship,
But we'll extend it for a limited period of time.
Lordship, next
Do that for a limited period.
next.
Third, learned counsel for the parties. Stop. Learned counsel for the petitioner submits that due to the absence of representation of the appellant on February 28, 2023, the interim order granted earlier was not extended. Full stop. It is, however, pointed out that the coordinate bench video order dated January 3, 2023 categorically recorded that considering the sequence of facts and the aspect that if before determination of the issue raised in the appeal, the appellant is evicted, it shall suffer substantial loss, passed an ad interim order of status quo with regard to this nature, character and position of the suit premises for a limited period. Full stop. The circumstances have not been changed in the meantime, and as such, the interim order, it is prayed, be extended. Stroke reimposed. Full stop. Next para. Learned counsel appearing for the respondent stroke Port Trust vehemently opposes the prayer. First of it is contended that the appellant obtained the interim order by suppression of material facts, in particular, the pendency of an eviction proceeding initiated by the respondent in due course of law was never disclosed to the coordinate bench, and as such, there should not be any reimposition of the same order. It is submitted that at the time of reimposition of an interim order, the court ought to hear the matter afresh and take a call on the issues involved. Next para. We find from the records that the present appeal has been preferred against an order rejecting the plaint in a suit filed by the appellant plaintiff. Next para. We agree with the opinion of the coordinate bench as expressed in the order dated January 3, 2023, that whatever might be the arguments of the parties on merits of the appeal, in the event the appellant is evicted from the disputed property prior to the hearing of the appeal, it would have the effect of deciding the appeal against the appellant prior to it being heard on merits. Next para. Moreover, we do not find any palpable change of circumstance to deviate from the opinion once expressed by the division bench. In the event an issue of suppression of fact is raised by the respondent, it was for the respondent to take out an appropriate application within the contemplation of Order 39, Rule 4 of the Code of Civil Procedure, which has not yet been done in the present case. Next para. Be that as it may, in the circumstances, we are of the opinion that the interim order granted earlier should be reimposed, however, ensuring that the appeal itself is heard expeditiously. Accordingly, Can 3 of 2024 is disposed of by reimposing the interim order of status quo dated January 3, 2023 and directing both parties to maintain status quo with regard to the nature, character and possession of the suit premises till January 31, 2025 or until further order, whichever is earlier. Next para. The respondent shall prepare and file the requisite number of informal paper books within a week or fortnight. Within a week from date, and serve an advance copy of the same on the learned advocate on record for the appellant. The appeal itself shall be listed for hearing on December 11, 2024.
I'm grateful, madam. Only one thing, there is an application for amendment where they have prayed for time to file opposition on 1st May 2023.
Amendment of what?
Amendment with regard to the cost title, which we have filed. They have prayed for time to file opposition on
What
May.
is the amendment sought?
Amendment,
Name of Kolkata Port Trust?
No. Hindustan Carrying Corporation was described as the partnership firm. It should be sole proprietor.
The problem is that in
for-
the plaint itself also there is the mistake. So whether in appeal, in amendment application, the plaint also can be amended.
So they have prayed for time to file opposition on 1st May 2023.
I will argue on
No
that.
opposition.
What is the CAN number of that?
CAN number 2 of 2023. They have not filed any opposition. as on date.
CAN 2 of 2023 shall be listed along with the appeal on December 11, 2024. Opposition, if any, thereto shall be filed by December 6, 2024. Reply shall be filed on the next return.
May I only pray for, instead of 11, can we have 13th?
Why 13th?
11th, Your Lordship, I am,
Friday the 13th.
may not be there in Calcutta for some professional work. Your Lordship is already fixed. In
Professional work we have to honor. Yes.
So I'm very sorry.
Then
for
instead of
this.
13, Friday we sit singly. I mean, then 16th, December 16th.
Yes, 16th. Your
Mr.
Lordship.
Nag, your diary, abroad or here or some other state. Or, instead of 11th, it will be 16th.
Grateful.
December 16th.
Grateful.
Much
Grateful.
Next.
Lord, I am appearing
Yes,
for
Mr.
the
Mukherjee, what is the matter?
appellant restoration application. Lord, I could not
Restoration
appear
within time.
within time.
Vehemently opposed. What is the stage of the appeal?
Lord, no direction for paper book. Admittedly, my Lord, it's a dispute of regarding royalty money in respect of land measuring 0.025 decimal.
There is no other injunction application or anything
No,
like that?
application for repairing. I have taken out an application because my property is in a very dilapidated condition. That is pending. That is can 2. And Milord, can 3 is the restoration application. Or can 1 to can 1. Can 1 that is stay of execution, I think.
We will dispose of this application. We'll allow this application, direct the other 2 applications to appear tomorrow in the list. Recall. In view of sufficient cause having been disclosed in the application for the absence of the appellants on the relevant date, comma, can 3 of 2024 is allowed, comma, what is the date of the
date, Milord, is November 11th.
Thereby recalling the order dated November 11, 2024 and restoring FAT 70 of 2023 and the connected applications to their original file and number. Full stop. Can 1 of 2024 as well as can 2 of 2024 shall be listed for hearing tomorrow.
Milord, it would be can 1 of 2023.
And 2?
And can 2 of 2024. Can 2 is
can 1 of 2023. Those will be listed tomorrow for you.
I'm grateful.
এখানেই আছে সব বলে দিচ্ছি।
Lordship, I am appearing on behalf of the appellant bank in this matter, your Lordship. Lordship, I am praying for adjournment for a week, your Lordship.
Mr. Jha, you are always ready.
Lordship, due to my personal inconvenience, your Lordship, brief is not in my hand here. And
for a week?
For a week, Lordship, kindly fix on Monday, Lordship.
He's always honest. You deserve that because you are always ready in your matters. So on the prayer of the appellant, the matter is adjourned for a week.
On Monday, Lordship.
For a week means next Monday? Yes, December 9th.
Lordship.
But I beg to appear on the petition.
Yes, please.
On my application, your Lordship is to direct the petitioner to serve copy of the application upon the respondents.
Is it happening for the first time?
No, my Lord, second time.
You have
It was
served?
taken up for hearing. Yes, I have served.
Service has been affected?
Lordship.
Please check up whether it has been.
Yes, I have.
Okay.
Only one respondent is there and delivery is confirmed. The track report is there, man.
Yes. What is the delay of?
30 days, according to the calculation, page 3 of my staff.
The reason?
Reason, my Lord, the COVID period was there. And during that time, my Lord, the order was passed and application was made, but there was some delay in.
And what is the injunction about? What is the appeal against?
Or the appeal against, my Lord, the specific purpose of contract, the suit was filed and it was, my Lord, passed. Twofold order was passed. Number one, my Lord, the specific purpose contract, the decree was not allowed. But on the other hand, my Lord, it was directed to get back
they
the
were
money.
The plaintiffs.
Lordship, I'm the plaintiff.
Oh, you are the plaintiff.
I'm the plaintiff.
You have challenged that the specific preference not being allowed.
Lordship.
And they were to return the money.
Yes, they have returned. They are to return the money because, my Lord, the order has been passed directing them to return the money. Though it is admitted position in the order itself, my Lord, clear that it is the laches on the part of the defendant.
Regarding the return of money, did you accept that return? Or if you have accepted, then there is very little scope. He is not sure.
No, my Lord, he is not sure. He just transfer brief, my Lord, so that.
Then we'll allow the condonation and pass an ad interim injunction, serve them again on the injunction.
Lordship.
That's what it is. Regarding the injunction, let us keep it open. Upon a perusal of the averments made in Can 1 of 2021, we are satisfied with the cause shown for the delay in preferring the appeal, since the pandemic woes, WOES, were ongoing at that juncture. Next para. Hence, Can 1 of 2021 is allowed, thereby condoning the delay in preferring FA 104 of 2023 and directing the said appeal to be registered. Next para, no arrest to cost. Next. Can 2 of 2021 is now taken up for hearing. Since the affidavit of service filed today discloses Oh, regarding that also you have served.
Both the applications.
Discloses that both the condonation application and the injunction application were served on the respondent, comma. We take up the injunction application for hearing, full stop. However, comma, upon perusing the averments made in the injunction application, we are of the opinion that another opportunity ought to be granted to the respondent to controvert the allegations made therein. Full stop. Next para. Accordingly, the respondent is restrained. What sort of injunction are you wanting?
Not to alienate the property, my lord. Which is should property.
Very well. Very well. Is restrained from. Na ki bolam? You pass an order of injunction? Just konta chalo. By an order of injunction from dealing with and or changing the nature and character of the suit property and or from transferring the same in favor of a third party till disposal of the injunction application, full stop. The respondent shall file affidavit in opposition to the injunction application within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The injunction application shall be listed in the monthly list of January 2025 for hearing.
Obligation.
Arekta line add kore daw. The appellant shall serve a fresh copy of the injunction application along with the gist of this order to the respondent and file another affidavit of service on the next date of hearing.
Good for yours.
Better to send a server copy.
I shall server copy. Obligation.
Mr. Boydurjo Ghoshal is for some respondent.
Mr.
Boydurjo Ghoshal is for, on behalf of
Yes.
some respondent.
Yes. What is the matter?
My lord, one of the respondent, my lord, died, my lord. My lord, application for substitution ready, my lord. Today it would be filed, my lord. Only 2 days time, my lord. In the meantime,
Take up next week. Lord, counsel for the appellant submits that one of the respondents has died in the meantime, and a substitution application shall be filed at the earliest. Full stop. In order to enable the appellant to do so, comma, let the matter stand over till December 9, 2024. Full stop. Liberty to the appellant to mention the substitution application as and when filed for inclusion and being tagged along with the other application.
Okay.
Next.
Item number 18. Or I'm for the respondent in this matter.
I'm appearing for the appellant.
Yes. My lord, already on this appeal, your lordship was pleased to pass an interim order. But the most important thing is this. In view of the judgment of the Honorable Supreme Court on
occupation
2G,
charges.
On 2G.
On 2G.
Oh, 2G. Yes.
2G. That is a my lord, matter standing before us.
Mr. You are to file an opposition to this for the purpose of.
I'm coming to that, my lord. I'm coming to that. I'm not very much worried about the occupation charges. I'm very much worried about the judgment passed by the Honorable Supreme Court, which will take away several hundreds of litigations.
No retrospective effect.
Retrospective effect and others.
So you are affected by that adversely.
Yes, yes. Now, my lord, just a minute for 5 minutes.
Yes, yes, absolutely.
My lord, since he is my junior friend, so
we are also your junior friends. So no difficulty. We'll wait for your comment. Yes, Mr. Dev, what is it?
Now, my lord, the father of this appellant and his brothers was the original tenant under the Premises Tenancy Act
1956. It's the previous one.
Yes. He died. When he died, we don't know. But after promulgation of the new act on 10th of July 2001, my lord, we have proceeded against the legal heirs of the tenants as tenants under the new act because they have inherited the tenancy and their tenancy will continue for 5 years from the date of commencement of this act. That is why in 2003, we have filed ejectment suit in the small causes court at Calcutta on certain grounds after serving of notice under section 6(4). And while the suit was going on, then my lord, in the evidence, they have said that our father died in 1990. So, by this time, My lord, 6 years have passed away, 5 years have passed away. Now, my lord, we have taken out an application in this honorable court under section 24 of the CPC for transfer of the suit because the small causes court has got no jurisdiction to adjudicate eviction of trespassers because they have been given power to adjudicate my lord ejectment suits under section 12A. You also knows very well, my lord, 12A of the Mediation Act 1987. Now, my lord, that application was heard by the then my lord Justice Tapan Kumar Dutt, and I was my application was rejected. Against that, my lord, I went to the Supreme Court. In the Honorable Supreme Court, my lord, after hearing both the parties, it is a reported judgment, and most probably it is the first judgment on section 2G. And I argued personally there. And my lord, my lord, the Honorable Court was pleased to direct the small causes court, as the evidence was already on record, to come to a finding whether they are the tenants or not. If they are tenants, then proceed with the suit. If they are not tenants, then return the plaintiff under Order 7, Rule 10, capital A.
Perfect. Yes.
My lord. My lord, it was found that they are not tenants by the small causes court. They preferred an appeal in the city civil court. The appeal affirmed the judgment of the small causes court. Now, my lord, then we have taken out, we have taken back the plaintiff in terms of section Order 7, Rule 10, capital A, and we have filed that in the city civil court at Calcutta.
That thing has to be revisited if it is, if the Supreme Court's latest view is taken.
I'm just praising your lordship with in a nutshell to my ability that the suit for eviction was the plaintiff was transferred and filed in the city civil court, and it was heard by the Lord Chief Judge, and the suit was decreed.
Please give us half a second.
My after the suit is decreed,
Your lordship also understands your agony.
my lord.
His lordship also understands your agony.
Oh, my lord.
Yes.
My lord, the agony of so many landlords, thousands of landlords.
But what would be done? Because the
Well,
Supreme Court
I'm just
Yes.
at the end, my lord. After the suit was decreed, we have put the degree in execution, and now in police help application is partnered.
Yes.
One witness has been examined, another. In the meantime, they have prepared the appeal, and your lordship is pleased to pass the interim order. I'm not worried about the interim order. I'm very much worried that my lord, kindly make room for me to argue on the Supreme Court judgment.
Very unenviable task for the High Court.
My lord, I want to argue.
No, we are open to that.
My lord.
We will hear that. But we have to prepare the appeal, finalize the paper.
Any form
You want to prepare the paper books?
My lord, any form. My client is, my lord, very now, maybe landlord, but
No, landlord need not be necessarily rich.
let them prepare formal paper book. The plaintiff.
But till then, you cannot be permitted to evict them. They will dispose of the injunction.
No, I'm not on the way of stay.
So you are not asking for this because we directed you to file opposition.
We will be filing opposition, my lord. We'll be filing opposition.
File
for,
that direction is already there.
Direction.
We have made it clear
have
that the
received-
question of
we have-
position of
we have
occupation.
received the copies 2-3 days back. my lord.
The occupation charges is a consolation price.
My lord.
Not occupation charges is not a final adjudication.
Absolutely, I know
It's a
that.
deterrent
There are
on them
several
also.
judgments from
And Mr. Ded, it's a deterrent on.
that Atmaram case.
Yes, deterrent on them also, so that they don't keep the appeal pending for inordinately long. It's a deterrent for that also.
Yes, madam.
If you have to pay occupation charges regularly, you will be fast in preparation of the paperwork.
Exactly.
Apparently, that's the impetus we want.
My lord, you'll also kindly have a look to the application for
No,
stay, my lord.
When will you file
My
your
lord, my lord,
opposition?
application for stay, you'll also kindly have a look, my lord. The thing will be very much clear.
Yes.
The application, paragraph 4. My lord, PMJ is situated Okrur Datta Lane. I don't know whether lordship knows it. It is a place in between Santosh Mitra Square and Subodh Malik
File your
Square.
opposition. We cannot take judicial notice of our personal.
Not that. I'm just very funny
No,
thing.
file your affidavit now.
Very funny thing. My lord, 60
Sir,
square
instead of
feet.
wasting time, we'll
My
take
lord,
up
2
this.
rooms and a dalan 60 square feet.
So you
Impossible.
Sir, you annex contemporaneous documents, receipts or something.
One
Do that.
I'll say it.
When can you file your opposition? Tell us.
My lord, within a week,
With those documents, we hope.
if there be any documents.
On the prayer of learned counsel for the respondent, the time for filing opposition is extended for a week from date. Stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on December 17, 2024. We passed injunction order till disposal of the application.
Till disposal, Lordship.
Just a minute. What
We'll just say. Till disposal, yes.
Till disposal.
No, my lord, kindly fix a date for hearing as early as possible.
Of the application.
And on the point.
When we dispose of the application, we'll direct paper books and all, the usual practice.
My
You are
lord,
the only respondent, one respondent.
I'm the only respondent, and only hurdle is that Supreme Court judgment.
You hope, you try to delay the appeal. That will help you. If the Supreme Court changes its mind.
Well, it
happens
don't know.
sometimes.
I don't know, but my lord, I'm just expressing my mind. Your lordship, my
You
lord,
can, but we cannot.
that is our liberty.
Yes.
That is our liberty, my lord. My lord, Supreme Court judgment is very, my lord, with due respect, my lord, it is very unfortunate.
Lordship, only one indulgence, interim order. May kindly.
Continue.
Mr. De, please make him understand. Next matter.
I will not stand in the way. I am very much worried about the law point.
And the affidavit of service may kindly be taken.
At a line add করে দিতে হবে, affidavit of service filed today be kept.
কবে আসবে বলুন?
17th.
আপনারা আমাদের ইয়ে করতে বলেছে।
17th.
17th. I'm good.
Item number 19.
But I'm very much eager to argue the matter before your lordship.
Absolutely. It will be a very interesting point.
Yes.
Number 19.
My lord, this matter,
yes,
we appear for the my lord, the appellants. My lord, they have supplied us a copy stating that the respondents have passed away. Since we need to file an
all the respondents.
My lord,
1 to 5.
1 to 5.
1 to 5 all have passed away.
My lord, we on Friday, my lord, we were being informed by them, my lord.
No, 1 to 5 have passed away.
Yes, my lord.
Where are the particulars of the heirs?
I do not know, my
My lord, they have supplied us, my lord. But I am handicapped with a brief to today, my lord.
When should you keep it? You
my lord,
take out your application.
Yes, my lord, a fortnight, my lord, fortnight's time.
This will go out of the list. Applications we always include.
Yes.
So file that application, mention both the applications. We'll
Great.
take up. Learned counsel for the appellant candidly submits that it has been informed by the learned advocate for the respondents that the respondent numbers 1 to 5 in the appeal have passed away, and as such, appropriate application for substitution has to be taken out. For such purpose, the appellant seeks a fortnight's time. Next para, liberty is accordingly granted to the appellant to take appropriate steps in that regard at the earliest. The matter shall go out of the list for the present with liberty to the parties to mention for inclusion in the list as and when an appropriate application for substitution and or other ancillary reliefs, if required, is filed. Ancillary reliefs means setting aside abatement, all those.
My lord, I may be excused, my lord. My advocate on record has come, my lord. On the instruction I submit, the respondent number 1 has passed away.
Not 1 to 5.
Not all.
1 to 5 now. 1. Thank God.
Yes, yes. I was also on this.
Respond number 1 কিন্তু ওটা, না?
Yes.
হ্যাঁ, I kept as 1 to 5. Maybe the shock of having an appeal.
Extremely grateful.
Item number 20.
Yes. 20.
My lord, service has not completed. I am.
There was a direction previously to serve.
Service not complete.
We directed you on 4th of November. So 1 month has passed. Why didn't you serve? Then we'll vacate the interim order. Why not? What is the reason for not completing the service?
I am very
You cannot get an order of stay and go on like this.
due to illness of my.
That you discovered right now.
Kindly give me time.
Why shouldn't you limit the interim order then? What is the decree? You have preferred the appeal against what decree? An adjournment is sought on the ground of the petitioners. Learned counsel appearing for the petitioner submits that copy of the application could not be served on the respondents. We find from the records that we had directed service of copies of the application on the respondents long back on November 4, 2024. As such, it is unfortunate that till date, no copy of the application has yet been served. Next para. Accordingly, we are modifying the interim order dated November 4, 2024 to the effect that the interim order of stay of operation of the impugned judgment and degree shall now operate till January 15, 2025 or until further order, whichever is earlier. The petitioners shall serve copies of the application immediately on the respondents indicating the next returnable date and shall file an affidavit of service on the next date when the matter is taken up for hearing. We have limited the interim order till January 15th. Now you are at risk. If you don't serve again, then it will be vacated. Take a short break. Yes. We'll take that break and come back, Mr. Chatterjee.
Lord, this matter, my lord, I'll take 2 weeks time, my lord. The reply is
Matter?
ready. Yes, sir.
20 to call.
21.
21 call.
The reply, my lord, is ready, but it hasn't been the client.
You are for the respondent.
Appellant.
Lord, we have filed our opposition, Lord. We are filing.
Just extends the time, my lord, for about a week or two, my lord.
Mr. Rai.
Lord, I will.
On the prayer of the appellant, the time for filing reply is extended for a week from date. The affidavit in opposition filed today be kept on record. Full stop. The matter shall be listed next on December 10, 2024.
So grateful.
Lord, after 10, Lord, any reason.
11. December 11.
11.
We'll come back in 5 minutes for the next one.
Definitely.
Great.
Great.
Number 22.
My lord,
Yes, Mr. Ghosh, what is the matter?
I beg to appear on behalf of the
You're for the
appellant.
other side.
I beg to appear on the appellant in respect of FM 8358. And also I'm for the petitioner in CO number 3943. Both the matters have been directed to be heard. There is an order passed by this honorable court.
What is the connection between the two, Mr. Ghosh? Please explain why the CO is also there.
Abandoned precaution, I also preferred civil application because, well, lord, I'm telling the facts of the very short. Suit for partition. Well, lord, I got 2/3 share from my uncle, and my landed friend's client inherited 1/3 share inherited from his father. 1/3. Two uncles.
No, you have challenged what? Injunction?
I have
passed
challenged
in-
the order of injunction passed till a miscellaneous case arising out of a 9 Order 9 Rule 13 filed after disposing of the suit in a final degree. The suit was decreed finally. A final degree was passed.
No, the Order 9 Rule 13 was in respect of?
Order 9 Rule 13 has been filed by my landed friend's client, alleging that
Against the?
Expiry decree.
No, this is from partition suit.
Partition suit.
You filed that Order 9 Rule 13 in connection with the preliminary decree.
No, final decree.
Final degree itself. So that decree was passed, you took out that Order 9 Rule 13 and got an injunction in connection with that.
Thereafter, I filed with Section 5 application and also an injunction.
Section 5, the Order 9 Rule 13?
Along with Section 5.
Section 5 was not allowed.
Not disposed of, not
But injunction was granted.
In the meantime, just the trial court has directed not to dispose the property till the disposal of the Section 9 application. Section 5.
That is an injunction.
This is the order. It's not assailing.
My lord,
Order
after disposal final degree, both the parties got their name mutual in the local office. My lord,
No, that is different, Mr. Ghosh, but since they have taken out an Order 9 Rule 13, Section 5, I mean, we will direct the Section 5 to be heard within a fortnight from the communication. Let that injunction still, it's there for so long.
My lord,
Yes.
If is not maintainable, he could have preferred an appeal against the final degree. But how can
Why is the Order 9 Rule 13 not maintainable, do you say? Why do you say that?
final
It was not
degree-
an expiry degree.
No, he contested the entire proceedings. And the application was filed for preponing the date from 29 April 2023. After serving notice, landed trial court allowed the application. It is not an expiry degree.
Lordship, may I submit on?
Yes.
Preliminary decree was passed. Thereafter, the place to the final decree. In the meantime, they prepared an application for preponing the date without intimating the defendant respondent and got the final decree. And the next date was scheduled. When the defendant appeared in the court, they come to know that the suit was decreed prior to the date.
If you want.
Against that,
Case. But we are handicapped because we cannot interfere with the main matter.
Not only
Because Order 9 Rule 13 and his Section 5 is pending.
Section
You are against an injunction application. We will dispose of lock, stock, barrel here, direct the trial court to decide within 15th January.
But in the meantime, injunction will not continue.
It has been continuing for so long. We won't disturb
Lord, I
that.
have
No,
challenged
we'll
that
limit
order.
that stay. We'll limit that injunction. Mr. Ghosh will say that that injunction will operate till January 31st, 2025 or until further order of the trial court, whichever is earlier. And secondly, request the trial court to dispose of the Section 5 application within, say, January 15.
I came to learn that there is no judge and will not.
Will empower the district judge to allocate to some other judge who is sitting.
My lord, I am unnecessarily suffering. My lord, I take only 2 minutes time. First partition commission owing to the local.
You are asking for what? This is an interim order application before us. Stay of operation of an injunction order, Mr. Ghosh, we don't grant. You know we don't grant. That would be allowing your appeal before hearing you.
But only 2 minutes time. Partition commission owing to the local. Well, kindly see this, how the petitioner appeal is being harassed by the conduct of the other side.
Ghosh, we appreciate fully. But the difficulty is if you stay the injunction order, if it was a positive direction, then we could have stayed.
Absolutely.
Directing you to do something. What do you propose to do? I mean, we can stay application. We'll have to take up. Then along with the appeal, we can take up.
But
if you
I have
want.
nothing to do with direction given by the lordships. But in the meantime, injunction, my lord. Injunction, my lord. Partition degree, my lord.
Your FMT has been admitted.
Yes.
Then we can take up the appeal and the CO together along with the application.
Kindly give short, my lord. Shortest possible, my lord.
You can do that.
Only appreciate the sufferings of the appeal and petition.
Very well. So how soon can you prepare your paper books?
Within the
Informal
week.
paper books you will prepare.
Yes.
Is an appeal maintainable or it should be CO? Because Order 9 Rule 13, because the language of Order 39
that is
is
the reasonings I have.
In my view, Lordship, it's appeal not maintainable.
revision should be maintainable.
Revision
So if revision is maintainable, we have annexed everything to the revisional application.
Yes, yes. So kindly fix it.
Then we can take up the revisional application itself for hearing. Because the language of Order 43 is, if an order is passed under Order 39, Rule 1 and 2, then
Everything I have understood.
CO has been directed to be heard along with the
Yes,
appeal.
there is an order on 1st May 2024.
So by
May
virtue
I
of that,
permit to
we
read
can
out?
take up
We feel that both the persons should be heard by a common bench in order to avoid conflicting decisions to be taken in respective cases. And therefore, let this record be placed before the Honorable Chief Justice. Therefore, assignment is that both the matters will be heard.
Where you will take up the CO, then come prepared. When can you come prepared on the CO? Stay along with the CO. CO, you check up whether you have annexed everything.
Yes, yes, everything I have annexed.
All are annexed. So we can take up even today. What's the difficulty?
Well, I am ready.
If you are prepared, you can take up.
I am ready, my lord.
I'm not ready with any judgment if is needed.
Come back on next week. We'll keep it. Next Monday, we'll keep it. The CO itself. The present challenge has been preferred against an order granting injunction in an application for condonation of delay in preferring a petition under Order 9, Rule 13 of the Code of Civil Procedure. Full-stop. The brief facts are that that a final degree of partition was passed in favor of the respondent stroke opposite party. Full-stop. Against the same, comma, pleading that the same is an ex parte decree, comma, the application under Order 9, Rule 13 of the Code was preferred by the present respondent along with an application for condonation of delay in filing the same. Full-stop. During the pendency of the Section 5 application, comma, the impugned order of injunction was passed. Full-stop. Next para. Learned counsel for the appellant contends that the court below was acted without jurisdiction and illegally in granting the injunction, comma, since the application under Order 9, Rule 13 itself was not maintainable as the decree was not an ex parte decree. Secondly, comma, no injunction could be passed before deciding the application for condonation of delay. Such contentions are controverted by learned counsel for the respondent. Next para. Be that as it may, comma, we find from the records that for abundant caution, comma, both an appeal and a revisional application has been preferred against the self-same impugned order, comma, since there was apparently a doubt as to what would be maintainable, comma, since the order of injunction has been passed in connection not with a regular suit but a condonation application in connection with an Order 9, Rule 13 application. Next para. We are of the opinion, comma, upon considering the facts of the case, comma, that a regular appeal is not maintainable against the impugned order. First, comma, Order 43 of the Code contemplates an appeal against orders passed granting or refusing injunction under Order 39 Rules 1 and 2 of the Code of Civil Procedure. Since Order 39 Rules 1 and 2 envisage injunctions passed or refused in connection with a suit, comma, as opposed to the present case, comma, in any event, no appeal would be maintainable under Order 43. Next para. More importantly, comma, the order of injunction has been passed not even in the Order 9, Rule 13 application, but prior to condonation of the delay in filing the same, comma, in connection with the condonation application, which is in any event an injunction passed under section 151 of the code and not 1 under order 39 rules 1 and 2 of the code of civil procedure. Full stop. Hence, comma, a revisional application is maintainable against the impugned order. Full stop. Accordingly, we dispose of FMAT 358 of 2023 along with the connected CAN, along with CAN 1 of 2023, and hold that CO 3943 of 2023 is maintainable against the impugned order. Full stop. The said revisional application shall be listed for hearing on December 9, 2024 under the heading applications. Full stop. It is understood that on the said date, comma, the revisional application will be decided finally. Full stop. Next para. We add a line of caution here. Full stop. Although otherwise, this division bench would not have determination to take up civil revisional applications, comma, since the revision was filed in connection with an appeal and has been assigned specifically to this bench, comma, there is no fetter in this court taking up the matter. In one matter, we passed an order at the time of FMAT, we have determination. Yes, what is the matter with
the
the motion?
plaintiff in a suit for partition, right, which was dismissed on the ground of res judicata. And Lordship,
what is your prima facie case? Why not res judicata?
Initially, there was a suit. The said suit was dismissed as dismissed for default.
Then order 9 bar is there.
No bar is there, but it's a partition suit regarding cause of action. Number the suit has been dismissed.
Sufficient prima facie case. So appearing for the first time.
No, there's a direction for service. Earlier, I have served. It was some of in case of some of the respondents, it's returned back. I was further served. Number the thing is that respondent number the years of respondent number 2. That are returned back with an endorsement.
Years of respondent 2 means he has died in the meantime.
He has died. He has substituted in the memorandum.
Substitution effected.
Yes, in the memorandum of appeal,
But in the application, you have not reflected.
No matter what happened before filing of the appeal and after passing of the impugned decree, he died. So I filed an application for leave to appeal to.
Oh, so all the heirs are
yes,
in the cause title.
Yes.
All of them have been who have not been served.
But if you also can take
Which
up
of the opposite parties?
Memorandum of appeal, can take up the memorandum of appeal.
Yes.
Respondent number 2, Sheikh Ghaffar Ali.
Yes.
He died. His heirs ABC.
But his heirs have to be served a copy of this application.
But I've sent, but that has returned back with an endorsement not served.
Serve again on them.
But I've served twice, Malada. They are residing in Delhi. And
what is the endorsement on the envelope?
No, endorsements are, it's in Hindi, Malada.
Both of us understand Hindi.
But
if you don't understand Hindi, it's one of the official languages.
But I don't understand.
And if it is in Delhi, my lord may also know the address. So, whether it's a false address, this is not Hindi. This is Hindi, yes.
And more interestingly, the
definition. Illegible Hindi, actually. Pata hai. Handwriting is like mine.
Address cannot be located.
So you have to find out their address. We'll pass an interim order. Are you enjoying an interim order?
No, madam, I'm not enjoying because
we'll pass an interim order, but for a limited period, you have to search out their address. But without searching out those addresses, you cannot serve them. How soon?
No,
can
but
you
the
do that?
problem is that the defendant number one, the defendant number two did not contest the suit also. Only the defendant number one contest the suit.
Or two did not contest?
Did not contest. Written statement filed only on behalf of the defendant number one only.
But two was served.
Who was served? He was alive at that point of time.
Because non-contesting party will dispense with service. We'll dispense with service then. You, please check up Mr. Ghosh.
Yes, yes,
that
yes,
you
my lord. I have the copy.
Only written statement was filed only by one.
One.
It was from the.
Well, kindly come to page 6 of the impugned order. Inner page 6.
But
issue
page
number
3, internal page 3, it
but,
is stated the
yes, yes,
defendants
defendants. But in
yes.
the inner page 6, my lord, kindly see issue number 6 and 6A, second paragraph. Regarding these issues, the defendant number one, the only contesting defendant.
Yes, yes.
In his written statement stated that previous only defendant number one contested.
So then we'll dispose of the injunction application directly to prepare paperbooks and all.
Yes, my lord.
The affidavits of service, you are filing the envelopes also. The
Well,
affidavits of service and envelopes filed today be kept on record. Are kept on record. Full-stop. It transpires that proper service has not been effected as yet on the heirs and legal representatives of the respondent number 2, who has died in the meantime, and his heirs were substituted in the appeal. Full-stop. Next para. However, comma, it is rightly pointed out by learned counsel for the appellants, comma, that it was recorded in the impugned judgment of the trial court that only the defendant number 1 / respondent number 1 herein contested the suit. Full-stop. As such, comma, we are of the opinion that service may be dispensed with on the other non-contesting defendants. Full-stop. Accordingly, the application is treated to be ready as regards service. Full-stop. A prima facie case has been made out by the appellants for hearing the appeal on merits insofar as the cause of action for filing a partition suit is a continuing cause of action and proceeds in diem. Full-stop. Moreover, comma, as opposed to the principle of res judicata, which was apparently applied by the trial court, comma, the principle akin to Order 9, Rule 9 of the Code of Civil Procedure would apparently be applicable to the present case. Full-stop. Next para. In such view of the matter, comma, and since sufficient urgency has been made out by the petitioner, and we find from the averments in the injunction application that the balance of convenience and inconvenience and irreparable injury factors favor the grant of an injunction, comma, the respondent number 1, we shall injunct the respondent number 1 only. Respondent number 1, respondent / opposite party number 1 and or his men and agents are restrained by an order of injunction from selling, transferring, alienating and or interfering and or transferring the suit property in selling, transferring, encumbering and or alienating the suit property in favor of third parties in any manner. Full-stop. The parties shall also maintain status quo as regards possession of the suit property. Full-stop. Both the aforesaid components of the interim order shall continue till disposal of the appeal. Full-stop. There will be no orders to cost. Stop. The appellants shall prepare and the appellant shall put in the requisites, including Tolobana, written up declaration and notice form, written up notice form and declaration within a week from date. Full-stop. The records be called for by special messenger, costs of which shall be deposited by the appellants also within a week from date. Full-stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, and the parties will be at liberty to mention the appeal for being enlisted for hearing as and when the same is made ready for hearing.
Much obliged. I'm not grateful. Grateful.
My lord, I beg to appear on behalf of the appellants, petitioners. My lord, I have, pursuant to my lord's direction, I have already served.
Yes.
Mr. Rajiv Rai is appearing for the opposite party. He has not come to the due to physical illness. I am praying for our case accommodation.
Physical illness.
Well, in any
Not a
event,
case of mental illness, so we'll grant it. If it was mental illness, we wouldn't grant it. Yes, so very well. When will he come back?
Tomorrow, Lord.
Tomorrow. What about this? Who was not served?
my lord, initially it could not be served due to insufficient address. The same address it was there in the plaint. Now afterwards, my lord,
Oh, you are appearing for the only respondent.
only respondent.
Very good. The affidavit of service filed today be kept on record. Full stop. An adjournment is sought on behalf of the respondent. Full stop. Accordingly, let the matter stand over for the day. Come back tomorrow.
Good.
Thank you.
Item number 26. 26, my lord, I appear for the appellant, my lord. In this matter, my lord, the CAN application has been disposed of already. The CAN is disposed of,
Directed to file a paper book, my lord.
but that'll be filed either tomorrow or day after, my lord. The order was dated 25th November.
So do that and we'll keep it next week for hearing the appeal.
Yes, sir.
FMT. Well, application আবার আসছে কেন এটা? হ্যাঁ?
Application to dispose.
Application disposed of.
কিন্তু application heading এ এসছে তো। Application heading এ এসছে কেন?
পেপার ছিল না তো।
I'm grateful. Could you, your lordship's pleasure, make it on 10th?
10th? তাহলে 9th না 10th? 10th.
I'm so grateful.
Thank you.
In this matter, I am for the lordship appellant petitioner lordship wife. Now lordship husband filed a suit for divorce lordship against which lordship a section 5 application lordship after 180 days.
No, husband obtained the divorce.
Husband lordship obtained the divorce on the ground of cruelty. Lordship, no, Mr. Owen Banerjee is appearing for the opposite party. You have been informed.
So
Initially, lordship, they
first. Section 5 has to be taken up first.
Yes, lordship.
180 days.
180 days.
You're sure he has not remarried?
Yes, remarried.
Oh, he has remarried.
Remarried lordship, that was taken ground on the opposition. We filed reply against that lordship and supplementary affidavit was filed lordship.
What do they use? Take instruction, Mr. Shannon.
Initial lordship. May I come back tomorrow, then lordship?
Their marriage is not illegal. Did they wait for that appeal period?
After expiry of the lordship statutory appeal period.
Then the marriage is valid also. What useful purpose will be served? If you win the appeal, this appeal.
So initially we tried to lordship settle the issue lordship, but because wife is did not getting any maintenance, that there is a minor child. So
we
regarding
can think about that. If a solution can be, should we send it to mediation?
I am led by Mr. Parthapratim Roy. So kindly take the matter.
You are there, Mr. Banerjee is there. You are there by default. You are his chamber junior. So why don't we send it to mediation?
It's not a chamber brief. I am not.
So what?
Then, my lord, kindly fix it tomorrow, my lord. I shall take instruction.
Mediation initially.
Take instruction, Mr. Shannon.
Yes, lordship. We are ready, agreeable to lordship for mediation, lordship, but যেহেতু বলছে আমার অ্যালুমিনিয়াম কারণ ও তো বিয়ে করে নিয়েছে আর তো সংরক্ষণ কি করে করবে অ্যালুমিনিয়াম
আর সামনে সপ্তাহের আমাদের মধ্যে নিয়ে নেবে দেখো আমার চেম্বার
Then lordship, may I pray one thing? If you lordship kindly take the matter on next Monday or Friday or Thursday, lordship, we can came back before you lordship with instruction.
If you can, you have a talk with Mr. Banerjee and involve your clients also if necessary. And if there is a scope of settling on the aluminium, We'll record something in our order. The present application bearing Can 2 of 2023 has been preferred for condonation of delay in filing an appeal by the appellant wife against a divorce decree obtained by the respondent husband. So next para, it transpires upon hearing learned counsel that after waiting for the appeal period, comma, the respondent husband contracted a second marriage. Next para, although technically there was no bar for the husband to do so, comma, in the event the appellant succeeds in the present appeal upon condonation of delay, comma, if at all condoned, comma, there would be a precarious situation for at least 3 lives, comma, being that of the parties herein and the second wife of the respondent. As such, comma, a query was made by us to learned counsel for the appellant as to whether the matter could be resolved between the parties by the parties parting ways. Parting ways. Next para. It appears that there is an issue as to the claim of the appellant wife for alimony, comma, which could be a sticking point in such conciliation between the parties. Next para. We also put the question to counsel as to whether the matter can be sent to mediation. For taking instruction from their clients on the issue as to whether the matter can be resolved from here upon agreeing on an amount of permanent alimony and stroke or the matter can be sent for mediation, comma, the matter is adjourned till December 9, 2024. The matter shall be placed under the same heading on the said returnable date when learned counsel for the parties shall apprise the court of the outcome of their endeavor.
Grateful.
এই আমার রেসপন্স নাম্বার কত? আমার চারটা না দেবো আমরা তো আরম্ভ 28
This side or that side?
Lord, the plaintiff, Lord, is the appellant before Lordship, Lord.
Yeah,
it's you all the way, Mr. Chatterjee. It's you all the way. All of them are his junior, both sides. Collusive, dismissed.
Yes, kindly. Yes, Lord. Very collusive.
Kindly cease.
This shows there's no collusion. Yes, Mr. Koro, what is the matter?
Lord, kindly comes to, it's against, Lord, an order refusing, Lord, the grant of ad interim injunction. Lord, the suit is against, Lord, challenging certain sale deeds. Lord, in that suit, Lord, I have prayed for injunction that has been refused. Lord, kindly straight away comes to, Lord, page number 35. Lord, although a usual, Lord, plea will be taken, that ad interim order refused so long, now no merit, so go back and fight it out. Lord, before that, Lord, as a caveat, Lord, I say, Lord, there is, Lord, valid ground for your Lordship's interference.
The injunction has been refused.
Can you see when it was refused?
Yes, Lord, I have put myself on caveat.
Yes, Mr.
Kindly, Lord, comes to 35. Page 35. The ad interim order of injunction is moved. No caveat is pending.
1 minute. This has been admitted.
Lord, this was not. I understand.
It's city civil court. We don't have determination.
Admit. Last Lord on last.
No determination. Justice Tandon. Go there and convince his lordship.
এটা তো পুরনো this is 2023
না তাহলে ওখানে
We have order 41 up to 2020. We have misappeal and first appeals from 2016. But if there's a misappeal between 2016 and 2020, it is taken up by the bench taking up order 41 matters. Immediately after admission, we have determination. That bench does not have determination. And if it's a city civil court matter, we have every determination. Order 41
have been
appeals.
passed in this matter.
So this is
If
the
you Lordship can
predicament.
treat those Lord matters
One
as
in one matter,
informal admission.
One matter, Mr. Kormakar, we did that. We informally admitted, decided the appeal or passed an interim, some order, probably decided. Where is Mr. Mukherjee? Mr. Meghajit Mukherjee was there. No, not him. He's not. His client took out an application. We are citing him as a witness, not as a culprit. He does not have any fault whatsoever. We encouraged him actually. He took out an application. His client took out an application for recall of that on that ground.
Justice Desai is judge.
So There are several judgments. I became aware of some of them at that point of time. So
But
five judgments were cited.
here I
on both
don't think
sides.
any of the parties will dispute that stand. Lord, there is no
No,
question of Lord.
Excuse me.
Not admitted.
জজ সাহেবের কাছে করতে অসুবিধা আছে নাকি?
No, we don't have determined.
Very well, Lord.
It's a nullity.
Since the appeal has not yet been admitted and we do not have determination to take up matters under Order 42 and Rule 11 of the Code of Civil Procedure, after the year 2020, let the matter go out of our list due to lack of determination with liberty to the parties for to mention for inclusion before the appropriate
Milord,
bench.
can you send this to the special bench as well, my lord?
Your Lordship was saying, my Lord, collusion. Your Lordship finds, my Lord, collusion.
Can you send it to the special bench, my lord? It will be good, my lord.
Why special bench?
Your lordship has the other matter, my lord, sent it to the special bench.
But for admission of the appeal, your Lordship send it.
No, that we are trying to avoid that.
Okay, kindly do this, my lord, then, my lord, for special bench, my lord.
On a better point. Yes.
Number 29.
Madam.
My lord, for the appellant petitioner, the application for injunction has been heard on.
Yeah, for the respondent.
For the respondent, also have instruction to appear. I'm yet to get all the. I understand that there is an interim order in this matter.
Yes,
It's the proposal of the application.
So if your lordship kindly directs me to file a short affidavit, I shall come up with a short affidavit within 2 weeks' time.
We'll do that. Yes.
affidavit of service, your lordship.
Affidavit of service filed to be kept on record. Full of learned counsel appearing for the respondents seeks an opportunity to file an affidavit in opposition to the injunction application to controvert certain allegations made therein. Full stop. Accordingly, the respondents are directed to you have instruction for all the respondents.
Of 1 and 2.
The others you have served. The others have been served. Oh, we directed on. There are two only.
Two only.
Yes.
Who served, my lord,
Very well. Accordingly, the respondents are directed to file their affidavit in opposition to the injunction application within what time? Within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing in the monthly list of January 2025.
Like 2 weeks.
Reply 2 weeks. Why? 1 week.
Grateful to your lord.
You'll get 1 weekend. Reply you don't require. Reply in an injuction application in connection with the
My
receipt.
learned friend will get a year in.
Yes. No, he'll not get the year in. We ensured that. 1 week finishes before that. That is what he's wanting.
Grateful to your lord.
Yes.
And let's say already directed to file paperwork on the last occasion. 26.
এগুলো আসছে কেন করছো বলো
But I believe since CAN 1 is appearing, that is why maybe.
CAN 1 that was not disposed of.
No, let's say directed to be heard along with appeal.
Appeal, yes. ও তো বলাই আছে দেখো এদিকে এসো shall be listed along with the main appeal by an order dated November 26, 2024. Full stop. However, it is appearing under the application heading. Full stop. Let the appeal along with the application be listed under the heading hearing tomorrow.
Well, actually, paperwork has not yet been filed. They're supposed to file paperwork, etc. There was a direction, specific direction for filing paperwork.
আচ্ছা tomorrow না করে তাহলে on December 16, 2024. Full stop. The appellants shall positively prepare and file the requisite number of paper books in the meantime.
So let's see.
Thanks.
My lord, in item number 31, my
1 second. যেগুলো অ্যাপিল অ্যাপ্লিকেশন একসঙ্গে বলবো সেগুলো তখন
number
talks
30.
of settlement. What about that?
Yes, my lord, it is almost on the verge, my lord. We have come to a conclusion that we'll be handing over the possession by the end of January, my lord. Kindly keeps it out in the first week of February, my lord. Then necessary orders will be passed, my lord, accordingly.
You're for the appellant.
Yes, my lord.
The
Judgment
counsel
is
for the appellant submits that the talks of settlement between the parties have proceeded substantially and the matter is on the verge of being resolved amicably. Full stop. Accordingly, comma, on the prayer of the appellant, the matter is adjourned and shall next be listed under the same heading in the monthly list of February 2025.
Grateful, my lord.
প্রথমে একটা করে দেবে none appears for the respondents at the time of call. Then whatever you say.
Your Lordship, I am appearing for the petitioner. The counsel pleading in this matter, Your Lordship, is
What
unveiled.
matter? We have not called any other matter.
Oh, item 32.
32? Yes.
Your Lordship, the counsel appearing in this matter for the petitioner is unwell, on account of which he is not able to appear today. I am seeking for 1 week's time. It may be granted, Your Lordship.
An adjournment is sought on the ground of learned counsel for the appellant. Let the matter stand adjourned till December 9, 2024.
Grateful, my lord.
Give your name, please. Next.
Number 33.
As per instruction, my lord, I have served.
Yes, what is the matter, Mr. Bandyopadhyay?
My lord, I have instruction to appear, but I am yet to receive the post papers, Lordship. If you will also kindly take up the matter on next week, Lordship.
Why in all your matters, Mr. De?
My lord, I have received the instruction to appear, but not the papers, my lord.
There is a subsisting injunction.
Yeah, there is application.
There is.
And 20 days delay, my
This is no condonation application.
condonation application. my lord.
There is no injunction now.
Injunction is also there, my lord, after condonation of delay. my lord.
No, there is no injunction order in force subject to correction.
If you did not condone the delay, then how could you pass injunction?
My lord.
What,
There-
my lord?
My lord, there is a application for condonation of delay, my lord.
Have we passed injunction in? Has this court passed injunction?
No, my lord, no.
Here there. Affidavit of service filed today be kept on record. Full stop. Learned counsel having instruction to appear for the respondent seeks a week's adjournment. Accordingly, let the matter stand over till December 9, 2024.
Lordship on 10th, Lordship. On
Very well. Adjourn till December 10, 2024.
I'm grateful.
Mr. De, please ensure that nothing is done in the meantime if we don't know the facts of the case. At least till the condonation is heard.
Grateful to you.
Thank
you. Number 34.
My lord, 34 service is not complete. my lord. The last-
Service not complete.
No, my lord. Last week I have served my
Learned counsel for the appellant submits that the service is not yet complete. Full stop. Let the matter stand adjourned till December 16, 2024.
I'm good.
16th December.
Number 35.
My lord, I beg to the appellant, my lord.
Yes, Mr. Ghosh. What is that? Appearing for the first time?
First time. My lord, stay application has been filed, my lord. There is a duration to serve copy of the stay application on the other side, my lord.
No, you have served.
No, stay application has not been served.
No, you said there was a direction.
No, my lord, there may be direction from a lot.
You're asking for a direction. What is the
My lord,
appeal arises out of?
Appellant husband prepared an appeal against the judgment and decree passed in a matrimonial suit. This matrimonial proceedings was initiated by the husband appellant on the ground of cruelty and desertion. My lord, learned trial court, my lord, dismissed the applications on the ground that when I have not initiated the proceedings under section 9 of the Hindu Marriage Act, so plea of desertion cannot be believed. No, that is the finding of the.
You filed only on the ground of desertion or cruelty also?
The cruelty also.
What about cruelty? What was held?
My lord, he left the premises, my lord. She left the premises 12th November 2013. Marriage was solemnized on 8th February 2012. That a child was a male child. My lord, along with male child, she deserted without any reasonable cause and excuse, my lord.
Divorce decree has been refused. So what is the scope of stay, Mr. Ghosh? We'll dispose of the stay, we'll grant you, we'll ask you to put in whatever requisites and all, so that you can expedite the hearing of the appeal.
I'm good. I'm deeply.
We'll dispose of the stay application without granting any stay, but passing those orders, so that you can prepare the appeal.
I'm good.
The present application for stay has been filed in connection with an appeal preferred by the husband against a judgment and decree dismissing the appellant's suit for divorce. Full stop. As such, comma, we do not find any scope of granting any stay, comma, since no positive direction has been passed, but the suit of the appellant has been dismissed. Full stop. Next para. However, comma, in view of the implicit urgency involved in matrimonial matters, comma, appropriate directions are required to be given for expeditious hearing of the appeal. Full stop. Accordingly, can 1 of 2024 is disposed of by directing the appellant husband to put in the due requisites, including Tolabana, written up notice form, declaration, etc. within a week from date. Full stop. The records be called for by special messenger, comma, costs of which shall be put in by the husband, by the appellant, also within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks after service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. The parties shall be at liberty to mention the appeal for enlistment as and when the same is made ready for hearing. Thank you.
I briefly apply, madam.
There is no scope of stay.
Lordship, I am for the appellant, Lordship. There is a 605 application and also an application for stay, Lordship. It is the grant of probate of a will. Petitioner's
Service has been properly effected.
Lordship.
How many respondents are there?
Respondents are 2, Lordship, and 8 appellants, Lordship. What happened in the year 2000 on HON'BLE Chandrabain executed an will. Thereafter, he died. He gave all his properties to 2 sons. They filed an application for grant of probate of will. In the proceedings, few present appellants appeared, others not appeared. The 4 appellants, they filed written statement. What happened in the year 2015? They agreed to a mutual agreement and present appellants, 8 appellants, including some legal heirs, and out of 2 plaintiffs, 1 plaintiff, they have mutated their share of the property by filing an application before the appropriate authority who is BLLRO. Thereafter, after recording of their name in the mutation proceedings, Lordship, they did not pursue, contested the suit, Lordship. Therefore, the suit was declared ex parte.
Probate suit.
Lordship. Out of 2 plaintiffs, 1 plaintiff got his share of property mutated in his name.
To 2 plaintiffs means there were 2 executors, or it was a letters of administration proceeding. Let us see the decree once.
1 executor, Lordship.
1 executor. What is this appeal again? 1 executor, then how could there be 2 plaintiffs? There could not be 2 propounders. Must have. Apart from executor, nobody else can file a probate suit.
Should kindly see judgment.
Yes. Application. Yes, there were 2 executors.
Lordship, I am.
2 executors.
I may be excused.
Executors named in the will.
Lordship.
The will has been annexed here.
No, Lordship.
Or the application for probate?
Application for probate.
Should have annexed that at least. How do you know?
Lordship, it is page.
It's not there. Anyway, sorry. So you have preferred this appeal against the grant of probate.
Lordship.
So
There-
what is, yes?
There is a delay, Lordship, for 40 days.
Which one is the condonation application?
Can 1 of 2024.
What is the reason? Explanation given?
Lordship, they have come to know regarding the ex parte order because one plot of land which is subject matter of another title suit. I have annexed that copy of that.
Yes.
I clearly to. So
They
that
disclosed about the probate there.
no, Lordship. From there we came to know that the proceedings in order is judgment is passed ex parte. Because after
That is
20
what we are saying. They disclosed about the probate there in the other suit.
No, Lordship.
They
No,
did not
what-
disclose about the probate in the
that
other
is-
suit.
No, Lordship.
Then how did you come to know of the probate in the other suit?
Lordship. One
Another suit. You came to know from another suit that probate has been passed.
Few appellants are party to the to that suit. Therefore, from them they came to know regarding this. Verbally no. not by, because one plot is also subject matter of that suit.
If probate,
Properties-
if probate has been granted, it's a judgment in rem. We generally don't pass any stay order against that. We can, at best, restrain the parties from or grant a status quo regarding the
Lordship, that will
transfer.
suffice
etc.
because their name already been mutated. They have to, even if they have got the
Since you have served, you have the affidavit of service. We are allowing the condonation application. Stay application will ask you ask you to serve a fresh copy of the application. Despite service, none appears for the respondents at the time of call. Affidavit of service filed today be kept on record. Full stop. Next para. The appellants have stated in the present application for condonation of delay bearing Can 1 of 2024 that they learnt of the probate proceeding much later.
But regarding the judgment of expertise,
in connection with a different suit, pushed up next para. Since the probate decree was granted ex parte, comma, there was no scope of the appellants knowing about the same at the relevant juncture. Pushed up. Since there is no controversy on the part of the respondents, comma, who choose not to appear at the time of hearing despite service, comma, the averments made in the application for condonation of delay should be accepted by applying the principle of non-traverse. Push up accordingly, Can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT 110 of 2024 and directing the said appeal to be registered in due course. Push up next para. Can 2 of 2024 is an application for stay of operation of the impugned judgment and decree of probate. Push up next para. Since a probate since the judgment and decree passed in a probate proceeding is in the nature of a judgment in rem, comma, we are not inclined to stay the operation of the same at this juncture at the behest of some of the parties. However, comma, in order to maintain the property which is the subject matter of the disputed will as it is, comma, we are inclined to grant an order of status quo. Accordingly, the parties shall maintain status quo as regards nature, character, and possession of the suit of the disputed property till disposal of Can 2 of 2024. The petitioners shall serve a fresh copy of the of Can 2 of 2024 on the respondents, indicating the gist of this order and file a further affidavit of service on the next returnable date. Can 2 of 2024 shall be listed next for hearing in the monthly list of January 2025.
I'm good to tell you.
Item number 37.
Yes, ma'am. 37, ma'am, I'm appearing for the appellant in this matter. Your lordship, on last occasion, ma'am, directed me to serve the injunction application. This is in respect to a matrimonial suit. Ma'am, the affidavit of service is complete, ma'am. Only one, ma'am, there is one problem in respect to that, ma'am. I have sought for a liberty to file an application for enhancement of the maintenance. That has been found, but it has not been filed. Lordship will kindly text it on the next week, ma'am, so that
What is this application for?
But this is only for injunction, ma'am, so that the husband.
Remarriage.
Yes, yes.
So you are enjoying that injunction?
Yes, yes, I'm enjoying that injunction.
So we can dispose of the injunction application then. They have received.
Yes, yes, ma'am.
He has.
Yes.
So we'll dispose of the injunction.
Yes, no, that application only I'm seeking, if your lordship gives me 2 days time, so that application may be tagged, so that I can pray for that.
There is a question of tagging. I mean, in any event, you have to mention that application. Despite service, none appears for the respondent at the time of call. Affidavit of service filed today be kept on record. Since the present appeal arises at the behest of the wife against a judgment and decree of divorce, comma, and as the appellant has made out a prima facie case, comma, since both questions of fact and law are involved in adjudication of the appeal, comma, we are inclined to make the interim order granted earlier absolute. Hence, Can 1 of 2024 is allowed, comma, thereby restraining the respondent husband from contracting any remarriage during pendency of the appeal bearing FAT 117 of 2024. No orders to cost. At this juncture, learned counsel for the appellant submits that the appellant would seek enhancement of the alimony awarded to the appellant. First up, liberty is granted to the appellant to take out appropriate application on such count and mention the same for inclusion in the list as and when the same is filed.
Grateful, man.
Thank you. If it's not.
But I appear for the appellant, my lord. Yes. But I'm up against an order, my lord, refusing interim order of injunction, my lord.
I'm for
But
the
after coming to the finding
Hmm.
that I am admittedly in possession of the suit premises and the issues raised,
Mr. Mukherjee, has it been admitted?
no, my lord, there has been an interim order passed, my lord. Lordship will find there are 3 applications before your lordship. One is the one is the main injunction
Interim order
application.
passed by us.
Passed by a coordinate bench, my lord,
coordinate bench.
which has been continuing, my lord.
Get it admitted first. No formal admission here.
My lord, then my interim order, my lord, was till 29th of November, my lord. Will then kindly consider, my lord, extending that also.
Application file comments? No, it is within time.
There has been no formal order of
Mr. Chattopadhyay, if
Yes.
there's an interim order, it's a deemed admission.
Malad, at that point of time, Malad, Lordship will kindly take, Malad, I have taken a point of the maintainability of the appeal, Malad, because Malad, this arises from a section 41 proceeding of the Presidency Small Causes Court Act. Now, Malad, against that, Malad, they could have filed a suit. Now, Malad, they have not filed that, Malad. They have contested their, Malad. After that, they
The
have
order is the order dated 26th of April 2024.
Yes, yes, yes. Justice Orijit Banerjee.
Well, the appeal arises from an order passed by the learned
My
civil
specific
court.
question is that this appeal itself is not maintainable. Well, I
I'm
have
up-
taken that point on the last, Malad, on that.
But the impugned order has been
For
passed
that
by the
reason, it
civil
was
court,
adjourned,
my
Malad. Lordship will
No,
kindly-
Mr. Chattopadhyay,
Yes,
but
ma'am.
you may have that point,
Yes, ma'am.
but the coordinate bench
Well, it was
made an observation that prima facie we are satisfied with the case of the appellant's plaintiffs and learned judge having found triable issues, etc. And we would have disposed of this appeal, but for the fact that learned advocate for respondent says that you want a few days time.
only.
So this is deemed admission. The coordinate bench is deemed to have admitted it.
The Lordship will kindly then hears out the appeal, fix a date, Malad.
We'll do that.
Yes, yes,
We'll
Malad.
do that.
That will be, Malad.
It's a deemed admission, Mr.
My lord.
Mukherjee. We'll hold that and
Since there is no formal recording, my lord, I
Malad,
profit
another-
to your lordship.
we'll observe that.
Well, another point I have taken before the division bench also, Malad, as Malad, he is taking the Malad stay of the execution. So, Malad, occupation charges may be given in respect to that, Malad. We have also, Malad, filed an affidavit to that effect, Malad. So,
What is the degree obtained by you?
Malad, I have, Malad, filed a section
No,
41.
this is against injunction.
Yes, ma'am.
Now, what has happened, Malad, section 41 proceeding was filed by me,
Acha,
Malad.
let him argue first on that. Yes. You are wanting occupation charges.
Yes, Malad, because
Was there a direction for filing opposition?
no, there was a
Then you have to
Malad,
file an opposition.
affidavit so that, Malad, I can get the value of the property so that the court can, Malad, at least ascertain what is the
Yes, yes, that has been filed by
Yes,
you.
yes, that has been filed. That has been
Has been filed or
Yes,
you are
it has
filing?
been filed. Has been filed. My copies
Sure.
has been also served.
Yes, Mr. Mukherjee, have you dealt with that?
But
Occupation
I have
charge?
also filed an affidavit, my lord, saying why I am not liable to pay occupation charges, my lord. That is also been filed by. My lord, kindly takes.
So then we have to hear the application.
Yeah, my lord, then kindly takes page 55, which are the prayers of my plaint, my lord, which has been filed before the city civil court. My lord will kindly keep in mind that the decree which has been passed by this small causes court of eviction against me.
Let us understand the scope of the appeal. What is the suit for? First, your ad interim injunction has been refused. You have challenged that in the appeal.
Yes.
So, what is the suit in connection? What is
But
what are the reliefs claimed in the
My
suit?
lord, that is at page 55, my lord. Suit for declaration, as also, my lord, I have challenged the decree which has been passed by the small causes court. My lord, the plaint case is that I am a licensee. My lord, by virtue of the bar of section 19 of the Presidency Small Causes Act, the court itself does not have jurisdiction to pass a decree in respect of an immovable property. But that is the consideration which was held by the learned coordinate bench, my lord. Because, my lord, my lord will kindly considers section 19, my lord. 19.
So, there was no scope of challenge in an appeal.
No, my lord, I have to challenge by virtue of section 42, my lord. I have to challenge it by way of a suit, my lord. And that is exactly what I have done, as your lordship will see from the prayers,
Just
my
for
lord.
the declaration also.
Yes, my lord. First declaration is that only.
Yes. So, why was the injunction refused? Ad interim refused?
But surprisingly, my lord, the court found I am in possession, but court says, my lord, there is no prima facie case that I will be dispossessed.
But you are in possession.
Admitted, the court has come to a conclusion, my lord. My lord kindly takes up the memo of appeal, or my lord kindly takes up my stay application, page 105. This is the impugned order, my lord.
You say you are a tenant.
I am a tenant, my lord.
According to you, what is the rent?
My rent is 500 rupees as I am paying as determined by the learned rent controller. My lord, two forums have adjudged my title as a tenant. The learned city civil court in a suit filed in 2001 and the learned rent controller. My lord, kindly takes up page 105, my lord. But if I may read the third paragraph. From the side of the defendant, it has been pointed out that this present suit itself is not maintainable and the decree as prayed for by the plaintiffs is not permissible by law, that the order of the learned small cause court is not binding upon the present plaintiffs. While deciding the question of rejection of plaint, my lord, their order 7 rule 11 has been rejected. This court expressed its opinion that without examining the various aspects of the matter, it would not be proper to reject the plaint. However, after thoughtful consideration of the rival pleadings as noted above, it may be stated that though the plaintiffs are admittedly in possession of the suit premises, no prima facie strong case has been made out by the plaintiffs by producing clinching material at this stage. And my lord, the execution proceedings have been started after I had filed the suit. The execution proceedings were started in 2021. This suit, my lord, is of 2019.
Was started after this order?
No, my lord, the execution proceedings were started in 2021, my lord, before this order, but after the filing of the present suit.
So you did not disclose about that execution case here?
No.
Injunction.
But I have my
in
in my
you are seeking a stay of the execution case.
in
But injunction may be broader.
Broader, my lord, because I am up
Broader.
against an order refusing injunction. But after the court has come to a finding that the issues have to be decided in trial. My lord, kindly say takes the paragraph just above that. Needless to say that several questions relating to validity and legality of the plaintiff's prayer will come up for decision at the trial. During
No,
trial,
court says
definitely.
there is no prima facie evidence to suggest that possession has been interfered with by the defendant.
But the execution proceedings are going on.
That itself is an indication. Yes, Mr. Chotta.
My case is
Dispose of the lock stock barrel here.
my case is that
Dispose of the appeal, the injunction application may be heard out.
I am on the maintainability.
But the
But Lordship wants to hear me. I am ready with that. Well, on the prima facie point is that section 41 proceeding Lordship will kindly takes. Well, I have Xerox the this YOLO tag this Precedency Small Causes Act.
We'll do this. We'll fix the appeal along with the application.
Yes.
You are ready. You can put it tomorrow also. Tomorrow is
or next week. Subject to your lordship.
Why?
Well, 10th is the date for execution.
You are ready in the matter.
Will then kindly.
Very well. Not tomorrow then. Then very well next week we'll keep the injunction application, the stay application alive. So no occupation charges now along with.
10th is the date fixed for execution. Well, before that lordship fix it. Your lordship and
10th is the day fixed.
Yes. Well, lordship fix it any date, man.
So then it has to be decided this week. 9th is risky. If you can't take up on that day.
Then kindly keeps it on Thursday, subject to your lordship's convenience.
Thursday, very well. 5th. Certain questions as to maintainability of the appeal has been raised by the respondent. Since the adjudication on such issue is relevant for the purpose of deciding the stay application as well as the appeal itself, and as all the relevant papers are substantially annexed to the pleadings before the court at this juncture, we are inclined to fix the application for hearing along with the appeal itself on December 5, 2024. Full stop. That much, yes. Keep this with you for the time being.
One instance is my interim order may continue till that date.
The interim order granted earlier shall continue till December 13, 2024 or until further order, whichever is earlier.
Great.
Thank you.
Number 39.
39, your lordship, Debolina lady is appearing for appellant. She is leg before another lordship praying for short passover.
Passover?
Lordship, I am for the respondent number 1 and 3. Eventually.
Yes. You are asking for a long passover?
No, Lordship.
You are ready in the matter?
Kindly keep it at.
You are competent and we start the matter. This for
kindly-
condonation of delay?
Yes, lordship.
Yes,
So kindly keep it at
36
2 p.m.
No, no question of that. What is the delay? What is the length of the delay?
36 days.
36 days.
Only.
Strongly opposed. Ms. Lahiri is in court, in the court premises.
No, lordship, he is in
Different court.
another lordship. Kindly keep it to.
Another court means not the high court.
Lordship, yes, lordship. Kindly keep it 2:30. He is.
No.
Kindly keep.
No. These matters cannot be kept pending. An adjournment is sought on behalf of the petitioners to save your skin. An adjournment is sought by the petitioner on behalf of the petitioners. Full stop. However, comma, such adjournment is refused in view of the short spectrum of the present application. Full stop. Next para. The present application has been filed for condonation of a delay of about 36 days in preferring the appeal. Full stop. Upon hearing learned counsel for the parties, we are of the opinion that sufficient reason has been given for the delay. Full stop. Hence, being satisfied, comma, can 1 of 2024 is allowed, thereby condoning the delay in preferring FAT 127 of 2024. Full stop. The said appeal be registered
Lordship,
in due course. In due course. Full stop. Any other application pending? We are in a spree of deciding applications. আচ্ছা প্রথমে দিয়ে দিও তন্ময় যে affidavit of service filed to be.
There is no pending any other.
So we'll direct you to we pass the necessary directions for preparation of paper books and all. That also you have objection.
No.
Your appeal.
Yes, Lordship.
The appellant shall put in the requisites including the declaration, written up notice form, Tolabana, etc. within a week from date. Full stop. The records, the trial court records be called for by special messenger at the cost of the appellants, also to be put in within a week from date. Full stop. The appellant shall prepare and file the appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you.
Lord, on the last occasion, my lord, directed to serve, Lord, I understand, Lord, my learned friend is appearing for the Lord, suit for eviction, Lord, decreed. Lord, now only pending for occupational charge to be fixed, Lord, thereafter usual orders.
You have used an
589.
affidavit in opposition.
No, my lord.
File it. Disclose whatever.
Yes.
How soon?
Fortnight.
This is appearing for the no.
Yes,
We have
yes,
already
second.
granted
Yes,
a stay
yes.
till disposal of the application.
No, Lord, your lordship has granted stay, Lord, till the next hearing.
Yes, till disposal.
Till disposal.
On the prayer of the learned advocate for the respondent, the time for filing affidavit in opposition is there was no previous direction. Oh, sorry. এটা কেটে দাও.
Service fees.
Learned counsel appearing for the respondent submits that the respondent is entitled to occupation charges and wants to use an affidavit in opposition. Full stop. Accordingly, the respondent is directed to file his affidavit in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing in the monthly list of January 2025. Please come back. Thank you. Affidavit of service filed today যদি না বলে থাকে দিয়ে.
Read.
Your Lordship, I am for the appellant petitioner, Your Lordship. As per the last occasion, Your Lordship, leave was granted to file a supplementary affidavits on behalf of the appellant, Your Lordship. I pray for at least a 1 week time, Your Lordship, to
Why?
file. Your Lordship, I am led by Mr. Devanshu Dinda. As
We
per
gave you that permission 1 month back. Why haven't you prepared till now?
Your Lordship,
Without eviction of a trespasser.
I
That's the whole.
I apologize. I apologize, Your
No,
Lordship.
you may we accept your apology. But what is the reason?
Your Lordship, the means I'm just instructed by my senior.
What was the occasion for filing supplementary affidavit? Why did they want?
Milord, they prayed that some of the documents are not annexed in the Milord application for stay. That's why. There are 2 applications for stay.
So stay is till December 15th.
Stay is till December 15th.
Will not extend it because let them do it. Then we won't give you 1 week. Sorry, because they have to file an opposition and you have to file a reply after that. We'll give you 2 days time to file that supplementary.
Yes, Your Lordship.
Not if I directed composite affidavit.
Yes, otherwise you cannot do it if they don't do it within. When the matter is called on for hearing, an adjournment is sought on behalf of the appellant stroke petitioner. Push up the time for filing supplementary affidavit is sought to be extended. Push up next para. We find from our order dated November 4, 2024 that we had granted leave to the appellant to file supplementary affidavit and accordingly had directed affidavits in opposition and reply to be filed. Push up. However, the prayer now for extension of the time to file supplementary affidavit would disrupt the entire schedule of affidavits. Push up. However, keeping in view the ends of justice, the time for filing supplementary affidavit is extended for 2 days and shall positively be affirmed by December 4, 2024, and a copy thereof shall be given to the learned advocate for the respondent by that time. Push up. The other directions regarding affidavits remain the same. Push up. The matter shall next be listed on December 12, 2024.
Item number 42.
Yes, Lord. Yes.
For the appellant, Milord.
Right. What is
This
the matter?
appellant rejected, Milord, against the impugned order dated 4th July 2024,
This is
passed
appearing for the first time.
Yes, Milord. Yes, Milord. It is good.
No copy is with me, Your Lordship.
Yes,
I have filed caveat.
Yes, I shall giving. I am just telling the matter is so much. I shall serve. Our Lordship will direct. I shall serve.
Our Lordships.
We shall. Yes, our Lordships. That I am going to say, Milord.
Plural, yes.
Milord, divorce was obtained in the 4th July 24.
Very
If
good.
your Lordship kindly peruses petition for divorce, verification was made on June 2016. Marriage took place in the year 2017. Your Lordship knows everything. Your Lord read everything.
Sort of premonition.
Yes, Milord.
Prophetic.
Yes. And besides that, Milord, cause of action arose
So
on the same date of the marriage.
Divorce petition was drafted before the marriage.
Yes, Milord. 16. You kindly see page number 13 of the application for appropriate order. I think your Lordship has read it.
We'll treat the marriage retrospective and grant divorce. So
As your
divorce has been
Lordship directs, that will I shall comply with it.
So divorce has been granted.
Granted, Milord. And we are filing the appeal.
So what is the application for appropriate order means?
Yes, Milord. Can one? Yes.
You have asked for dismissal of judgment and decree. What does that mean?
Milord, decree of the divorce, we shall want because it cannot sustain, Milord. If your Lordship reason for that consummation, non-consummation of marriage.
Here the appeal on marriage.
Yes, grateful to your Lordship. What had to be done, we must suggest.
No, divorce has been granted.
Granted.
You have not asked for injunction. They'll remarry, then it will become infractual.
Milord, I got the last date of deed of decree of divorce. That
What will she do? Please don't call your client. She is not an exhibiting.
It's just I have taught him.
Why should you see the client? Why should we see the client?
I am seeking forgiveness.
What is the reason for producing the
No, no,
your
no, I am
client?
seeking forgiveness for that, my lord. Previously I used
Their
to.
privacy need not be disrupted for
Yes,
this.
yes, get full to
You are the advocate. You are representing her.
Grateful.
So you argue your matter. Yes.
Yes, your lordship must called me so that I can.
No, but you have not asked for injunction. So they let them remarry then. Although they don't now they have notice.
No, my lord, I shall.
Anyway, give a copy of this application.
Yes, get full to lordship. Get full.
But this is we'll dispose of this application by directive to putting the requisites and all. So prepare paper books and all. Will
I am serving the copy first of all, as your lordship rejected.
Service. I mean, this is we'll dispose of this application. No order. You have asked in this application. Your prayer is for dismissal of the judgment and degree, which does not mean anything. If you ask for praying, setting aside of the judgment and degree, that's subject matter of the appeal itself.
Actually,
so we cannot allow this application at this point of time.
No. As your lordship rejects, I
will
shall
dismiss your application, but will direct you to put in the requisites and file paper books within a limited.
No, as your lordship
and you will also put in the special messenger cost.
Set aside that lordship. I shall comply with it. Set aside of the decree and of divorce, Lord. Just your lordship has understand.
Set aside.
Just your lordship has rectified me.
We'll set aside your application.
No. Set aside the application. Application, yes.
We'll dismiss this application of yours. This does not carry any meaning to us. If we allow this application, then the appeal will be allowed. It will the appeal will stand allowed. You have asked for setting aside the judgment and degree. We have to hear the appeal on merits.
Yes, get full to lordship.
So for that, what do you have to do? You are the appellant.
Yes, I have to serve the copy of the opposite parties, my lord. Of the copy
you
of
will
the
have to put in the requisites, written up notice form, declaration, Tolobana, etc. and put in the special messenger cost for bringing the lower court records. So that the appeal is expeditiously heard. And then you'll have to prepare paper books.
Get full to lordship.
We'll direct pass those directions immediately.
Get full to lordship.
But give a copy to her. Give it right now.
Today I am giving it. It is just need. ঠিক মতো লাগলো আমার লর্ডশিপ আমাকে এত বকবেন যে আমি এক্ষুনি দিয়ে দিচ্ছি কপি এক্ষুনি কপি দিয়ে দিচ্ছি লর্ড
So take care of that.
Yes, Lord.
You are not giving a copy. We are not saying you give a copy.
Xerox is not ready, lordship.
Xerox টা করে দিয়ে দিচ্ছি
Office copy only, one copy is there.
I was called in by that person also, and
which person?
I am not. I mean, that person, and I am gradually improving my. I am
which person? I don't understand.
Yes, I am not. I was his junior.
Who's junior?
That Alipur court, Lord. Yes, I am
my
not.
father's junior.
Yes, Lord.
You are my father's junior.
At the first time,
sir, withstood you for so long.
No, I am not.
Impossible.
I have deviated, my lord. I am criminal practitioner.
I don't believe that.
Yes, Lord.
You may have worked in some matter with my father in Alipur court.
But
you could not have been a regular junior of my father. I know all my father's juniors.
If I make any extra talk, must forgive me.
And then I should impose cost. If you are junior of my father and still you have filed this application, exemplary cost should be imposed on you.
No, Lord, that is
absolutely. What sort of an application is this?
Yes.
What sort of an application is this, sir?
Application for appropriate the application at all not sustained. Yes. Then I am not pressing it, my lord.
This application makes this application makes a peculiar prayer. Full stop. The appellant stroke petitioner seeks within double inverted setting aside within double inverted dismissal of the judgment and decree double inverted clause impugned herein. Full stop. Next para. Apparently, the appellant has sought for setting aside the impugned judgment and degree. Full stop. If the application is allowed, comma, the same would tantamount to allowing the appeal itself without hearing it, which is an absurd proposition. Full stop. Accordingly, Can 1 of 2024 is dismissed without any order as to cost. Full stop. However, a copy of the application shall be served during the course of the day by the learned advocate for the appellant to his counterpart appearing for the respondent. Full stop. Next para. The appellant shall put in the requisites, comma, declaration, written up notice form, etc. within a week from date. Full stop. The trial court record shall be brought by special messenger as at the cost of the appellant, which shall also be put in within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. The appellant shall also put in the deficit court fee of rupees 70,
My lord, it has been, as per instructions, it has been given, my lord.
comma,
70 rupees, yes.
if not already
Yes, yes,
deposited, comma, if not already deposited, comma, also within a week from date. Post of liberty to mention the appeal for inclusion in the list as and when ready for here. Give a copy to her.
I shall be within two. I shall tell after signing the copy, my lord, I come again. With permission. So,
Appeal number 43.
Not on the last occasion, your lordship directed me to serve the copy of the application being can 2. My lord, can 1 also, my lord, regarding my lord, can 1 is my lord order 41. Yes, your lordship already noticed.
We have already
the can-
directed it to be listed for hearing along with the
matter. But
the
your
usual
lordship
order.
kept my lord, this can 2 because there your lordship has passed an interim order, my lord, wherein the subsequent suit, my lord, this is a suit, my lord, filed by my client being the husband under section 9 of the Hindu Marriage Act, seeking for my lord restitution. My lord, that has been dismissed, holding in 2 of the grounds that the reason is, my lord, that I have not take care of medical treatment of my lord, wife. That is one of the ground of which, my lord, this has been, my lord, perpetrated that some cruel action on my part, which, my lord, prompted the learned judge, my lord, to dismiss, my lord, this, which is under appeal, my lord, challenge is before your lordship. Now, my lord, the subsequent suit, my lord, much after, my lord, after 4 years, the initiated by the wife on the ground of, my lord, cruelty, my lord, if that should be proceeded, which is, my lord, now at the evidence stage, then, my lord, this, my lord, ultimately, if this judgment which holds, then, my lord, this judgment will be exhibited and this will be my lord, a formality, mere formality. That's why your lordship
Restitution of conjugal rights was dismissed. The suit was dismissed.
which is under challenge, my lord, before your lordship in this appeal.
He is bearing stay that suit. How it is possible, my lord?
Yes, but Mr. Banerjee, that suit is decided before this suit. That suit was filed subsequently. The substantial issues involved are the same. Although in divorce suit you have to prove more than his suit for restitution.
My lord, actually, my lord, different suits have been filed against my client, my lord. Your lordship kindly
No, let us focus on this particularly, because now they are seeking a stay of your divorce suit.
My lord, he filed an application against my client, money suit, my lord. That has been dismissed.
Money suit, we are not interested in money
suit. My lord, maintenance application, they have not paid any amount. They have to, my lord, mat suit, my lord, dismissed. Divorce matter is dismissed. Only custody matter is pending, and that divorce matter is only.
No, Mr. Banerjee, the principle of section 10, why should it not apply? We are telling you, you will answer that. Because section 9, your divorce suit was filed during pendency of the section 9 application.
Yes, much after, my lord, 4 years after.
Yes.
2018,
when his section 9 application was pending, restitution suit was pending, you had filed the divorce suit at that point of time. Now, during pendency of this, subsequent to that. Now, subsequently, it has been dismissed. It's a continuation of that suit. Now, if your divorce suit is now decreed, what remains in this appeal? I mean, there is no scope, then there would not be any scope. Suppose your divorce suit is decreed today. As of today, it's decreed. Then there is no scope of interference in the appeal. Unless they file an appeal, of course, against that, and that is allowed, and that's a different chapter. But as of today, why shouldn't we? If he wins the restitution suit, then there is no scope of granting divorce to you. This was a prior suit. That is why only. If his suit was subsequent, then you are right. Then you are right. Your divorce suit ought to have been heard earlier. But why shouldn't the principle of section 10 CPC apply? Why shouldn't it apply? You satisfy us on that?
Tomorrow, my lord.
Why tomorrow? That is the only ground involved here. Mr. Mukherjee, if there are other grounds of divorce, because divorce is not restricted to
try
this
to
issue.
impress your lordship, kindly see, my lord, page 7 of the judgment, my lord, the memorandum of appeal. I am, my lord, only on this part. Had it been a case, the other, my lord, aspect has been gone into here. The learned judge, while deciding the suit, has come to a conclusion that I have not take care.
So we'll complete them, then come back to you. Yes, what did they say?
Look,
What
page
did he say?
7.
7.
The second paragraph starts with, it is the specific case of the respondent that the petitioner never provided medical treatment to her at the time of her illness. She accordingly deposed in as OPW1. This allegation is fully corroborated by the mother such and such examined as OPW2. The petitioner produced certain medical papers regarding the seizure disorder, Exhibit D collectively, and this is proved the evidence of the doctor examined as OPW3. The respondent also produced the OPD tickets, Exhibit C. If the allegation of incident of 27th of February 2018 is not committed by the petitioner, then also what prevented him to provide medical treatment to her for her injuries? Conversely, not a single scrap of paper has been come to the side of the petitioner that he ever borne the expenses of him, giving medical care, attention and treatment to the respondent wife. Pausing here for a moment, Lord. I have pleaded, but I could not, Lord.
Order 27
that
is
is
for
the
that.
doc.
Yes.
So if this, Lord, observation remains on board, a matter decided conclusively between the parties, this will be a tool, Lord, or evidence, Lord, which will be relied upon, and by the piece of this evidence, Lord, automatically the suit filed by the wife, that will be decreed. Because ultimately, Lord, on contested hearing, this has been proved as of now that yes, I have not, Lord, taken care of the, Lord, medical treatment of my, Lord, wife, and that is one of the, Lord, ground which can prove, Lord, the cruelty.
Also, you did not prove any.
That is also, Lord, there. Lord, I approached the concerned Pradhan, and the Pradhan also arranged for a meeting for, Lord, mitigating.
Those are also part of
Yes. I have pleaded in my
anyway, those will be decided later.
That's why, Lord, that's I am invited on the first day itself. So if this, Lord, observation remains, then that suit will automatically decay. That's why, Lord, I pray, Lord, that the subsequent suit initiated by the wife 4 years after, Lord, institution of my suit, that will remain state, and your Lordship directs me, Lord, I shall immediately prepare the, Lord, the paper book and other formalities.
How soon can you prepare the paper?
Lord, 4 weeks. And LCR, Lord, it's from, Lord, Hooghly. It will not take, Lord, much time, Lord. By this week, I can, Lord, put in entirety the requisite and all that.
Mr. Baji, what do you say? Yes. Yes, you make your arguments.
498 application is also pending, madam. Entire paper is lying with my client, my lord. His client, my lord.
What paper?
That is, my lord.
What
Aadhaar
paper is
card,
lying with this?
that is Aadhaar card.
Your papers, your personal documents.
All, MRI.
Your personal documents.
Yes, all are lying with him, my lord.
Yes, but how?
MRI
What
report, all
does
the
that
MRI
have to do with this matter? Now we are hearing the stay. You address on that first.
We think, you file paper, in meantime,
You will file paper book.
he will file paper.
4 weeks, you said. No, 2 weeks, you say. 4 weeks, you said. Let us do that. Yes, but this stay will continue. Heard learned counsel for the parties. Direct the paper books we prepared earlier. Otherwise, if the divorce is granted, nothing remains.
My client never.
Obviously, divorce will be decreed. The present application arises out of an appeal preferred by the plaintiff husband in a suit for restitution of conjugal rights against an order dismissing the suit for restitution of conjugal rights. Full stop, next para. Learned counsel for the petitioner contends that the respondent wife, 4 years subsequent to the initiation of the divorce suit, filed a suit of her own for divorce, which is still pending. Full stop, unless the said suit is stayed, there would be virtually an automatic decree therein, in view of the observations made in the judgment and decree impugned in the present appeal. Full stop, next para. It is further contended that the principle of section 10 of the Code of Civil Procedure is applicable, inasmuch as the divorce suit was filed subsequent to the institution of the restitution of conjugal rights suit, and the issues involved therein are substantially the same. Full stop, next para. Such contentions are controverted by learned counsel for the respondent wife. Full stop, we find that the issues involved in the restitution of conjugal rights suit are virtually a mirror image of those involved in the divorce suit. Full stop. In the event the subsequently instituted suit for divorce is not stayed, the there will be nothing remaining to adjudicate in the present appeal, comma, since there would not be any scope of grant of restitution of conjugal rights, even if the appellant ultimately succeeds in the present appeal, if in the interregnum a divorce decree is passed. Full stop. Next para. As such, comma, we are inclined to grant stay. We are inclined to make the interim order of stay passed herein absolute till disposal of the appeal. Full stop. However, comma, in view of the urgency involved in the matrimonial proceeding, comma, the appellant should be directed to expeditiously prepare paper books and take other steps to ensure that the appeal is heard at the earliest. Full stop. Accordingly, can 2 of 2024 is allowed, comma, thereby granting stay of all further proceedings. Very well. The grant of stay of all further proceedings in matrimonial suit number 43 of 2022 pending before the learned additional district judge, second within bracket fast track bracket close court at Kalna, comma, district Purbo Bardhaman till March 31, 2024 or until further order, whichever is earlier. Full stop. Next para. The parties will be at liberty to seek extension of the interim of the order passed herein in the event the appeal is not disposed of before March 31, 2024, 2025, sorry, again to 2025, March 31, 2025, full stop. Next para. The appellant shall put in the due requisites, including Tolobana, written up notice form, declaration, etc., within a week from date, as well as put in special messenger costs within a week to ensure that the trial court records be brought by special messenger at the cost of the appellant. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment for the purpose of hearing, and as and when the same is made ready for hearing.
But since Mr. Banerjee appeared,
Service of notice on the respondent is dispensed with in view of appearance through counsel.
So,
from 2018 just from
up to 31st March.
Maintenance টা দিতে বল।
This will be
was it not
Oh,
requisite
Talabana
because
Talabana কথাটা যেখানে বলেছেন ওটা বাদ দিয়ে দেন। Except the Talabana, the rest of it.
Fine. Great.
Yes.
Well, what happened, well, actually, well, my client is detached from her husband, my lord, from 2018.
Submitting yourself if it's possible
I
to
shall.
part ways, then do that.
Then your
What is the use of keeping them bound together?
Your lordship is keeping alive, my lord, this can too.
Can to have disposed of,
Because
but you have granted
extension,
stay.
That's why, my lord.
You'll have to file another application. This is to ensure that you, as Mr.
No, my lord,
Banerjee said,
What happened, my lord?
it is done.
No amount paid.
You have not applied for maintenance.
Already applied for my lower court, my lord, already passed an order. That has not.
আচ্ছা, we'll make something clear. The hearing of the divorce suit state, যেখানে বললাম না, একটা লাস্টে অ্যাড করে। It is, however, made clear that the stay of the divorce suit granted above shall not operate in respect of interlocutory applications. Full stop. Only the final hearing of the divorce suit shall remain stayed till March 31, 2025, and it will be open to the court taking up the divorce suit to decide all interlocutory applications, comma, if filed in the meantime, comma, in connection with the said suit.
Grateful.
So everything remains, you can
Fine,
execute
fine.
your
Great.
maintenance and everything. Yes, next.
My lord, I am for the appellant, my affidavit of service.
That I am appearing for the respondent number 325.
All have been served, all the respondents?
Yes, my lord.
Yeah.
My lord, 325 is appearing. One has been served, but unfortunately he has come to me only, so I have released. So.
Oh.
And rest of them have served. We have the receipts are there. My lord, the section, this application relates to condonation of delay.
What is the appeal about? Probate?
Probate, my lord.
Probate was granted?
No, rejected because though it was a registered will, original will got misplaced and could not be produced at the time before the trial court. Apart from that, no attesting witness were produced.
You produced a certified copy of the registered will?
Before the trial court, we have produced the certified copy, but since no attesting witness was there before the trial court and original will was not there, so the probate was not granted, rejected rather.
Obviously.
Now at this stage, in the month of June, while cleaning the house, the respondent number 1 has
found original.
Found the original. We want to deposit that and get the.
And the other attesting witnesses you have also found?
But the attesting witness we are not sure about, but original will we have found.
My lord, so far as his entire case based on, my lord,
obviously,
that the will has been kept with the opposite party number 1. And my lord,
So you found it from their belongings or your belongings?
Their belongings.
Your belongings, not their
No,
belongings.
no, it is from opposite number, party number 1, it has been found.
Oh, it has been recovered from them?
Them only.
You went to their house and searched?
No, no, no. After they have recovered, actually these are own brothers. So they reside in the same premises, and it was informed that we have found that.
They are cooperating with you?
Only opposite party number 1. Opposite
my
number
lord, the
2
opposite party 1 contested in the case court below.
Mr. Mithu, you have got your fees. You already got your fees. There is a chance that you won't be getting. Is there a chance of no settlement probate matter we have to set aside? So we are. What is the delay?
Delay is 401 days.
What is the reason for the delay? So much.
That was just because they didn't prefer any appeal because the original deed they couldn't find out. Now, since they have found out in June, middle of June 2024, they have preferred this appeal.
Respondent 1 also contested. He also denied his submissions that the will has been kept with me. And my lord, he also denied that
there is no order for Rule 27 application. You have to seek to produce that will, original will.
Lord, liberty may be granted.
What do you say to the Section 5 application, Mr. Mitro?
So far as the entire foundation is, my lord, now here he is making an application that delay has been caused in view of the will could not be traced. And my lord, he could have filed appeal earlier, although his case is that he could not file the will in time before the court.
Mr. Mitra, the difficulty is since this is a will, we are more, inclined to give him an opportunity. That is, we are being very frank. If it was if it was an in-person sort of litigation, then we would have our doubts. You would be right. But since it is the expression of the will of a deceased person, if the will is correct, genuine, is the expression of interest of the will of a deceased person. That's why we are a bit more circumspect.
My lord, apart from that, the respondent number 3 and 4 has filed another partition suit also subsequently.
That's different. So what?
In connection with this property.
Therefore, they are denying the will.
Yes.
Obviously, they're denying. They're asserting title on the basis of inheritance. But can this be a good ground? Because the delay in preferring an appeal we can appreciate. Then whenever you can, when you'll get the, they have to be at your mercy. If you get it after 20 years, say, then at that point of time you come up with an appeal. That was the only ground that you could
That
not
was
produce
the
a will.
only- That is the only ground.
And that too, my lord.
Petitioner was also 88 years old. He's a old and
Petitioner is 88 years old.
yes.
Sir, otherwise he can always take out a review application of that judgment also.
He can.
Discovery of new material, he can do that. So instead of, we want to preempt that, let it be over here. The present appeal has been preferred against a judgment and decree dismissing the petitioner's application stroke suit for probate. First up, the petitioner could not produce the original will and or prove the same, which was primarily the ground for such dismissal. First up, in the present application for condonation of delay, it has been stated that subsequently the original registered last will and testament of the testator Sri Kanailal Khan, bracket is since deceased, bracket close, has been discovered, prompting the present appeal to be filed. Which of next para, learned counsel for the respondent opposes the said prayer and contends that that after the suit itself was dismissed for non-production of the will and the petitioner having taken a stand before the trial court that the will was not lying with him, the ground taken in the application for condonation of delay ought not to be accepted. Full-stop. Next para. However, from paragraph number 6 of the present application, we find that the appellant stroke petitioner has taken a stand that in the middle of the month of June 2024, while cleaning his house, the original registered last will and testament was discovered by the respondent number 1 from his house, and as such it has become necessary for the parties to produce the said original will. Next para, although the respondent number 1 contested the grant of probate in the court below, since the appellant seeks to produce the will at this juncture, no useful purpose would be served in relegating the petitioner to a further application for review on the ground of discovery of the will at a subsequent stage. As such, we accept the grounds for delay as stated in the application, and accordingly can 1 of 2024 is allowed, thereby condoning the delay in preferring the appeal. The appeal be registered duly. But you have to bring on record that will.
Yes,
We are not advising you, but you have to do whatever is necessary. The appellant shall put in the due requisites, including declaration and written up notice form within a week from date. Service of notice of appeal on the respondent is dispensed. Oh, you are for all the respondents.
3 to 5.
Respondent numbers 3 to 5 is dispensed with. However, Talabana shall be put in for service of notice on the other respondents. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing as and when the same is ready. Mr. Mitra, if there is any scope of settlement, he's 88 years old. So please, you have to take the initiative.
I'll talk.
Because respondent number 1, if he is with you, it can be resolved.
My lord, with respondent number 3, 4, who are the sons and daughters of the sisters,
they will be opposing.
They are not agreeable.
Determination to hear this matter.
What is this?
My lord, it's a affirmative, my lord.
Not admitted yet.
No.
Since we do not have determination to take up admission hearing of appeals after the year 2020, comma, let the matter be released from our list on the ground of lack of determination, with liberty to the parties to mention for inclusion before the appropriate bench having determination. তুমি এখনো careful হচ্ছ না।
Lord 46, in view of the Mallard's previous direction, Lord, I sent the Lord service upon the opposite respondent, but according to postal authorities report, Lord, the incorrect address, but I sent it at the correct address as per the decree. Now, Lord, let me give a chance to serve upon the learned advocate who is appearing in court below.
The affidavit of service filed today be kept on record. First of, although the petitioner served a copy of the application on the respondent at her address as appearing in the impugned decree, comma, proper service could not be effected. Full stop. Next para. Hence, comma, in order to ensure proper service, comma, the petitioner is directed to serve a copy of the application on the learned advocate appearing for the respondent. This is against the preliminary degree. Appearing for the respondent in the trial court, indicating that the application shall be listed for hearing in the monthly list of January 2025 and file an affidavit of service on the next date of hearing. Serve along with a server copy also, otherwise the advocate won't accept.
Great.
Number 47.
And senior advocate Mr. Vinay Mishra not come to court, not today.
Yes, sir?
Vinay Mishra.
He has not been designated. Since when did he become a senior advocate? He said Binoy Mishra. He is not a senior advocate. Do you know the meaning of a senior advocate? He may be your senior. Senior advocate is something else. It's provided in the Advocates Act. You should go through the Advocates Act. Binoy Mishra has not come to court, so what can we do? You are there. Yes, what is the matter?
Section 5 is there.
How much
The
delay?
partitions, 114 days delay.
What is the reason?
Well, reason is that before the landed court below, there is a usual practice in the Jhargram court that final degree has been passed. Immediately thereafter, my lord, the clerk went for filing the application for obtaining the certified copy of the order. Their practice is that unless the main file is come, they will not accept the application for obtaining the certified copy. By this way, my lord, they reject it. And immediately after receiving this,
He will be embarrassed. Let us take it up tomorrow.
tomorrow.
He will come tomorrow. On the prayer of the respondent, the matter is adjourned for the day.
তোমার নাম দাদা?
Item number 48.
48, I am sorry.
Yes,
Appellate
sorry.
petition. Well, as per previous direction, I have served all the respondents. However, the respondent number 1 also came here or contested the earlier occasion. And
Take the microphone a bit closer to you.
I
Yes.
was directed to raise the respondent to serve the copy of application. I was done so. But kindly see the
On the other respondents.
other respondent.
Yes, because you also appeared on the last occasion. Yes.
Yes. But
So what
my
about
lord,
that? Service has been affected.
Service was affected, excluding respondent number 9.
What about him?
Respondent number, my lord, the track report, my lord, I was annexed. There was no intimation what the article was written, but original postal was returned to me with report deceased.
Deceased.
Yes.
Then you have to
Subsequently.
substitute. Yes.
Subsequent. Well, the text, I will be text.
Pardon?
I'm appellate to give liberty to take steps, my lord, on the death of the.
But if he died before the injunction order, then this is a void order.
I come to know subsequently, my lord, when the service was effective.
Even if you come to know later, order in the name of a deceased person, we don't know. Anyway, ascertain the date of death and
Yes.
is yours.
Yes, I will. I will.
Yes, hand it over, please.
Yes.
Milord,
Yes,
in the meantime, may I pray for a respite, Milord? On the last occasion, your lordship passed an order of injunction, Milord,
Yes.
not to change the nature and character, along with not to part with possession to third party. Milord, I was praying for respite only on this court, Milord. May I construct, Milord, subject to the fate of this final adjudication in the
Construction we
appeal,
cannot
Milord.
permit you.
Milord, from 2015, Milord, I have got, Milord, it converted to Bastu. Subsequently, I got Milord, plan sanctioned, Milord. Subject to, Milord, the fate
No,
of
my
the
lord,
appeal,
their
Milord.
application already trial court rejected during pendency of
Then
the
you will have to file a proper application. I mean,
Very well,
or
Milord.
did we direct you to file opposition in this?
No,
Injunction?
Milord, no.
We are directing you to do that.
Very well, Milord.
In your opposition, you disclose everything.
Because, Milord, only one thing, Milord, I'll take 2 minutes time of your lordship, Milord. Only I'll indicate page 12 of the, Milord, judgment, Milord. Page 12 of the judgment. That is the, Milord, cross-examination of the plaintiff's witness, Milord.
Yes.
Milord, the last paragraph, Milord. Page 12 of the judgment, Milord.
Page 12 of the
judgment, Milord.
Right. Yes, we are there.
Last paragraph, Milord.
Last paragraph.
Starts with, Milord, at the time of cross-examination of PW1,
Yes.
it appears that he has specifically admitted that the predecessor of the plaintiffs, Mokshuda Dasi, had not challenged the RS ROR of 1954-57 during her lifetime. Milord, here, Milord, pausing here, Milord, I'll just Milord, indicate one thing, Milord. The entire episode is, Milord, 1058 dag was trifurcated, Milord, into other Bata dags. I purchased from one of the, Milord, because 3 brothers were there, plaintiffs 1, 2, and defendant number 10. I purchased from defendant number 10. They got this property from their, Milord, paternal, Milord, grandmother, Milord, 8 decimals each, 24 decimals. Milord, their case was, Milord, it was from the original dag. My case is from the Bata dag. Milord. Further, it has also been admitted by him during his cross-examination that he had not made any prayer before the settlement authority to modify the map of the original plot number 1058 after the said plot had been subdivided into 3 plots, being 1058, 1058 by 1768 and 1058 by 1769 respectively. Further, it has also been admitted by the said witness that the plaintiffs had made an application before the concerned BL and LRO for correction of the record of rights, but the said application has been rejected by the concerned authority and that subsequently the plaintiffs had not taken any step against such order of rejection. Further, it also appears on going through the evidence of PW1 that he has specifically admitted that the plaintiffs along with the defendant number 10 had acquired 24 decimals of land belonging to Mukhoda Dashi as recorded in plot number 1058/1768 of the RS ROR. The aforesaid fact has also been admitted by PW2. So, Milord, this is the main plank on which, Milord, they had been, Milord, harping upon the entire, and on that, Milord, I had been suffering, Milord, that injunction order, Milord, in the court below, Milord. Now here, Milord, it had been, Milord, admitted. In nutshell, may I place before?
No, but we'll decide the injunction application, then we'll hear all of this.
Very
At
well,
this
Milord.
stage, we cannot.
Very well,
Premature.
Very well.
At least file your opposition and disclose why you want to make a repair.
Yes, yes, yes.
Your plan may expire. We won't supply you with reasons, but there can be several reasons.
I'm grateful.
So do that.
My lord.
And regarding this respondent number 9, you have to take steps.
Yes,
You're appealing for respondent number 9.
I'm for the state respondent.
Pro forma respondent.
Pro forma
Why
respondent.
state correction of records of rights? Consequential correction of records.
Yes.
The RSROR correction.
That trifurcation of RS ROR, Milord, that is the
Consequential
reason,
relief
Milord.
might be
Yes.
there. Very well.
Consequential.
Affidavit of service filed to be kept on record
14
along with
and
an
15.
envelope which indicates that the respondent number 9, comma, who was sought to be served is since deceased. Full next para, learned counsel for the appellant seeks to take steps in that regard. Accordingly, leave is granted to the appellants to take immediate steps for substitution of the heirs and legal representatives of the deceased respondent number 9 upon ascertaining the date of such demise. Next para, unless it is specifically known by the court that the demise happened prior to November 20, 2024, comma, when the interim order was passed in connection with Can 1 of 2024, comma, no order regarding the validity of the said no observation regarding the validity of the said order can be made at this stage. Full stop, next para, be that as it may, comma, the respondents, the surviving respondents shall file their affidavits in opposition within 3 weeks from date. Full stop, reply, if any, shall be filed by January 3, 2025. Full stop, the application shall be listed on January 7, 2025. Full stop. Further liberty is given to the appellants to mention for inclusion in the list and to be tagged with the main file the proposed application for substitution, comma, if filed in the meantime.
I'm grateful, Your Lordship.
You are the pro forma respondent.
My lord, I am the pro forma respondent.
So
Respondent
direct
number
only the
14 and
respondents
15.
to file.
Yes, my lord.
Mother 49, mother, I pay for the appellant, mother. Mother, on the last occasion, your lordship was pleased to direct us to serve, mother. Mother, we have served, mother. Mother, the plaintiff respondents have possibly not received, mother. Because
You are the defendants.
I am one of the defendants.
So they have to be served.
My lord.
Not yet received means what is the endorsement there?
My lord, it is item bagged, my lord.
Not yet served.
Not yet received, my lord.
So you'll postpone the application.
My lord, kindly keeps it next Monday, my lord, possibly within that time, my lord.
Learned counsel for the appellant stroke petitioner submits that the respondents have not yet been served, although copies have been dispatched some time back. Full stop. Accordingly, let the matter stand adjourned till December 9, 2024.
Much obliged, my lord. Well, in the in the meantime, may I be permitted to serve upon the advocate appearing in the court below, my lord, because a preliminary decree in the partition suit, my lord.
Let us see the outcome of this service. Then we'll, because you're already enjoying a whatever order we are to pass, we have already passed. Yes, Mr. Rautia, for the respondent.
No,
Litigation. Oh, sorry.
No, yes. What is the matter? Appearing for the first time?
My affirmative, my lord, it has to be admitted first.
Then it goes to Justice Sandon.
No, my lord. City civil matter.
Oh, city civil code.
Your lordship has to determine it.
Yes.
My lord.
Oh, yes.
My lord, the instant appeal has been preferred against the ex parte ad interim order of injunction.
Granted.
Granted.
What is the suit for? What is the suit
My
for?
suit for declaration that being the absolute owner of the divided and demarcated plot of land, the plaintiff has got absolute right to use and enjoy the property without interference from any court. And my client, the defendant, has no manner of right to create any disturbance and not to oust the plaintiff from his lawful position. Well, your lordship kindly have a look at the cost title. I am the widow lady, 75 years old. I don't have any the means to evict him, ousting him from his lawful position. What happened in this case?
No, you are which appellant?
Appellant is my lord.
Widow lady, which one is the widow lady? Number one.
Number one, Oja.
2 and 3 are
married daughter. Married daughter.
All are married daughters.
My lord. Married daughter.
And he is the son. The plaintiff is the son.
No. Plaintiff is my lord, the brother of his husband.
Acha. Your uncle. And your
my clients.
Very
well.
So let us see what is the fault in the order.
Order in the fault in the sense, your lordship kindly allow me to take 2 minutes of your lordship.
Yes, absolutely.
My lord, a joint property was purchased by two brothers, having their 3 feet and 2 feet share. My client entitled to 2 feet, and the respondent with your lordship 3 feet.
Your client's predecessor.
My lord, predecessor. Sorry, man. My lord, partition suit was filed by the respondent with your lordship. During the pendency of the partition suit, my client's predecessor engaged a lawyer to represent him before the trial court. But that lawyer died immediately after the interest. My client fell seriously ill. He was totally bedridden. So, without contest, the preliminary degree was passed. But, so far the declaration of my right title interest, there is no defect. Perfectly okay.
255th yours. Yeah.
Thereafter, my lord.
You were implemented in the meantime.
My lord. After passing of the preliminary degree, my client died. My predecessor of my client died.
Oh, he died after.
Up to final degree, passing of the final degree stage, nobody represented him. Only in presence
Not
of
substituted.
Substituted.
substituted, my lord, at the time of holding commission by the Partition Commissioner.
Before that, you were not
No,
substituted.
no. My lord, Partition Commissioner on receipt of the copy of the notice of Partition Commission, we participated with my lawyer, one of the daughters. My lord, in presence of both sides, partition suit was, my lord, the allotment was made, lot A was allotted to the respondent and lot B to my client. My lord, thereafter, my lord, upon considering the allotment of both the parties, a meager amount, so far my allotment is concerned, allotment B. That particular allotment was devoid of any amenities. No filter, supply of filter water, no privy, bath and kitchen.
All the appellants were jointly allotted that portion.
My lord,
Then,
but in that view of the matter,
you have been residing where?
in a portion of that house.
Acha, very well.
It's a joint property. My lord, considering that aspect, a sum of rupees only 25 was allotted. Was allotted
25,000.
OLT money.
Said 25. Yes.
Only 25,000. OLT money for the purpose of making construction, bath, privy, kitchen, and water, installation of filter water. However, my lord, with the with such meager amount,
challenge that final degree.
No, my lord, the helpless lady might have having no means at all. No means. My
Her
lord,
daughters are there, married daughters are there.
daughters, they are living in their matrimonial house.
So what? They retain their character as daughters.
No, no, they are not that one.
They still are the daughters of
Yes,
the
they
lady.
My lord, what happened thereafter? My lord, with the help, with the that meager amount of 25,000, we started
You can
making.
appreciate that. Then what happened?
We started making construction of a kitchen.
So you considered to that final degree.
Thereafter, yes.
It was put into execution or
No, not
ordinary courts. It was.
ordinary court. Ordinary.
So then what happened? Now another suit has been
My lord,
filed.
with that meager amount of 25,000, we made an attempt to erect a the kitchen and bath and privy, and at the same time for installation of sewerage water line. When the personnel of the KMC came to install these sewerage filter water line, they resisted strongly, and they could not to inspect the premises even.
What is the age of the lady, your client?
75.
Achha, then what happened?
And my lord, in the meantime, what happened? They filed a separate suit for declaration and injunction, restraining my client from using
of their exclusive right in their portion. And injunction so that you cannot dispose them.
Dispose them and not to use enter that.
But you cannot because they are.
That's true. My lord, that's true.
So what is your grievance against this injunction?
My lord, I do it.
We can appreciate your plight otherwise.
My lord, what I am submitting to your lordship, kindly I do admit.
His possession, his portion, his entitled.
Separate allotment, separate.
Yes.
My lord, super.
Should have preferred an appeal against that final degree.
My lord.
Anyway, you have not, so we are nobody to advise.
My lord, what I am submitting, you are subject to your lordship, kindly approval.
Yes.
My lord, we are ready and willing to make my allotment quite separate and independent. With the help of that, my lord, 25,000. Your lordship kindly direct the other side to allow my client to use and enjoy the all amenities of the premises for a certain.
That would be much beyond the scope of the suit, the injunction application, or the impugned order, or this appeal.
Well, that's true. That's true. I do appreciate.
Sir, without there is nothing in this appeal. No use keeping this pending for another 100 years.
Your lordship kindly consider
these matters are unnecessarily increasing the crowd in the High Court. Unnecessarily. You have no case. I can fully appreciate and empathize with you to some extent. But Mr. Raut, your remedy lies elsewhere. You can prefer a counterclaim there. You can take out an independent suit. You know much better. You are much more experienced than us.
Nothing was done. Nothing was done.
Do that now.
Nothing was done.
It's a continuing cause of action
Well,
if they
in the
disturb your
meantime,
position.
Since I'm the appellant number 175 years old, your lordship
Can there be a ground of admission of appeal?
No, no.
Or hearing this appeal at all? What is there in this appeal? Admittedly, this person, the plaintiff, is the exclusive owner of that portion.
My lord.
And he has got an injunction. You may not disturb his position.
I am not going to disturb. My lord, 75 years lady.
If you are not going to disturb, you don't have a cause of action for this appeal. Because that is precisely what has been directed.
No,
you won't disturb his position. You say I won't disturb, so don't
Since by
disturb.
the order of injunction, my client has been prevented from using the at least the bath and privy. Right now, I am fetching water from the outside.
No, you are at present using the bath and privy, which was previously common.
Yes. Yes. I want that, your lordship. Kindly consider. And restrain me to ousting all these. Order your lordship may pass. Kindly allow me.
But
And
even if we
actually-
admit the appeal, we cannot pass an order of stay. That would.
Well, kindly, Your Lordship, directly, immediately serve the copy. Let them come.
But
you
what
got
about the
what-
partition degree as per the final degree? Do you have a copy of the commission's report? As per that,
Commission report আছে.
Mr. Raut, tell us something.
My lord.
The partition degree has not been put into execution. Let us try to formulate something for you.
No, no, no.
Partition
Nothing.
degree had not been put into
No.
execution.
না ওরা করেনি কিন্তু ওরা দেরি করছিল বলে আমি নিজেই একটা এক্সিকিউশন ফাইল করলাম
কিসের?
এই পার্টিশন
Yes, no, tell us that.
করেছে?
Don't embarrass us later on.
ফাইল করছিল না তো
কিসের?
চুপচাপ বসেছিল ওইভাবে পড়ে আছিল পিটিশন ফাইনাল ডিগ্রি হওয়ার পরে তখন
You have filed an execution case.
My client has filed.
Has filed an execution case for what?
ফর ইমপ্লিমেন্টেশন অফ ফাইনাল ডিগ্রি
Or
এই ফাইনাল ডিগ্রিটা ইমপ্লিমেন্টেশন করা
for
You cannot
implement-
suppress this,
for
Mr. Raut.
implementation.
Your learned junior is absolutely correct. You are suppressing.
No, no, I'm not suppressing. It was not. Well, I'm very much.
You are saying no.
I'm very much candid with Your Lordship.
You are very much candid.
My lord,
He is very much candid.
so far suppressed, my lord, execution proceeding, it was not within my knowledge. I was not instructed. Otherwise, my lord, there is no need of making suppression. I'm before Lord.
If you are wanting execution, Mr. Raut, are you entitled to oppose this injunction? Tell us this. Tell us this. Teach us the law on this. Forget that you are representing somebody.
Well,
You are an advocate. You are an officer of the court.
My lord, all knowledge. I know that, my lord, so far the execution proceeding, it is.
You have put that partition degree into execution, which degree says that it is his exclusive portion.
My lord, exclusive, no doubt. My lord,
You got a copy of that decree or that give us some handle to say that you have been still using that kitchen, bath and PV as common use.
No, I'm not required kitchen, only bath and PV and water for the time being. So that in the meantime, I can erect the kitchen, bath, PV independently. Within a limited time, subject to law. Kindly allow to.
It is in a very difficult.
কনস্ট্রাকশন করতে দিচ্ছে না পার্টিশন অফিসে দিচ্ছে নেক্সট করে executed.
As of today, the final solution will even if she was this position of it was joined to what to do, she is joined to this instead of putting the executed solution partition and the suit and open
করতে দিচ্ছে না কাজ আমাদের
partition decreased to without implemented has got this injunction. Therefore, before the decree is executed, he has pulled one. And the ladies outside for that common reason. That is still there. Stay, we'll make it clear. We'll direct them to serve copy. Admitted, direct them to serve copy. We'll make the ground clear. Using this, and of it, the partition degree to be executed.
You বলবে তো আমাকে আমি তো জানি না সব ফ্যাক্ট
Within common user of the party.
সেই এক্সিকিউশনটা ফাইল করার পর তোর আলটিমেটটা দিল
Let them come and actually, please, the bath and PV she'll have to go outside. Is it good? So, we will have to surface. Set aside.
Well, since in terms of the commission report, they did not pay the royalty money. That is why the decree was only that purpose.
only that for
You pay the royalty money.
Mr. Raut, we want a clear answer from you on certain questions.
My lord.
One, the lady is actually 75 years old.
My lord.
My lord, yes or no?
Yes, well, kindly
Check up.
affidavit করেছি।
Because we'll put this in our order.
My lord,
And there will be a certain amount
Well,
of
I'm just-
illegality in
just
our
a
order
minute,
in your
just a
favor. Therefore, we have to be very certain on the facts.
My lord, my lord. We have mentioned, my lord, I'm coming to that.
We are only bothered about appellant number 1, not the married
No,
ladies.
no.
They are the daughters, they are living elsewhere. So this lady is 75-year-old. We have to ascertain that.
India's কোথায়?
মানে his daughter her daughter
75.
above 55
I was 75, 1. Secondly, till the passing of this injunction, or she has been using bath and privy, that bath and privy.
Yes, regularly.
What is she doing now after this injunction order? Ask your client and tell us.
ওইটা ইউজ করছেন তো এখন
Tell us the truth. What is she doing now? How is she?
But they are using the bath in
The same one.
What fetching water from outside.
The present challenge has been preferred. এটা order আচ্ছা ঠিক আছে ওটা লিখতে হবে না। The present challenge has been preferred against an order granting an ad interim injunction in favor of the plaintiff stroke respondent in connection with the declaratory suit. Full stop. Next para. The brief facts as narrated by learned counsel for the appellants is that there was a partition suit between the predecessor in interest of the present appellants and the present respondent, comma, who were brothers. Full stop. The said partition suit was decreed initially in preliminary form and thereafter finally. Full stop. Next para. The predecessor in interest of the present appellants met his demise during the final degree proceedings, and the present appellants came to know of the partition suit much later when they were substituted therein. Full stop. Next para. It is submitted that the appellant numbers 2 and 3 are married daughters of the of late Gopal Chandra Ojha, their predecessor in interest, and appellant number 1, Srimati Chaya Ojha, is the 75-year-old widow of late Gopal Chandra Ojha. Full stop. It is contended that even after the partition decree was passed and exclusive partition was effected between the parties, comma, allotting the subject matter of the present suit in favor of the respondent, comma, the partition decree, the final degree of partition had not been implemented, and the appellant number 1, comma, who resides there, comma, has still been using the common bath and privy at the suit premises. Full stop. Next para. By virtue of the present injunction, comma, it is submitted that the appellant number 1 would be virtually ousted at her advanced years from her only residence. Full stop. It is also contended by the appellants that a meager provision of rupees 25,000 as OLT money, OWELTY, OLT money was provided to the appellants in the final degree of partition, comma, which is absolutely insufficient to make adequate construction of bath and privy and other structures on the portion allotted to the appellants. Full stop. It is submitted that in the absence of any bath and privy in the premises allotted to the appellants, comma, it would be impossible for the appellant number 1 to continue her residence, and she would be ousted without any specific eviction decree being passed against her. Full stop. Next para. Upon considering the materials, comma, we are of the opinion that the appeal is required to be heard on the grounds as taken in the memorandum of appeal and as indicated above. Full stop. It is to be considered whether the respondent, whether the plaintiff stroke respondent is entitled, comma, by bypassing an execution of the final decree of partition, comma, to obtain an ad interim injunction in an independent suit filed for declaration and injunction on the premise of the said partition decree. Full stop. Apart from the maintainability of the suit on the ground that an execution case is already pending at the behest of the appellants, comma, it is also required to be seen as to whether by virtue of the ad interim injunction which is impugned herein, comma, the appellant number 1 could effectively be ousted from the property by stopping her user of the still common bath and privy at the suit premises. Full stop. Accordingly, the appeal is required to be heard on the said grounds and is hereby admitted. Full stop. The application for injunction is now taken up for hearing. Full stop. Since a prima facie case has been made out for hearing of the appeal on merits, comma, the appellants shall serve copies of the application on the respondent, indicating that the application shall be listed for hearing in the monthly list of January 2025. Full stop. Next para. A limited order of stay of operation of the impugned order is passed to the effect that till disposal of Can 1 of 2024, comma, the Respondent and or his men and agents shall not restrain the present appellant number 1 from using the bath and privy on the suit premises. Full stop. However, comma, it is made clear that the above rider is subject to the outcome of the application, comma, the appeal, and finally the suit. Full stop. Next para, the appellant shall file an affidavit of service to that effect on the next returnable date. আরেকটা line add করে, the party shall act on the server copy of this order without insisting upon prior production of a certified copy. Immediately take a server copy and serve.
I'm extremely sorry, Mala. So far, initiation of execution proceedings, neither in the four corners of the application nor it was intimated to us. That was I was not in a position to submit.
No, do you know? Actually, you have initiated an execution case.
For recovery of money, old money.
Anyway,
Well, it was not in the application, and it was not intimated to me. A deep knowledge.
Thank
Item number 51.
My lord, item number 51, the advocate on record is not currently out of town, so I'm seeking for 1 week's accommodation.
on the prayer for the appellant.
Yes.
On the prayer of the appellants, the matter is adjourned for the week. Please give your name.
Due to me, I am appearing for appellant. I am praying for some accommodation because landed counsel who was appearing for the appellant informed the client that due to some health issue, he will not be able to continue this matter. In this situation, my client has to.
We'll keep it next week. Next week. On the prayer of the appellant, same order. On the prayer of the appellant, the matter is adjourned for the week.
But can it be in a top of the a very short question?
After seeing the size of the paper book, definitely not.
Nothing. Only
But
size.
nothing.
Definitely not.
Substance.
It can go to the last of the list if you want. Not.
Looks into the facts of
After
the
seeing
case.
that paper book, definitely not.
Finding earlier recorded.
Malad, this is volume part 1.
This is only part 1.
Only part 1.
Not
Part
this
2 is
month.
also there,
Not this
Your
month.
Lordship. But nothing is there. It will take 10 minutes. I shall take 10 minutes from your
Your 10 minutes, Mr. Banerjee, everybody is aware of it. Sorry, no. It will remain in the list.
Lordship.
Yes.
My lord, item number 53, I'm appearing for the appellant. Mr. Sarojit Singh is appearing in this matter. He is on leg in court number 29. So, my lord, not today.
On the prayer of the appellant, the matter is adjourned for the day. You're lucky. We'll ask them. It's a short. Yes.
I am for the respondent. This is a matter wherein your lordship had taken up the matter on 14th of November, and there was direction that the department shall serve us with the copy of the paper book. I had mentioned this matter twice, your lordship. The paper book, actually the file was lying in the court itself. The file did not go in the department that we could get the paper book.
So we'll send the file
Your lordship,
down.
I may take the paper book from the court itself and be ready with the matter
Very
by
well,
next
we'll
week.
direct extra copy আছে পেপার বুকে দুটো কপি ছাড়ার কপি নেই থাকবে পেপার বুকস নিশ্চয়ই থাকবে দেখো ভালো করে
And the appellants are also not there. The matter may be dismissed, your lordship. The best.
Oh,
Nothing
so
to
easy.
decide on that.
no পেপার বুকস দেখো পুরো ফাইল লোয়ার কোর্ট রেকর্ডস আসেনি
Give
You
me
can
a
direct the
server.
appellants to hand over a copy of the
Your
paper
lordship,
book.
I had contacted the learned advocate. He said that yesterday or day before yesterday they have taken a change. So today he's not appearing. I had requested him as well that you serve me a copy because I'm not able to get the copy.
Very well, we'll adjourn it for the day. We'll say that the none appeals for the appellants.
Your
We'll
lordship.
put it at that. We'll give them another chance tomorrow. If they don't come the day after, then we'll dismiss it for default on Thursday. None appears for the appellants at the time of call, although the respondent is represented through counsel, full stop. Let the matter stand adjourned for the day.
Number 55. I am for the respondent.
Well, I am for the appellant.
Yes, Mr.
Well, I seek my accommodation at least 1 week after vacation. They got it listed. Just well, I could not do any homework with it.
1 week after vacation, Mr. Mukherjee?
Yes, yes.
Why not next week?
Kindly. No.
Take the weekend.
Yes, yes.
Keep it next week.
No, 1 week because I have been
List.
advised to keep some keep away from some work.
Oh,
homework I can't do at the moment. That is why 1 week after vacation, I assure you, Lordship, we feel comfortable now, my lord, after the long. I
Super accommodation I never. Mala only one thing.
He should not.
As it appears from the cause list, Mala the can 22 of one can application is pending. But Mala no application has yet
Order
been
41, Rule 27. It should be hard along with that.
Have a copy, Mr. Mukherjee.
I came to learn from the
That is giving only on the paper book, everything.
paper book is there.
Yes.
In the paper book, Mr. Mukherjee says it's included.
We have already given in the paper book.
Mala paper book that has been included, no doubt. No doubt.
We'll give you liberty to use an opposition.
Yes,
if you're getting time.
Kindly
ওই তো পেপার বুক তো পেয়েছি
ওইটাই তো
হ্যাঁ
আপনি কপি দেননি 22 সালে
but you have not turned up when the interim order was made. Absolutely, they did not turn up.
At which page of the paper book is the order for 27 annex?
199. They did not turn up when the matter. Otherwise, the judgment order should have been passed. We move this. Why this order? Page কত?
Yes.
Page কত?
Learned counsel for the appellant seeks an adjournment till 1 week after the till 1 week after the upcoming winter vacation. Full stop. Next para. On the prayer of learned counsel for the respondents, the respondents are directed to file their affidavit in opposition to can 3 of
2022
of 2022 within 3 weeks from date. Full stop. Reply if any shall be filed within 1 week. Reply if any shall be filed by January 8, 2025. Full stop. The appeal shall be listed for hearing on January 9, 2025 along with the said application. Yes. Yes. আগে দেখে না হয় কিনা
56 it should come under the application. You know, last occasion was on 14 November, was directed to sub copy of the application for the PDVD.
Let us see.
Now 39 number of respondents all have not yet been, but I have not yet got them or not.
কি গো এই
Check report.
application appeal application আসছে
Is dead. I have to text it also.
We'll put it after the vacation. So who has died?
13.
Respondent number 13.
13. But as a postal, 6 postal tax I have not yet got whether they have received or not, and 13 did.
Very well. Learned counsel for the appellant submits that upon sending copies of the application to the respondents, it appears from the envelope which has returned from the respondent number 13 that the said respondent has met his demise in the meantime. Accordingly, on the prayer of the appellants, leave is granted to the appellant to take out appropriate application for substitution of the deceased respondent. Since the service is otherwise also not complete on all the respondents, let the application stand adjourned and be listed in the monthly list of January 2025. If you file an application for substitution in the meantime, file that, mention that, we'll take up. Appropriate heading and the other
Application.
Application heading
It
as
should be
well.
under the heading application. Yeah.
My lord, in item number 57 and 58, my lord, Mr. Oturu Banerjee has been newly engaged by the respondents, my lord. Only today morning he has received the brief, my lord. Requires some time to take the appropriate
Depends on
instruction.
him.
My lord, on the last occasion, if your lordship takes up the order.
My lord, as Mr. Ajay Choube has resigned from the brief, my lord.
Mr. Banerjee is saying that other end of the. We'll give them 1 week. Let us give them. Otherwise, no useful purpose will be served. You will argue. We will close arguments. He'll take out a recall application. Mr. Banerjee has to prepare himself by this week. Come back next week.
Grateful, my lord.
An adjournment is sought on the ground of learned counsel for the respondents. First up, it is submitted that the newly engaged counsel for the respondents could not prepare himself. First up, it is found from the previous order dated November 21, 2024 that a last chance was given to the respondents to contest the appeals. First up, next para, however, in view of the predicament being faced by the newly engaged counsel of the respondents, the matter is further adjourned till December 9, 2024. First up, however, the matter will be taken up ex parte on the next occasion if the respondents seek an adjournment and or are absent at the time of call. There cannot be any further last chance. I mean,
57 and 58.
57, 58 both. তাহলে matters করে plural করে দেবেন. These will appear together.
Grateful, man.
Thank you, sir.
Number 59 and 60.
Union of condition. The respondent is the union. There's a competition between the state and Sir Rai, any other side?
Yes,
I mean, obviously there is some other
Mr. Mukherjee is there.
Shobhati Datti is there.
He has been instructed not to appear.
Oh yes, yes, something, yes. Right.
বলা হয়েছিল যে সার্ভিস করতে হবে।
we have served.
Yes, accordingly, my lord, we have served personal lordship direction, my lord.
Personally served. Respondent has received. Both the respondents have received.
Yes, yes,
Yes,
দেখেন
yes.
আমি দেখিনি।
Probal Mukherjee was appearing. The which was taken from them. They were instructed not to appear. So we directed them to. What is the conspectus of the appeal? It will take some time.
2 appeals are there, my lord, probate. It will take, my lord.
Because we are thinking about this because for the coming 2 weeks, this week I'll be sitting with Justice Kant, next week with someone else probably, we don't know, or we'll continue. So we have to ensure that the appeal is disposed of within this period. Otherwise, keeping it parted in this composition.
If the other
not
side is
adhere to
not
any-
there, I'll make my argument only one, maximum tomorrow morning. After that, it can be completed.
What?
Now it's 3:30.
No. What is what?
It is a probate.
Why do you say 2 appeals?
Yes, my lord.
We have
What-
only one before us.
No.
There are 2 appeals.
Yes, 59 and 60, my lord will find.
So what is the conspectus of the appeal?
Yes,
Just
my
tell
lord.
us.
2 appeals are there, my lord. One, in respect of the mother, filed a application for grant of probate. Another is the son. 2 wills are there. on the
Competing
surface.
wills. Competing wills.
Competing wills. Now, my lord, the sons.
Mother and son are the only heirs. No, there are.
No, there are other heirs are there, but younger son who has been.
So 2 camps.
2 camps.
You are the mother or the son?
Son.
Son, very well. Yes.
Now the mother's will is grant probate. Against that we prefer the appeal, and my probate application dismissed. Against that,
whose will was earlier?
No, son, his father. Earlier, my lord, I big.
No, the will was whose will was earlier?
Mother.
The last will of the
Mother will was earlier, son's will was later. If I can prove that the son,
that is why we ask. Then the court must have held disbelieved the execution of your will also.
Yes.
Because if your will is executed, mother's will automatically
the mother's will automatically goes.
even if it is proved.
Yes, yes. So my condition, my
Which one is that appeal?
Yes.
Your dismissal?
That is 435. I want to first impress your lordship regarding the.
Because if 435 succeeds, even if the mother's
that
will was
is immaterial.
executed
That
properly.
is immaterial.
Yes. So 435.
435.
Defect has been cured. There was an old defect. We don't know. Please ready for hearing. Otherwise,
Did you
কোনো স্ট্যাম্প নেই কিছুই দেখা হয় না নাকি? Classified as memorandum from appellate decree.
It is original.
Should be original.
Original.
You are the appellant.
Yes, well, the leave may be granted.
Do it right now. First do it and then we'll take up. একটা order record called leave is granted to the learned advocate on record for the appellants in FAT 435 of 2017 to carry out the necessary rectification in the caption of the memorandum of appeal, classifying the same as one from an original decree. Only score through the appellate and write original and sign.
Original, partially.
Mr. Rai, please ensure. Amended with the leave of court.
Correction has been done.
Mr. Bakchi, how are you?
Pulling on.
Great.
না কেন কেন না এইগুলো দেওয়া যাবে না হ্যাঁ একটা
What happened?
Yes, going somewhere else.
No, definitely not. He's the advocate on record.
No.
His back sheet is there.
He is the controlling advocate on record. Someone is lending advocate.
Where is he going to control now?
One motion and
If Mr. Bakchi gives you permission, then he'll be. Depends on him.
I am for the respondent.
This matter?
No.
No, Mr. Bakchi, Mr. Bhattacharya is there in this matter, along with Mr. Rai. Mr. Bhattacharya is wanting to go to some other court to earn money, leaving Mr. Roy alone.
Permitted to do it.
Permitted? Mr. Bakchi is permitted. Go.
I'll be here in 5 minutes.
Yes.
5 minutes.
Very well. Yes, Mr. Rai. Be sharp, be brief. Yes.
The original owner of the property is Pyaribon Chakraborty, my lord, who died on 5th. He died on 20th April 2006. 20th April 2016. 20th May 2006. 20th May 2006. I may be correct.
Yes. Then what?
Now, my lord, this is the will which is subject matter of dispute.
This is the will of Perry.
Perry. We bequeath the property in favor of the son.
Date of will?
Date of will 5th May 2006. And
5th May 2006.
My lord, will find page 1. Kindly turn to page 2.
Page will, date of will? Died on 20th of May.
May 2006. And the will was 5th May 2006.
Very well. Then?
Now, my lord, from the will itself, my lord, I'll suggest your lordship the.
Why was it refused by the trial court? What was the main?
According to the trial court, the signature was there, blank paper, subsequently was converted into will.
How many attesting witnesses were there in the will?
4. Out of them, my lord, There is one attesting witness in respect of both the wills. He was the attesting witness.
Yes.
We want to. He was the aged person. We filed an application. একটু দেখে নে।
Now, how many attesting
Four.
witnesses proved your will?
One. And the reason for disbelieving my lord, that I will satisfy your lordship. There is no occasion for disbelieving my will.
So out of the 4 attesting witnesses, the common attesting witness.
Yes, that's why I filed an application.
He adduced evidence in support of the other will.
No.
He disproved your will.
No, he did not come.
He did not come at all.
We filed an application. He is aged person. We filed an application for holding.
So you need to call only one attesting
Yes,
witness.
that
as
is
per-
done. Apart from to dispel all the suspicious circumstances, I want to adduce him as a evidence. As a aged person, I filed an application to adduce evidence on commission. That was kept pending, not been decided. And on that basis, my lord, the learned court below satisfy lordship held adverse presumption against me for not adducing him as evidence.
What?
Yes, that is the point I will satisfy your lordship.
You filed an application,
Application
for
that is pending, not been disposed of. And for non-production, that witness, that learned trial court took adverse inference against me for holding that is suspicious circumstances. That portion, my lord, I will come.
That is the only ground.
No, apart from that, other grounds are there. One of the main grounds is also there. My lord, can you turn to the objection? Because so for the objection, what are the grounds they have taken for the purpose of disputing my will? Page 10, my lord, your lordship find.
Yes.
I'll make it out. Yes. Defendant filed original grant of probate, the last will testament of 8 March 2006 of her husband Priyamohan Chakraborty, deceased testator. In the said last will, the testament dated 8 March 2006, this defendant hasn't put his signature, which type of signature he has been doing since about 2003 in the bank's post office and in the pension account of this defendant's husband has put his signature, which type of signature he has been doing since about 2003. In the bank's post office and pension account of this defendant's husband Priyamohan Chakraborty's signature are to those similar of signature of Priyamohan Chakraborty as appear in the last will and testament dated such and such of defendant's husband Priyamohan Chakraborty. This defendant has taken
2 main grounds apparently in the
Yes.
objection. One is that enmity between you and father, there was no relation was not good.
This is the allegation. But
Yes, 2 grounds. The more importantly, the father could not physically sign,
Yes.
put his full signature.
full signature, physically not in a
Yes.
position.
That are the 2 grounds from the
No,
request.
apart from that, your lordship find.
That has been repeated in several
Yes.
places
Uh,
and manufactured, obviously. That
and page 13, your lordship find the physical condition. Third paragraph.
Bengali will, but English full signature.
English full signature. Type
But
to it.
maybe
Yes, there will. My lord, I'm not on that. My lord, can you consider these are the
page 13. Yes.
page 13? This defendant father states the defendant's husband was bedridden.
Yes.
He has 2 attendants, 2 shifts on 15th April 2006. Before that, the defendant's husband has cerebral attack in July 1998 and admitted to Ekbalpur nursing home. He was to some extent immobilized. He was put under physiotherapy. He could somehow move inside the house.
1 second. What was the date of her will?
8 March, no? 5th March.
Which year?
Same year, 2006.
Then the same logic applies to her will also.
Apart from
There
that,
he did not put his full signature.
he did not put his full signature.
Thumb impression.
No, short signature.
Acha.
And I'll suggest from their evidence it will appear he was there at Asansol.
Anyway, so
Yes,
let's continue
my
with
lord.
this. Yes. So physiotherapist and all, he
All and
hospitalized, could not.
And
They
the
produced
signature
medical papers also.
yes. And the last thing is, my lord, the last portion. Not executed as such, it cannot be said. The alleged witness were witness to the date of execution on 5th May 2006 of the impugned deed and manufactured will. Impugned and manufactured will. This defendant's husband was not maintained as physical. So these are the sum and substance of their objection
Yes.
regarding the will. Now, my lord, I am drawing lots of evidence. So first, in terms of the Succession Act, what was my evidence to prove the will? That your lordship will find at page 19. Because both the evidence were taken together.
Is there any discussion in the judgment that section 63 was not complied with?
No,
Or-
it was not in that fashion, my lord. But to some extent, it is disbelieved on the ground, my lord. If your lordship wants, I can place the judgment. After that, I can.
No, in your own way, whatever. You are placing the evidence, do that.
Yes, my lord, if your lordship kindly consider the evidence, PW1 is the evidence of Monjusi, who was the plaintiff for the propounder of the earlier suit. That's why he was PW1, and our case was made as DW1.
The two suits are hard.
Two are analogously, so their sector was PW1, 2, 3, and our is DW1, 2, 3. So, my lord, I am drawing lessons over the DWs are concerned. DW1 টা কোথায়? Oh, annex করা ইয়ে নেই। সেপারেট কপি আছে? আলাদা করে কপি করা হয়েছিল তো। ও না, অ্যাপ্লিকেশনের মধ্যে ওটা অ্যাপ্লিকেশনের মধ্যে দেওয়া ছিল। অ্যাপ্লিকেশনের মধ্যে দেওয়া ছিল।
DW is not there.
Yes, it was there in the application because it was not within our
application.
There initially the application was filed. Judge একটু দেবেন?
It should be a part of the paper book also.
Should have.
Paper book does not contain all the evidence, Mr. Rai.
Only this evidence.
The other paper book, the other matter paper book contains.
Same.
Why?
I.
What can be done?
This
what application? Application has been disposed of already.
Yes, the documents, the evidence was annexed in that application.
What application? What is the number of the application?
Yes. Can 4465 or 29? Achhe, 18. Just there.
দুটো কপি বার করবে।
হ্যাঁ আছে। ক্যান্টা দে।
ওনার কপিটা দাও। 4464 or 5?
4465 2018.
4464 দিয়েছো কেন? 65 টা দাও নাকি? 4 টা নিয়ে নাও, 4 দুটো নিয়ে নাও।
Lord, I beg to excuse my lord for inconvenience. It should have, my lord. Because it was COVID time, we could not get inspection. Yes, my lord, this paper book was prepared, we could not get inspection of the subsequently.
What COVID time?
This COVID period, this paper book was prepared according to my paper book. My lord, can you turn to page 82, your lord shall find the evidence chip. Senior advocate চলেছে, আমি কিছু বলবো।
Yes. You can appear without him.
Yes, he cannot appear without me.
Yes.
এখন তো লিজ নিয়েছি।
DW,
my lord. If your lordship can turn to.
This is DW1.
DW1, the propounder.
Yes.
My lord, he has just narrated the entire fact. He physically fit and 5th May it was executed. Apart from that, nothing more than that. Now, my
propounder.
No.
This is the propounder of the will.
No, DW1.
No, we are interested in the attesting witness more.
Oh. No, আরে অরুণ চক্রবর্তী, অরূপ চক্রবর্তী attesting witness. আমি না বসুন আমাকে একটু
give me half an hour, give us half an hour, we'll argue your matter and you be the judge. Give us half an hour, we'll prepare ourselves.
It's স্বপন চক্রবর্তী।
Mr. Chakraborty, Mr. Rai, prepare yourself and come back.
No, এটা তো অরূপ চক্রবর্তী। আমাকে ছিল তো।
No, this is not the way an appeal is.
No, my lord. I should.
Since certain documents are not found in the paper book, comma, let the matter stand adjourned for the day. All the evidence we can't find.
আমি বললাম কালকে।
Should we direct you to do that? That will be better for all of us.
No, we have already instructed my junior because they have supplied me in this
না তাহলে লাস্ট লাইনটা না যেটা বললাম সেটাই হবে। The matter since আচ্ছা কেটে দিন ওটা, আমি নতুন করে বলছি। We find from the paper books that all the relevant documents, including some of the witnesses' evidence, is not a part of the paper book. So accordingly, the appellant in FAT 435, your appeal?
Yes.
Appellant in FAT 435 of 2018 shall prepare and file a supplementary paper book, including all the left out documents. Such supplementary paper book shall
By
be
tomorrow.
prepared within a.
By tomorrow.
We cannot take it up before next week. If you prepare it by tomorrow,
Only that two documents, the chief and the cross. These are the only things left
shall
out.
be prepared by tomorrow.
Yes.
The matter is urgent till tomorrow. Come back.
Ready করো, immediate ইয়ে করে করো।
Take a chance.
Yes, we just want to fix it. Otherwise, there is a document in my brief, but I told them to prepare a supplementary paper book. They did. তৈরি করে রাখো, দুটো তৈরি করিস নি আলাদা করে জেরক্স করে ওই এভিডেন্সটা স্বপন চক্রবর্তীর এভিডেন্সটা
Next matter.
না
Call the next.
জজটা বলে কালকের মধ্যে কলটা রেডি করবে।
You are for the respondent, Mr.
Respondent.
Who is for the appellant? The paper books have been prepared in this matter. Paper book হয়েছে? Paper book কোথায়? কি হয়েছে?
পেপার বুক আমরা তৈরি করেছি।
হ্যাঁ, দুটো পেপার বুক আছে, লেখা রয়েছে। না বলছো কেন? লেখা রয়েছে টু পেপার বুকস, তুমি না বলছো? So,
Lavanyashree.
Can you give a notice to her? Miss Lavanyashree Sinha. But we don't know, I mean, without her, how can I? If it was you are the appellant, Mr. Bagchi, we could have heard you and disposed it of expert. We cannot do anything but dismiss for default.
But I am not praying for.
No, that will not serve your purpose because the appeal must have been listed after so long. So can you please serve a notice then on the learned advocate for the appellant?
Yes.
Please ascertain who is the learned advocate. Ms. Lavanyashree Sinha. Do you know her?
Yes.
Please serve a notice, come back tomorrow.
Day after tomorrow.
Very. Then next week, Mr. Bagchi, because the difficulty is this combination won't continue for over a week. So if you keep it part heard after tomorrow, then it will be difficult for us to pass the judgment. So we'll keep it the week after, the next week. None appears for the appellants at the time of call. First of the learned advocate on record for the respondents is requested to serve a notice regarding the pendency of the matter in the list to her counterpart appearing for the appellants. First of the matter is adjourned till December 9, 2024. Next.
In this matter, I am for the appellant, Mr. Mukherjee is for the respondent. You will also be kind enough to take up next week.
Next week?
Next week.
Don't
Yes.
like Justice Kant? Why next
No,
week?
I couldn't prepare. I must be candid.
If Mr. Roy has some difficulty, but the thing remains there is a partition deed registered, which is under challenge in the suit. That suit got dismissed on merit. So, my lord, suit for partition after the partition deed being executed, where Lord, my learned friend's client is one of the executed. Lord, kindly fix us any day. Today, my learned friend.
What my learned friend is submitting is not that. I am not the party to the deed of execution. Shekiri.
We'll put it next week.
Mr. Rai will lay down the law. And the
Yes,
facts.
next week. On the prayer of the
And the
appellant.
paper books, my lord, at the time, because there is a vernacular language that's not accepting, my lord, subsequently.
On the prayer of the appellant, the matter is adjourned till December 9, 2024. The paper books handed over in court today on behalf of the appellants be kept on record.
I am also appearing, my lord, in this matter.
For whom?
I'm led by
Yes, yes.
Yes. বুঝেছিস তুই উল্টো পাল্টা বলবি আর আমার নামে বলবি না হ্যাঁ
That's what.
But
Yes, Mr. Mitra.
my I appear for the appellant. My lord, I'm praying adjournment for DS Mollik appearing. He is
Who is appearing?
DS Mollik.
Till when are you asking for an adjournment?
4 weeks at least. These days, yes.
Forget it. Forget it. No adjournment for 4 weeks. It's appearing in the list. Come prepared tomorrow.
But is it 12th of November the matter was taken up?
No, come prepared tomorrow.
There was adjournment was done on their behalf.
No, here. We are refusing adjournment. We'll take up the matter today itself. On the last occasion on 12th of November, we granted adjournment.
Today he has returned back. Again, he has admitted 2 days.
Admitted in hospital. Engage somebody else. Why are you taxing him?
I'm not.
We'll keep it next week. Engage somebody else. We'll keep it next week. An adjournment is sought on behalf of the respondents. Full-stop. It is submitted that learned counsel appearing for the respondents is in some personal difficulty. Full-stop. Next para. As a last chance for the respondents to contest the matter, the same is adjourned till December 9, 2024. Full-stop. It is made clear that in the event the respondents seek further adjournment or remain unrepresented on the next date when the matter is taken up for hearing, comma, the same will be proceeded ex parte against the respondents. Please come prepared on December 9th.
Yes.
Either prepare yourself or engage. Please give your name now.
And Namta Ablai.
Thank you. Mr. Dottan, Mr. Bera, this matter is regarding that land acquisition.
The land acquisition, but what your lordship, I heard your lordship. But after additional evidence is allowed, it will take time.
Yes, we suppose, because if this bench takes up, it will be difficult for all of us.
Yes.
So we'll adjourn it for the week at least.
Yes,
Or we'll
yes.
adjourn it till 16th, because the regular bench will sit from 16th. Justice Kumar will be, no, not from 16th, sorry. His lordship will be coming back because he has gone to Port Blair. He'll be coming back on 17th. So we'll keep it on 17th December.
17th or 18th, whatever.
17th or 18th December, we'll keep it. 17th December, we'll keep it. Let him come back.
Yes, no, because after additional evidence is allowed, matter will take time.
Yes, it will.
And in the meantime, on one of the, my lord, respondent also expired a filed application for substitution.
That is pending, that will be decided at the time of
That application is appearing.
Yes.
Appearing.
So that will be decided
That will
at
be
the
decided
time of.
At the time of, my lord, this formal application.
But you take instruction, whoever is appearing, I mean, you have instruction to
My
appear.
lord,
No, I have.
Or you yourself,
Appellant has, one of the appellant has expired, we have filed.
No,
application for
respondent.
Substitution.
one of the respondents.
Oh, sorry, respondent.
The other way around, yes.
The respondent, we are appearing for all the respondents who have filed the vocal. That's a formal.
Yeah, filed application, that application may be allowed, your lordship, my lord.
So we are just adjourning till 17th of December.
Yes.
After order record করে, since
Or
this
instead of 18, 19, your lordship,
19th,
19.
19th, since this is not the regular bench, comma, we do not intend to take up the hearing of the present appeal, comma, which might take some time. Hence, let the matter stand adjourned till December 19, 2024.
19 Thursday.
If you are in difficulty, and if you no difficulty, we'll grant. No difficulty on
We
that.
expect always we are not in difficulty, but.
No.
And my lord, this matter also will not take more time, my lord. I can assure your lordship, I am in a very weaker condition, my lord, and they are in upper hand with.
They have an upper hand.
Nothing upper hand.
My lord, only, my lord, this land acquisition matter, everything, my lord, I am seeing, my lord, that I only on the question of law I am arguing with your lordship, my lord. Factual aspect, there is none. I cannot say anything.
64 to 72, same item.
64 to 72, same order. Act a common order.
These are analogous matter, my lord.
It's all analogous.
Common order.
In a division.
75, 5. 4 পর্যন্ত বললে যে
64 to 70 কত?
72.
Oh, 72.
72.
No, not today, থাক. 73, 74, not today. Same.
76, Your Lordship, I'm for the appellate. Mr. Romindranath Mahato is appearing online, Your Lordship.
Online?
Yes.
Who is for the respondent? What is the matter about? Mr. Mahato is there. What is the matter about?
It is
You
suit
take
for
some
partition.
time.
Yes, Your Lordship, it's a hearing matter. Your
No,
Lordship.
hearing matters do not take
It will
much
take,
time.
I will file supplementary.
You have
paper
challenged
borders.
preliminary or final degree?
Preliminary degree.
Preliminary degree. What is the premise of main ground of your challenge? We will not close arguments without hearing Mr. Mahato. But what is the main premise of your challenge?
I'm not that prepared. Should be.
Golden opportunity
Yes, Your Lordship.
lost. You never know when the next chance of arguing an appeal will come to you.
Sorry.
You never know. Your choice. An adjournment is sought by the appellant. Let the matter stand adjourned for the day. দুজনেরই নামটা give your names also.
Item number 77. My lord, I'm appealing on behalf of the appellant, my lord.
Yes. What is the challenge against?
Final degree. My lord, in the last occasion, my lord, the respondent have filed an application for.
He's appealing for the respondent. Again, they'll come tomorrow and file a recall application. And
my lord, Swarup Banerjee, they have filed an expeditious disposal, my lord. That application has been disposed, my lord.
and they're not here today.
My lord, kindly. Last order time.
They will not keep this matter part heard. Because of the difficulty we are discussing.
Well, kindly today, matter may dispose of, my lord, today. I'm ready for hearing.
It will dispose of today itself.
I'm ready for hearing, my lord.
No, we understand you are ready, but the other side is not there.
Not there, my lord.
Then what can be done? We are passing it over. If Mr. Banerjee comes rushing, if you can call him, let us see. We'll call the next few matters. Pass over. If it's a short matter, we can take up.
My lord.
But provided Mr. Banerjee comes, we're just passing it over. Otherwise, you'll have to raise your deals. Yes, next. Pass over. Yes, Adit.
Item number 78.
What I am for the appellant led by Mr. Juan Banerjee. On the last occasion, my lord, the opposite party was to file the paper book.
They have not yet filed the paper book.
No, my lord.
Dekhi order sheet.
And the land acquisition department has submitted their calculation.
No, keep it with you. Unless paper books are filed, we cannot help you.
My lord.
On November 26, 2024, when the matter had been last taken up for hearing, learned counsel for the respondent sought an adjournment and assured the court that the respondent shall file the requisite number of paper books during the course of the day. However, learned counsel for the appellant appearing today contends that no copy of any paper book has yet been filed. None appears for the respondent as well, so as to answer the court's query as to such filing of paper book. What about the paper books?
My lord, it has been filed today, my lord.
After the above order was passed, learned counsel for the respondent comes rushing in court and submits that the paper books have been filed only today. In any event, unless the appellant gets a copy of the paper book, the matter cannot be heard. Have you got extra copies of
It has
paper
been
book?
served, my lord. I'm told that it has been served. Upon Mr. Owen Banerjee.
There is some doubt as to whether service has been effected
Done, my lord.
on the learned advocate for the appellant. Be that as it may, you are filing the paper books today. Where are those?
Filed, my lord.
In the department?
In the department.
let the paper books filed today in the department be tagged along with the main file. First of the matter be adjourned till December 9, 2024. আদিত্য ফাইল আজকে ফাইল আছে ওগুলো আনতে ডিসেম্বর 9 থাকবে রেড তুলবো
My lord, 79, I beg to appear on behalf of the respondents.
This is a part-out matter, my lord.
Justice Kumar and me?
Yes, my lord.
Not today. Not this week. না এটা এক কাজ করো এটা এই বেঞ্চে কোনো অর্ডারই পাস করেনি এটা তুমি ব্র্যাকেটে দিয়ে রাখো December 19, 2024. It will appear next on December 19, 2024. When Justice Kumar.
December 19. Grateful.
Grateful, my lord.
Yes, thank you. Not today. Same.
32 for opposite party, my lord. I'm appearing.
We're making not today.
Great.
Not today.
I am for the applicant.
Appellant. Hide and seek.
My lord, ex parte decree of divorce. When the suit was filed, the wife was residing with the husband at matrimonial home. Pandemic situations, kindly remember that.
You are the wife.
I am the wife.
Who is appearing for the other side?
Madam, Mr. Sobhusachi Mukherjee, my lord.
দেখি ফাইল অর্ডার শিটটা দেখি
Your lordship, please to extend the short for time. Your lordship extend the interim order.
Yes.
No paperwork has been filed, but
So the interim order has been extended till disposal. So
Yes,
you are
yes.
protected by injunction.
yes.
So since they're not there, let us wait for them. Paper books were to be filed.
Madam, no paperwork has
Applications have not been disposed of as yet.
Yes, that application has not been disposed of. While she was residing there, thereafter after passing the degree was passed.
এই আদিত্য এটা হিয়ারিং লিস্টে এসছে কেন অ্যাপ্লিকেশনস শ্যাল বি লিস্টেড টুমরো লেখা রয়েছে আমাদের কোর্টেরই তো অর্ডার অ্যাপিল হিয়ারিং এলো কি করে under the application heading. Tomorrow. They may have been following the list and they did not find out. Let the matter be listed under the appropriate heading tomorrow. কাল অ্যাপ্লিকেশনে দিও দয়া করে বুঝেছো পাসওয়ার্ড ম্যাটার যদি বোথ সাইড থাকে রাখ পাসওয়ার্ড ম্যাটার উই কলিং Yes, Mr. Banerjee.
Yes, my lord, I don't know.
VIP treatment for you. We are waiting for you.
My lord.
Call the password. Madam.
Sorry, my lord.
No, no. It's
Reach.
Sirampur Hooghly on 2020 on 22nd February 2021.
This is against a final degree of partition. What is this against?
This is final degree.
Partition degree, final degree.
My lord.
Yes. What is the ground of challenge? You concede to the preliminary degree, the shares.
Preliminary degree, considered.
You have no objection.
No.
Fair. Yes.
My lord.
What is the ground of challenge?
My lord. The first ground is that the landed commissioner did not give any notice to the appellant defendant herein.
This is an ex parte final degree?
Yes, my lord.
Achha.
Any notice, though the specific direction has been given by the landed court below. Kindly, if your lordship kindly trouble to turn page 38, paragraph 10, my lord. Let Shri Kashinath Ghosh be appointed as an advocate commissioner to partition the suit property by metes and bounds as per the preliminary degree as per law. The partition commissioner shall, after giving notice of both sides, hold the commission work, my lord. And if your lordship kindly trouble to turn the page 18 of the paper book, if your lordship can found that on the, may I be permitted to read, my lord?
Absolutely.
On the next, on the date fixed, that is on 15 September 2018 and 20th July 2019 and 3rd March 2020 and 8th March 2020, 3rd December 2020 and 10th December 2020, I went to the local after due service of notice to registered post with AD and the learned lawyer of the plaintiff, and the plaintiff himself identified the suit plot and handed over to me the Xerox copy of the plaintiff Xerox copy. And nowhere it is recorded mentioned.
Defendant is not there.
The defendant is not there. And I have served the notice defendant also. First thing. My lord. Second point is that, my lord, if your lordship kindly travel to turn the page 5 of the paper book of the schedule of the property.
No, but he says, and I went to the local after due service of notice through registered post with AD. And lawyer of plaintiff and plaintiff himself identified the suit plot and plaintiff handed over. So it's not clear as to whether that previous sentence qualifies both.
Yes.
He does not say that that was sent to the plaintiff only. He says, I went to the local after due service of notice through registered post with AD. And it is disjunctive. Then, and the lawyer of plaintiff and plaintiff identified the plot. So he might have served notice through registered post to both.
But my client has not received the notice, my lord, as per my instruction.
Very well. Then,
next, my lord, as per the schedule of property, my lord. If your lordship kindly travel to turn page 5, my lord.
Page 5, yes.
Page 5. Kindly, if your lordship can look the third line, LR dag number 158, RS dag number 108 of 150107, LR dag number 137, and my lord, LR dag number 160, 137, and one.
The numbers are a bit.
Yes, yes. LR dag number 160, 158, and 137. My lord, got it, my lord?
No.
LR dag number.
There are several LR dag number. You are picking and choosing.
LR dag number.
Which
my lord, kindly.
Which
type copy, my lord. Kindly come.
Where is that?
Type copy.
Oh, the entire thing has been.
I got it, my lord.
Right.
There are
page. Type copy page.
Type by 5.
Right. Yes, yes. Yes, you are reading from which line?
District Hooghly, PS Sirampur, Mouja.
Entire thing. Yes. What is your contention? What do you want to say?
There are 3 LR dag number. LR dag number 158, 160, and LR dag number 137. 3 LR dag number.
Yes.
And total area of land 1 vigha 3 kata 13 chitak 75 square foot. Mile.
Right.
Well, if your lordship kindly travel to turn the commissioner report.
What would be your point that the entire property was not demarcated?
My lord, kindly, he has allotted the portion LR dag number 158, 140, and 137. 140 is not there.
This is page?
Page 20 of the paper, my lord.
So instead of 160, he did 140.
Yes, my lord.
Are you sure this is not a typography? No, no, it's repeated elsewhere also.
In my
above.
partition deed also, man. In my partition deed, I can
Partition deed must contain 160.
160, my lord.
No, no, in his report,
In his report,
in
160.
two places, at least at page 20 itself, the second sentence and those 3 lines. So 2 places he has written 140.
140. In thereafter, he has allotted the share in 140 also, my lord. Nowhere in 160 in the partition commission report for allotment. My lord.
140 is beyond the suit premises, suit property.
Suit property. As per their plan.
As per the degree also.
As per
the final degree must contain that.
Yes,
only.
yes, yes, my lord.
All right, then.
If your lordship tally appreciate the total area of land is 1 bigha 3 kata 13 chitak 75 square foot.
The area tallies.
Yes, if we convert the said land into square feet, then we can found that that square 17,220 square foot is 1 bigha 3 chitak 3 kata 13 chitak 75 square foot. And if we divided 70,220 by 9, then we get 1913 square foot per shareholder, and which amounts to 2 kata 10 chitak
per shareholder.
Yes, my lord. As per the total land, each shareholder will get only 2 kata 10 chitaks of land, and the partition commissioner has allotted, as page 25 of the paper book, 3 kata 2 chitak 10 square foot of land. 25, my lord, page
25 years.
Second, I have shown the plaintiff 19 share in my partition plan by figure L1, L2, L5, L6, L7, L4, L3, and colored yellow measuring about 3 kata 2 chitak 10 square foot. My lord, got it?
This is for the plaintiff. What about the others? The previous pages will find that.
Actually, all shareholder will get 2 kata 10 chitak.
No, may not always be possible because of the demarcation. Sometimes it's compensated by OLT money because of the peculiar structure of a land.
Yes.
Maybe it varies. But suppose the unity of the character of the land has to be broken.
Free portion to the plaintiff. My lord, kindly, if you kindly appreciate,
what has been allotted to you? It may very well be that there's a DOBA sort of thing,
my lord,
which is of a bit more than the land adjacent to
Yes,
it.
my
So
lord.
it may be allotted entirely to somebody and OLT money is given to the other. That may happen also. Need not be exactly same area for
My lord.
all the portion. Or somebody is in possession of some property.
Well, if
some
your
part.
lordship go through the map.
We don't get your point at all. What are you driving at? 2 points you have got. One is no notice of commission to defendant. Second is that omitted dag number
Cream
160.
portion has been allotted to the plaintiff because there are
What
three
has been
dag-
allotted to the plaintiff?
cream portions.
Cream portion.
If I already I'm taking on these grounds, my lord, in this regard.
Why do you say cream portion allotted?
My lord, if you kindly lordship the travel to turn the
There is no map? There-
Yes, yes, my lord.
Yes.
My lord, have map also.
Where is that?
Page 20.
Yes.
5A.
The plaintiff gets which portion?
25A. My lord, LR dag number 158. This is the Bastu. This is the Bastu land. And the Landed Commissioner has allotted a total share in respect of the 137, 140 to the plaintiff in this portion, my lord. And nowhere in 137, 140 are not allotted. And 137 is a pond.
What has been given to you? Let us see that.
I'm the rest on it. I'm the rest 8.
Where is that? Where is that allotment of yours? Only plaintiff share has been demarcated.
yes.
You have not been given anything.
Yes.
There were only 2 parties. There were 2 sets of parties, plaintiffs and defendants.
Plaintiff and
How
defendant.
many plaintiffs were there?
Plaintiff one.
One plaintiff.
And defendants?
How many defendants?
Defendants?
Must be 8 defendants.
8 defendants.
Because 1/9 has been given to the plaintiff.
Yes.
So plaintiff's share has been allocated.
Yes, my lord. Not our share.
And the rest remains for you.
Yes.
Acha, very well.
My lord, if you kindly found from the length and breadth of 158, dark number.
You haven't got any portion in the Vastu? The entire Vastu has been given to him?
Not at all, my lord. Vastu. Major portion is given to him, my lord.
And what have you got? Some Vastu and
some Vastu.
And what
he has
about
not given in the ponds in the other number 137, he has not allotted, my lord, that portion. Petition has not allotted the pond portion and 137, 140. As per his record, 140, my lord. My lord, if you lordship kindly found from the Partition Commissioner map in Ila 158 from the eastern side, if you lordship found from 56 foot 7 inches.
You don't find the key or the legend?
My lord.
Where is that? Which portion? Yes, key you have found. Not. This is not. It's a 148.
56.
Yes.
0.7 in the north eastern side, my lord.
Yes, 56.
And then
56 feet 7 inches.
56 foot 7 inches.
Yes.
And if we calculated the 34 foot 4 inches and 99 foot 3 inches, then we ascertain the 56 foot 7 inches. And if we calculate the western side 56 foot 7 inches, then we will find 40 foot 13.4. অসুবিধা হচ্ছে এই লেখাটার জন্য টোটাল ক্যালকুলেশনটা ম্যাপ করলেন 50 foot 40 and 9. It is not eligible copy for me. My lord got my point, my lord. Page.
This yellow has been given to plaintiff. So this is yellow. This is yellow. The yellow portion here has been
my lord,
the yellow portion here has been given to the plaintiff.
Yes, my lord. If you western side calculate 40 foot 30 foot 4 inches and 9 foot 3 inches, then we will get 62 foot. And if eastern side 56 foot 7 inches, my lord. It is the calculation of the Partition Commissioner, my lord. How he has calculated, my lord.
But who has been given that Pakka 2-storied building on the southern side? Yellow portion has been given to plaintiff.
Yes, my lord.
You have got that Pakka 2-storied building also on the top. Yellow portion is only this. Look at this.
Yes, my lord.
Only these three.
Yes.
That has been given to the plaintiff. But you have got all the rest, including that Pakka 2-storied building.
But
there's a Pakka 2-storied building above that. Eta ferat diye debo na. You go through this. We have understood. We have got a feel of this. Yes. You have got a Pakka 2-storied building. Just look at that.
8 shareholders are there, my lord. Kindly appreciate.
Maybe.
He has not given any proper allotment for the pond.
But you could not be given. This could not be. It would be like Shylock's division. I mean, this is one unit, right? These three. The yellow portion is one unit. It is a bit more than the ideal average of 2 katas and 10 chataks. It's 3 kata something.
My lord.
It's a bit more. But dividing that midway would not be possible. If his share was to be given exactly to the extent of 2 kata 10 chatak, the average, then the portion which would be left of that building would not be usable by anybody. Therefore, that building has been given entirely to him. The rest has been given to you, which includes
It's
the
not
Pakka
allotted in the
two-story.
pond portion also, my lord. 137, my lord, the pond.
That has also been given to him.
No, that portion has not been calculated, and this portion is shifted to the 158.
But this could not be, I mean, he was residing there at that point.
He is not actually residing.
Oh, achha.
That person is not residing. The petition, the respondent is not residing there.
According to you, what should have been given to him? Suggest something which should be given to him. Half of this.
140. We have no issue, my lord. If we give the 140 total.
140 is a vacant land.
Yes.
And you get all the premises.
140 is total area of land, my lord.
140 is a vacant land. He has to construct, make construction there.
4 kata. 4 kata.
4 kata, 8 kata, 100 kata, he has to make construction over there. Are these agricultural lands? It's a bastu.
Yes, my lord.
There is a ready-made construction, Pakka two-storied building there, and another construction. We don't know the height of the other, the one which has been allotted to him. How many stories?
If you lordship.
So there are 2 buildings. One has been given to the plaintiff.
And if we calculate the total area of lot L1, L2, L3, L4, that has been also be erroneously. Kindly.
What L2, L4? Where do I find that?
Erroneous calculation, my lord.
Appeal court cannot go into that nitty-gritty.
Well, my only submission, your lordship, to
can recalculate on behalf of the commission.
160 is not there. 160.
Yes, that's a good ground. 160, 140.
And not
no notice of commissioner. Notice, we are not sure. Did you take that point before the? It was an ex parte degree.
Yes, my lord. As per the preliminary degree, I have no objection, my lord.
No notice, we are not sure from that stray sentence only. That may mean either way. I mean, he says that page 18, the commissioner says, I went to the locale after due service of notice through registered post with AD. That part of the sentence ends there. Then he says, and lawyer of plaintiff and plaintiff himself identified and handed over to me the Xerox copy. You chose not to be present, maybe. The lower court records are before us.
Yes, yes.
Lower court records are the. Mr. Banerjee, please check up the lower court records to see whether the commissioner filed the service on you. That would clinch the first issue in your favor. It must be a part of that bunch containing the commissioner's report. Commissioner's report map and the other documents. There you will find the registered post.
So far the map is concerned, I have not received any copy of the map in the paper. It is missing from my.
I have not received.
Not
paper book.
25A ওগুলো পেজ দেখতে পাচ্ছি না।
আমি দিয়ে দিচ্ছি। আমারটাই দিয়ে দিচ্ছি।
তোমার কাছে নিয়ে
LR tag number 158 in L5, L4. If your lordship found that if we calculate 13 foot 4 inches into 40 foot, then we will get 536 square foot. And if your lordship kindly trouble to turn 23 of the paper book, last paragraph, my lord, the partition commissioner allotted 380 square foot in this area, in the connection with the LR tag number 140, my lord. Partition commissioner allotted 380 square foot, where if we calculate it in the L5 and L4, then we can found the total area of land is 536 square foot, my lord. This is also the erroneous calculation.
The rest has been given to you then. He has been allotted 380. Total is 500 something.
No.
Don't understand.
Plaintiff will get the LR tag number 380 square foot. That is 8 sheetak 20 square foot.
What is
And
the total area there?
If we
In
calculate
140, what is the total area?
Is the total area 536 square foot.
Out of that 380 has been given to him.
This total area have given to the allocated to the respondent number 1. He said that he has allotted 380 square foot. If you if we find from the map, then the total calculation is 536 square foot. He has allotted to the plaintiff respondent. Absolutely erroneous calculation, my lord. Highly appreciate, my lord.
$500?
536 square foot. If we calculate 13 foot 4 inches into 40 foot.
Into 40?
40 foot.
Yes. What else? What other points?
My lord, I have already submitted that the laded code below in the code below are in accepting the partition commissioner report where he has allotted the cream area to the plaintiff respondent without being heard by the defendant appellants. My lord, the laded judge in the court below should have appointed a fresh commissioner for allotment of the suit property as per law and equity, my lord.
Why fresh commissioner? Because the report was bad.
My lord.
Anything else? What else? So 2
For
points.
For that, the laded judge.
Primarily 2 points. One is no notice on you. Second is omitted DAG number 160 and calculated 140, which is not a subject matter. Third ground is the cream portion has been allotted to plaintiff. And in DAG number 140, the map shows 536, whereas he has narrated in the report that 380 is being allotted. These are your points. What else? Any other point?
My lord. There
is no point.
Are you not considering that the partition commissioner has allotted the front and valuable portion of the suit property, suit property to the plaintiff respondent by depriving the discriminating the defendant appellant, my lord.
That is a general argument. Argue on specifics.
My lord, court below ought to have examined the advocate commissioner, my lord, before accepting the report of the commissioner.
Commissioner has not been examined.
No, as per my knowledge is concerned, my lord.
No, commissioner must have been examined. Otherwise, in a partition suit, it could not go. And you are not there, so you could not have cross-examined him.
Well,
summons must have been served on you. You were appearing in the suit.
The last point, my lord. The Landed Judge Landed Court below are in law and not considering that the Partition Commissioner did not give any share of pawn to the plaintiff respondent. Rather, the said share of the pawn has been allotted to VT land instead of pawn.
Yes, no share of pawn given to plaintiff.
Yes, my lord.
Rather,
Rather
VT
the-
was given.
Rather,
VT was given. Vita.
Yes, my lord.
That is covered by your cream argument. Cream portion was given to him.
My lord, only my humble submission before lordship to set aside the order and appoint a fresh commissioner who will investigate the local and allotted the share among the co-share of the said suit plot, my lord.
Yes. What do you say, Mr. Banerjee? What is your
First of
argument
all,
on
my
that?
lord, kindly come to page number 8.
Yes.
The preliminary degree was
যত্ন করে রাখো আমার কাছে
passed, my lord, by the Landed Court. Page number 8 of the paper.
পাঠাবে আমার কাছে page 8
Page 8. This is in the year 2006 of the paper book, my lord.
Yes.
Thus, it is declared that the suit case, the fact of the plaintiff in brief that one of the Gokul Chandra was the original owner of the suit property. After his demise, the property left.
So preliminary degree was also past expertise. They were all along absent.
Yeah, all along absent.
Yes.
Thereafter, my lord, long back,
Yes.
preliminary degree was passed in 2000. They did not challenge any title, anything.
No, they did
Then,
not.
my lord, kindly come to the final degree order, my lord, 29th of February 2021. The partition report, commissioner's report was submitted. Page number 14. Is the
Yes. Yes. Finish in a nutshell, Mr. Banerjee.
yes, my lord. Just 1 minute I will take.
What is your argument to these? What are the
First of all, my lord,
differences? They have made two arguments, no notice of commission.
So far the measurement is concerned, my lord. Well, I refrain myself from making anything about the measurement because it all depends upon commissioners. But it was all along expertise. They did not take any.
No, but the commissioner gave the cream portion to you.
My lord, that is their case. But my case
Yes,
is
you
that,
refrain from saying anything that means you accept
no,
their
my lord,
case.
so far the measurement is concerned. According to them, long after the commissioner's report was filed in 2022-21, and now it is 24, my lord.
So what? If the
going to
commissioner
check.
did a wrong, it's a wrong. Still a wrong.
It's a wrong. If it is a wrong,
They
it is wrong.
give the measurements. 380 square feet was written against DAG 140, but you were allotted 536, which is evident from the map.
You come
And
to
no
the-
copy notice was served on you. DAG number 160 was omitted. 140 was included. What about that?
My lord, so far whether the notice has been served or not, my lord, it is not. I am not very sanguine, my lord. From the record, if it itself shows that he is not served with the notice by the commissioner, then it is well. Otherwise, but so far the contentions, my lord, in the commissioner's.
What about DAG number 160 omitted and 140 included?
I'm just coming. My lord, kindly see page number 20. The 3 DAGs has been mentioned. 158. 20 of the is it the report of the partition commission?
Yes, we have seen everything.
Then my
You
lord,
answer why 160 was omitted and 140 was included. LR DAG.
my lord,
Although
160
the suit property includes 160.
my lord, yes, my lord. Suit property includes 160, but
Don't repeat our sentence, answer.
But plain schedule, it omits DAG number 140. It omits.
We know that. What is the answer
Then,
to that?
then I filed an application, revisional application against the rejection of our application for amending the degree, and that was rejected by the High Court also, revisional application, with the finding that when the appeal is pending, in the meantime the appeal was kept pending, the appeal court will take care of that. So on merit, I am not going to pass any order. This was the observation of the.
So that is neither here nor there.
So that should be taken care of. So
Still, you have to answer this.
Yes.
What amendment did you seek?
So far, to include DAG number 160 in the schedule.
And what about 140? It's somebody else's property.
Yes. So far, my kindly come to next page, my lord.
So you are admitting this error.
No, kindly come to the page of 23 for once, my lord. It is not a case that it is a misdescription of the property. So far, I can appreciate, my lord, from their
Repeatedly, everywhere it is said 140 misdescription. It is not a part of this suit schedule.
not of the part of the suit schedule. I admit that. It is
Then
not. Then, my lord, kindly see.
everything goes.
My lord, kindly see. The plaintiff adduced evidence before me. What is it? It's not 23.
They've merely gone on to make a division and allot it. You have been given someone else's property.
No, my lord.
And you are very happy about that.
Kindly see the middle paragraph. The plaintiff, which is now 23. For once, my lord. In nutshell, I am just going to kill
What
them.
nutshell? Adduced evidence complete.
Yes, yes. My lord,
Complete. The nutshell is prolonging. Yes.
the plaintiff adduced evidence before me, stated that he did not took any land on LR number 140, which is in the nature of the VT, but he should be allotted the land from LR number 158 in exchange of his share in LR number 140 VT, but it should be adjacent to his allotted land in share.
Whatever is said,
it
whatever
was-
you said, commissioner allotted.
Commissioner
Whatever
allotted.
plaintiff said,
Yeah,
according to his dictates.
commissioner allotted. So there is a misdescription with regard to the LR number 158. Instead of 158, it will be 140. So for my position, this is admitted position. That particular dag number was not.
No. 160 should be included, 140 should go out. 158 is all right.
140 will be included. That is why, my lord, application was made. That is not part of the record. I do not know, my lord.
What about commissioner not being examined? Commissioner was examined.
I have to inquire. My lord, tomorrow I will. The lawyer is.
The closing arguments.
I have inquired. The lawyer who
Your
was,
lawyer's inquiry would not help us. You have to show us from
he
the
also
records.
expired. Who was conducting the trial in the court below.
Expired.
Expired.
Naturally, we are on the verge of expiring after your arguments.
No.
There is every possibility of our expiring also after the matter is over.
My lord, you may.
You will ask your advocate and who has expired, and he will
No.
say upon a seance that this happened,
No, my
and
lord,
we'll
no.
rely on that.
No, my lord.
Better to look into the records.
Yes, that is why I am sticking.
You have
to
not
the-
looked into the records. You are arguing a first appeal.
I'm
We'll
yes,
do
I have
that for
gone
you.
through the record. There are 3 dag number. One dag number is.
You have gone
missing.
through the records. Answer us whether the partition commissioner was examined. You have gone through the records.
I cannot say, my lord, whether he.
You have
was-
gone through the records. Shall I ask questions on the record to you?
No, my lord.
I have just now gone through the records.
No, my lord. I am.
I'll ask only 2 or
Leave it to
3
you.
questions. You'll be able to answer that.
My lord. But that
You have not
particular
touched the
dag number.
record.
My lord,
You
that
have not
particular.
touched the records, Mr. Banerjee. We are closing arguments. You cannot improve whatever you said.
Yes. Only my only prayer is that if it is found any misdescription in the suit property, my lord, if the order is set aside, if this order is set aside, kindly give us the liberty.
To do what?
To make necessary correction.
To?
Regarding this dag number. I will, if required, I will produce the document, my lord, before.
There is no question of you're making any correction. Whatever should description is there is there.
Only the
Preliminary degree passed.
Final degree
Final
passed.
degree passed. We cannot reopen that. Neither can you.
Yes.
My lord, one thing, my lord,
Whatever is there on that, the commissioner has to
But that is, my lord, in
make allocation.
2021, my lord. Now they have not challenged anywhere. Now, my lord, at this stage of final degree, my lord.
No, that's why you are saying we cannot reopen that. You are challenging. You are saying that the description should be changed. It has not been challenged by anybody. It has attained finality.
My lord.
Final degree suit property remains. How can we permit you to amend now?
If the, my lord, commissioners will
My lord, after
again.
final degree, he has filed an application for amendment, and that application has been turned down by the landed court below.
Where are those records? Why are not those part
Not
of this?
annexed. This is not annexed in the. I know. I have given the records to him also, my lord. The last occasion.
Your application, where is that?
My revisional application.
Revision application, anything.
Or they were present in the particular case. That time I was not holding the brief. But still, my
You are now holding the brief.
Yes, yes. Just give me 1 minute time.
We were also not holding the brief. It's not our responsibility.
No, my lord.
It's your responsibility to prove your case. We are asking you questions only, then you are answering.
Yes.
What happened to your amendment application? Rejected by the trial
Rejected
court?
by the trial.
That amendment was filed when? After the final degree?
After the final degree.
After final degree, you made an amendment application. Under which section?
My lord, his
I hope
application was.
not under Order 6 Rule 17.
152, 153.
Let me see now.
Let him say. Yes. Which provision?
Well, what provisions they have adopted? Let me.
Who has adopted?
The lower court record. I'm trying to find out the lower court. Kindly give me 1 minute time.
After order record, hard in part. This matter will appear at the top tomorrow. We'll give you 5 minutes, Mr. Banerjee. You'll have to complete your arguments within that 5 minutes. এখন আজকে পাঠিও না, কালকে একসঙ্গে পাঠাবে, রেকর্ডগুলো রেখে দিয়েছো। আমার নোটটা স্কুলে থাকবে, খুলে না যে স্টেপল করবে। থ্যাংক ইউ।
Gratefully, Lordship.